Judgment is recalled by the very honorable judge.
No, in his matter only, I have brought it to his knowledge saying that the judgment in 2025 that these judgments are wrong.
Correct.
It's not, probably not correct.
One additional SPP is directed to accept notice for the respondent. Yes.
I make one submission, my lord. Only based on the, my lord, statements of the localites, my lord. I have
We'll
been
see,
implicated.
let him see, yes.
My lord, their statements also not recorded in the.
No, we'll see, sir, no problem, yes.
Date may be fixed.
We'll see, yes, 2nd July, yes, next.
54.
Husband, no stay, all else interim order, 85. Bata diyo bhai? Yes.
35.
Notice.
Accused number 1 to 6.
One HCGP, 2 emergent notice.
There is no, in the FIR, my lordship, and complaint, there is no mention in the accused number 5 and 6. my lordship.
Huh?
FIR number 4 and 5, yesterday I did some complaint.
Yes.
Civil dispute in is created a story. my
ಯಾಕೆ
lordship.
ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆಯಾ ಮೇಡಮ್? ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆಯಾ? Yes. Next.
My lordship, there-
Notice,
and
sir.
the basis of the civil suit, my lordship, is created a story and filed a complaint. There
No
is
story, sir.
There is no
We'll
specific,
hear the story of the other side also, yes.
no specific allegation, my lordship.
Injury ilva madam? Yes, next.
36.
Both two injured.
Anything else?
My lordship,
One HCGP, 2 emergent notice, 35 ಆಯ್ತು, 36, 37 same madam.
Yes.
Matter, yes.
38.
In the meantime, A1 and 8.
39.
39, theft.
ಇಲ್ಲ
309 ತಾನೆ?
ಇಲ್ಲ ಕಸ್ಟಮ್ಸ್ ಮ್ಯಾಟರ್ 39 ಗಣೇಶ್ ಕುಮಾರ್
Sir, ಯಾರು ವೆಂಕಟಗಿರಿ ಅಮರೇಶ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇರ್ಬೇಕು ಸರ್.
ಸಾರಿ ಮಿಲನ್ ವೆರಿ ಸಾರಿ
ನಾನು ಓದಿದ್ದೆ ತಪ್ಪಾಗೋಯ್ತು ನಾನು. ಎಸ್ ಎಸ್.
39.
No case, no representation by the petition list after 2 weeks. Pendency of this petition will not come in the way of further proceedings before the concern. Next.
40.
ಪಿಟಿಷನ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1
The petitioners are before the court calling in question so and so. Page 12 ಅಲ್ಲಿ mark ಮಾಡಿದ್ದೀನಿ ಮೇಡಮ್. Page 12 ಅಲ್ಲ mark ಮಾಡಿದಲ್ಲ, ಒಂದು ನಿಮಿಷ. The incident that happens on 20th September 2023 of an alleged hurling of abuse against the complainant, a crime comes to be registered after 6 months without any explanation for delay. If hurling of abuses has taken place on 20th September 2023, nothing prevented the complainant to register the complaint immediately. This delay would undoubtedly kill the cause of the complainant, albeit prima facie. Therefore, there shall be an interim order of stay of further investigation. Charge sheet ಆಗಿದೆಯಾ? Further charge sheet ಆಗಿದೆಯಾ? Further investigation query the petition to the next date of here. Next.
41.
The petitioner is case, my lord. 66 and 67 of IT Act, my lord.
In the meantime, yes. Next.
42.
In the meantime,
43.
Petitioner.
42 ಯಾವುದು? ನೀವಿದ್ದೀರಾ?
42, sorry.
42, I represent the respondent number 2 in this matter.
ಹ್ಮ್.
Case of impersonation and fabrication of the sale deed.
ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿಲ್ವಾ?
Civil suit ಹಾಕಿದ್ದೀನಿ, but what has happened is this, as the petitioner before your lordship is actively involved in the particular.
Today,
fabrication
42
of
could be.
enforcement. What had happened is, he has deliberately given a false address. And admittedly, my client is in USA. At the time when she is in USA, the sale deed got executed by impersonating by some other person. And even.
The accused number 3.
Yes, accused number 3 is the person who got the sale deed executed in his favor.
He is the beneficiary of the sale deed.
Yes.
Purchaser of the property,
ನಾವು ಸ್ವಾಮಿ ಅಷ್ಟೇ ಸರ್.
But
ಅದರಲ್ಲಿ
no, no, he is the one who has involved himself in. the case.
purchaser of the property.
Your Lordship may kindly do one thing, give me a week's time. I will file the documents to indicate that this man is actively
Right.
hand in glove in this.
File it, yes.
Yes.
ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ನಾವು ಪರ್ಚೇಸರ್ ಅಷ್ಟೇ.
The petitioner, the learned counsel for the respondent seeks complainant seeks so and so undertakes to enter appearance for the second respondent.
What has happened is, the name of the respondent but is wrongly shown.
ಹಾ ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಿ.
Wakalat hakini, but it is not been put up.
All right, so and so.
ಇದ್ರಲ್ಲಿ ನಂದು ಏನಂದ್ರೆ ಸ್ವಾಮಿ ಜಮೀನು ತೋರ್ಸಿದ್ರು. ನಾನು ಓದೋ
ಅಲ್ಲ ಅದಕ್ಕೆ according to me, if what I read, you are a bona fide purchaser. But if something else is there, we will see. Next week ಮಾಡೋಣ.
Next week, man.
List the matter on 18th in the fresh matters list. Objections, if any, by the respondent, by then registry to print the name of so and so is appearing for the respondent. Yes.
44,
43, 43.
Private complaint, Mallar.
Correct, sir. Theft, 379.
There is no ingredients in the.
No, no, sir. Yes. Who asked you to come on record? Notice ಮಾಡಿದ್ದೀನಾ? ಮತ್ತೆ ಯಾಕೆ ಬಂದ್ರಿ? With your knowledge ಪ್ರಕಾರ ಏನ್ ಕೇವೇಟ್ ಇದು? ಎಲ್ಲರೂ ಬಂದ್ರೆ? 4 ಕೇವೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಹಾ.
There is no ingredients.
No, sir.
I have sold the two properties.
No problem.
One property.
No problem. One HCGP, 2 emergent
Take
notice.
page,
Returnable by so and so.
32, Mallar.
2nd July, yes. Next.
44,
This has to be issued to the complaint accused.
Correct, go to notice, yes.
55,
This conflict between the maintenance of the apartment, my lord.
In the meantime, yes, next.
Please, my lord.
State, sir.
46,
Gift deed forgery.
None for A3 under the body warrant I have been produced before the court.
Parvala, yes. 1 HCGP, 2 emergent notice. Next.
47,
MLA matter, cognizance order, not passed.
So we have to, ಇನ್ನೊಂದು matter ಇದೆ remand ಮಾಡ್ಬೇಕು. It's not contrary to 175. ನೆನ್ನೆ ಇತ್ತೇನೋ ಅದು.
And tomorrow, your lordship.
I will take this also along with that. ನೆನ್ನೆ ಒಂದು ಅರವಿಂದ್
Then
ಕಾಮತ್.
in addition, I have raised other ground also.
ಆಯ್ತು, will ವಾಪಸ್ ಕಳ್ಸೋಣ.
There is no material at all.
Tomorrow we'll see inter alia if that is there.
And it is connected with WP 3887.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ? ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ? ಯಾವ್ದ್ರಲ್ಲಿ?
388, no stay, no stay.
ಹಾ, ನೋ ಸ್ಟೇ. ಟ್ಯಾಗ್ ವಿತ್ ಬರ್ಕೊಡಿ.
388,
ಹಾ, so and so ಬರ್ಕೊಡಿ. ಟ್ಯಾಗ್ along with that. ನಾಳೆಗೆ ಹಾಕೋಣ.
please.
Yes. Next, tomorrow.
48,
Petitioners, Andarbar,
KPL
government.
79.
ಅಲ್ಲ ಕೋವಿಡ್ ಅಲ್ಲಿ ಅದ್ ಮಾಡಿದೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್? ಅಂದರ್ ಬಾರೇ ಮಾಡೋದು ಕೋವಿಡ್ ಅಲ್ಲಿ. ಎಸ್, ಡಿಸ್ಪೋಸ್
permission is
ಅಂದರ್ ಬಾರ್. ನೆಕ್ಸ್ಟ್.
49,
Petition, alleged offense 420.
ನೀವು ಜಿ ಪವನ್ ಕುಮಾರ್ ಮಾಡಿ. ಪವನ್ ಕುಮಾರ್ ಜಿ ಅಂತ ಕರಿಬೇಕಾ ಮತ್ತೆ?
As again accused number 2.
In the meantime, yes.
50,
The petitioners in this case.
No stay for A1, A2 interim order 85. Yes.
51,
Yeah, what is this problem? Huh. Next.
Petitioner,
51 na.
please,
51,
purely.
Grantees,
Please, my
you are
lord.
grantees of the land, LRs of the grantees.
Please, my lord.
The petitioners are LRs of the grantees. The granted land is the subject matter of the dispute. The petitioners, when go to check the land of belonging to them, as they are the legal representatives of the grantees, a crime is registered by someone in possession of the said land, which has become the present offences. In the light of the said circumstance, there shall be an interim order of stay of further proceedings by the petitioner to the next date of investigation.
Just
Further
charge sheet has been
invest, charge sheet
filed,
ಆಗಿದೆಯಾ? Further proceedings, next.
madam. Civil suits are pending, madam.
ಆಯ್ತು, ಅಲ್ಲೂ ಬರ್ಕೊಳ್ಳಿ. The learned counsel of the petitioner submits that civil suits between the parties are also pending before the concerned court on all these circumstances.
52.
The petitioner in this case, my lord. My lord, it's a dispute is in civil nature, my
Oh,
lord.
yes, sir.
And civil suit is also pending, my lord.
Ah, sir.
Fact is, my lord, the grandfather of the complainant
Hmm.
and the accused number one
Hmm.
acquired a site number 11 which is situated in Lagere, Bangalore, my lord.
Hmm.
So the grandfather died in the year 1991, my lord.
Hmm. Yes, no problem. One HCGP, two emergent notice. No stay. Not a case for stay at all. Yes,
53.
next.
52.
The petitioners are accused numbers 3, 8,
In the meantime,
trying
next.
for the offense under section
54.
406.
Stayed, madam.
54.
304A, driver, driver.
Negligence.
ಸಿ ಕ್ಯಾಮ್ರಾದಲ್ಲಿ
No, ಎಲ್ಲ evidence. Driver 304A ಅಲ್ದೆ ಇನ್ ಯಾರಿಗ್ ಬರುತ್ತೆ?
A2 was a contact. of-
Oh, no.
When is it happening?
File discharge.
Death also.
Huh?
Ah,
Driver.
civil
ಡ್ರೈವರ್ಗೆ ರ್ಯಾಶ್ ಅಂಡ್ ನೆಗ್ಲಿಜೆಂಟ್ ಆಕ್ಟ್ ಬರದೆ ಇನ್ ಯಾರಿಗ್ ಬರುತ್ತೆ?
CCTV footage ಬರುತ್ತೆ.
ಅದಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ CCTV footage, not here. Discharge, yes.
You brought it to file.
Ah, yes, yes.
55.
Civil suit is pending, my lords.
Yeah.
In pursuance of the interim order, my lords. The Gram Panchayat, my lords, we interface with the affairs of the question, my lords. We filed application, my lords, for
In the meantime, yes.
56.
Next.
56.
No representation via the petitioner. List after 4 weeks. Registry is directed not to list the matter prior to the expiry. Next. MMDR
57.
notice, same. Additional SPP is directed to accept notice for the respondent. Chandrasekhar. Chandrasekhar. A1 no stay, 234 stay. Husband.
59.
Vikram Raj. Cause list ilva? Cause list iralva?
Lords, the petitioners are, the first petitioner is the
Correct.
friend of the deceased, the petitioner.
306.
306. First one. Lords,
Video
even
call
the
ಮಾಡಿದ್ದು
allegations
WhatsApp message.
state that
My lordship,
what-
against A1, my.
WhatsApp video call was going.
28/3/2026 crime is registered. Let me see the investigation papers.
Yes,
One HCGP, two emergent notice,
Date may be fixed.
returnable by the 7th of July. By the next date, the learned HCGP shall place on record the entire papers of investigation conducted up to 6th of July, 2026. Yes.
Lords, as far as petition number 2 is concerned, my lords, she's nowhere relating to the crime. She's the mother of the first petitioner.
Let's see, bail ಸಿಕ್ಕಿದೆಯಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ.
No coercive steps, member.
bail ತಗೊಂಡ್ಮೇಲೆ coercive ಏನ್ ಬಂತು? Yes. Next.
60.
Lords, permit me to appear, Lords. Lords, I am instructed to withdraw the petition, Lords. I will file necessary memo before the quantum, Lords.
All right. Memo.
Lords. I will file in the quantum, Lords. I'm sorry, Lords.
Learned Counsel Naveed Ahmad seeks leave of this court to withdraw the petition. Withdrawn by placing a memo on record, withdrawn in terms of the memo. Yes, next.
Obliged, Lords.
61.
My lord, appear for the petition in this case.
138,
Please,
no ground.
My lord, defective legal notice, my lord.
ಅದು ನೋಡೋಣ, yes.
Sought by,
La-
my lord,
Learned counsel to serve on the counsel representing the respondent in the trial proceedings, counsel for the respondent trial proceedings, Monday fresh matters. Next. ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ.
62.
ಎಷ್ಟು ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ ನಿಮ್ಮ ಮೇಲೆ?
But I have filed,
ಅಲ್ಲ, so many cases against each other.
I have filed about 2 more attempt against the de facto complainant here in my lord. And one civil
In the
dispute also
meantime,
pending and
yes.
obtained stay, my lord.
In the meantime, madam, next. States, stay quoted.
63.
Ravi Shankar.
QCR is
Accompany the
Meantime, yes, one HCGP 2 emergent notice returnable by second, will send it back later. Vivek,
civil.
stay ಮಾಡಿದ್ದೀನಿ sir,
64.
20%, 20%. ಏನಿದು 64
64.
Rajkar.
64 63 ಯಾರು? Akram Pasha. Akram Pasha stay ಆಯ್ತು. 64 in the meantime. Yes, next. Please. Madam, ಯಾಕೆ ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತದೆ ಇವತ್ತು? Other state ಇಲ್ಲ. 63 state ಇಲ್ಲ, only respond, emergent notice to the respondent. 64 in the meantime, one HCGP 2 emergent. 65.
65.
Yes. 60,
65.
20%. Yes. List on 22nd in fresh matters. No representation we have the petition. Wound certificate ಇದೆಯಾ?
Page number 46.
ಏನು?
Simple.
66.
No injuries at all.
Meantime, next.
Right.
67, who is Brinda? No representation, list after 2 weeks.
Yes.
Huh? Yes.
68.
Prasann Kumar, 7A.
Yes,
Petitioner to serve on council, B. Latif, appearing for the Lokayukta with requisite set of papers. List on 2nd July. Next.
69.
Petitioner is the accused number 2. My lord,
Allegation is wiretapping.
yes, my lord, against the accused number 1, my lord.
No, sir. Anything else, sir?
My lordship, only on the confession statement where accused number 1 is.
Unauthorized recording of conversation.
He is the managing director of.
Complaint.
Unauthorized recording of conversation contrary to law, contrary to Telegraph Act. You have no right to wiretap.
My lordship,
They
the
converted the call.
allegation, my lordship, international cast, local cast.
Yeah, parala. This is huge. Anything else, sir?
My lordship, the complaint was registered against.
No, no, sir.
Enterprises, my lordship. The proprietor is the accused number 1.
Correct ಆಗಿದೆ.
Nowhere connect to accused
No,
number 2,
no,
my
no,
lordship.
nothing doing. You are equally, you have no right to wiretap anybody's conversation, sir.
My lordship, accused number 2, my lordship, no.
Gross violation of right to privacy.
Only on the basis of the co-accused statement. my
No,
lordship.
no, nothing doing. Not only right to privacy, many things. One would write, I'll write.
Discharge.
You have no business of wiretapping.
Discharge.
Discharge, yes.
70.
the pendency of the matrimonial dispute in way back in the year 2024.
No problem, sir.
79, 2025, he is making allegation to assault.
No.
Meanwhile, I will
You are
not-
the husband.
I'm the husband, yes.
One HCGP 2 emergent note. No stay. Yes.
71.
Yes.
Issues in this case.
A1, no
A1
stay.
husband.
A2, yes. 85.
72.
Counter case
Notice. One HCGP 2 emergent notice.
connected with my lordship.
Adal stay ಇದೆಯಾ?
I'll stay.
Tag with so and so.
501 of 2023.
ಬರ್ಕೊಡಿ. Yes.
73.
Jairaj.
Praise time.
Praise time, no grants time.
My senior, ಹುಷಾರಿಲ್ಲ.
Your senior ಹುಷಾರಿಲ್ಲ? ಫೈಲ್ ಇದೆಯಾ? ಫೈಲ್ ಇದೆಯಾ?
ಹಾ ಸರ್.
ತೆಗೀರಿ. ಓದಿ. What's the offense? ಸ್ಟಾರ್ಟ್. ಟೈಮ್ ಕೊಡಲ್ಲ, ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. ಓದಿ, ಫೈಲ್ ನೋಡಿಲ್ವಾ? ನೋಡಿ ಈಗ ಓದಿ. ತೆಗೀರಿ ಫೈಲ್ನ. Where's the file? You not got the file? Which is that file? ಬೇರೆ ಕೋರ್ಟ್ದ? ಎಲ್ಲಿದೆ ಫೈಲ್? ಓದ್ಕೊಂಬನ್ನಿ, 2:30ಗೆ ತಗೊಂತೀನಿ. ನೀವೇ ಓದ್ಕೊಂಬಂದು ಮಾಡ್ಬೇಕು, ಆಯ್ತಾ? ಎಸ್.
74.
13:1. ಯಾರಿದ್ದಾರೆ?
Lords, we have entered appearance on Monday.
You.
Yes, but AP Ranganatha.
So and so registered to print the name of so and so is appearing for the petitioner as the counsel Satish DJ is
Lords,
in place of Satish DJ.
I'm filing a memo for withdrawal, my lords.
ಅದನ್ನ ಅವರೇ ಮಾಡ್ತಾರೆ. Recording in terms of the memo.
Like,
Yes.
75.
ಏನ್ ಮೇಡಮ್ 4 ಒಬ್ಬರದೇ ಇದೆ. ಸರಿ ಇದೆಯಾ ಈಗ? ಈ ಕನ್ಸೋಲ್ ಸರಿ ಇದೆ. ಸ್ಟೇಟ್ ಇಲ್ವಾ? ಇದೆಯಲ್ಲ?
State 354A.
ಹಾ? 354A ಅದೇ 4 ಇದೆ ಇಲ್ಲಿ. ಸೇಮ್ ಪೆಟಿಷನರ್, ಸೇಮ್ ಕ್ರೈಮ್. ಎಲ್ಲ ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್. ಕಂಪ್ಲೇಂಟ್ ಬೇರೆ, ಬಟ್ ಕಂಟೆಂಟ್ಸ್ ಎಲ್ಲ ಸೇಮ್. 354A. No representation behalf the petitioners. List the matter on 29th. The fresh matters list. Yes, next. Expunging that.
This number 2 fresh matter, still number 1.
ಅದೇ ಅಲ್ವಾ ಮೇಡಮ್ ಕರೆದಿದ್ದೀನಿ 4. This number 2, 354A.
This is asking for clubbing of all this thing. Application 220 has been rejected.
ಅದೇ ಕ್ಲಬ್ಬಿಂಗ್. ರಮೇಶ CN.
There are 4 cases where the witnesses are cross witnesses in all.
220 must have been allowed. Well, direct the trial to be conducted together.
Yes, joint trial.
Yeah, yeah.
The investigation officers are also same. Witnesses are also
No,
cross
correct.
witnesses.
It's a 220 case, no problem.
A waste of judicial time.
Correct. The petitioner will pass a common order in all these
Yes.
4 matters. Now we're 220.
The recent Supreme Court judgment in that clubbed all this thing.
Yes, yes. Waste of time in there. Yeah. The petitioner in all these cases, 4 is common. The complainants differ while the accused, while the witnesses and the investigating officer is the same in all the cases. In that light, a application comes to be filed before the concerned court seeking clubbing of all these cases under section 2, invoking the power of the learned magistrate in section 220 of the CRPC and trying them together. The concerned court rejects the application by the following order, page 9, 10, 11. The order on the face of it is erroneous as the issue is similar, the investigating officer is the same, witnesses are common, and the complaint only on the reason that the complainants are different, the concerned court has declined to answer the application under section 220. Therefore, the application deserved to succeed, it does before this court. In that light, the petition stands allowed, the order so and so stands quashed. The concerned court is directed to club all the cases, and take it up together and take it to its logical conclusion. Disposed. ಅದಕ್ಕೆ ಜಯ
Charges are already framed and PW1 evidence.
ಇದರಲ್ಲಿ two similar complaints.
ಅಲ್ಲ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋ ಅಂತ
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಬಟ್ ಎರಡು ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್,
ಏನಾರು
ಎರಡು ಚಾರ್ಜ್ ಶೀಟ್, ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್, ಎರಡು ಚಾರ್ಜ್ ಶೀಟ್.
ಯಾವ್ದು ಬೇಕು ನಿಮಗೆ?
ಒಂದ್ರಲ್ಲಿ ಪ್ರಯತ್ನ ಪಟ್ಟ ಅಂತಾರೆ.
ಇಲ್ಲ ಏನಾರು ಇರಲಿ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ, ಎಲ್ಲಾರ್ದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ,
ಎಕ್ಸಾಕ್ಟ್ಲಿ ಸೇಮ್.
ಕರೆಕ್ಟ್. ಹೌ ಕ್ಯಾನ್ ಐ ಟೇಕ್ ಇಟ್?
ನಾನು ಇಷ್ಟೇ ಕೇಳ್ತಾ ಇರೋದು. ಟೂ ಸಿಮಿಲರ್ ಕಂಪ್ಲೇಂಟ್ಸ್, ಸೇಮ್, virtually the same ingredients in the complaint. They have made it into two FIRs and two charge sheets. Because it is Krishnamata Udupi have given the complaint, I will have to face this.
Charge frame agide.
Second one stay ಮಾಡಿದ್ದಾರೆ, which is the second one. Because how can I face
ಸರ್ ನೀವೇ ಹೇಳಿ
on similarity?
ನೀವು ಬಂದ್ರಿ ಅಂತ ನಾನು ಅದನ್ನ ಮಾಡ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಅಲ್ಲ ಅದೇನಾರು ಇರ್ಲಿ, ವಾಟ್ ಡು ಐ ಡು ವಿತ್ ಆಲ್ ಆಫ್ ದಿಸ್?
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಎರಡು ಬೇಡ ಅಂತಂದ್ರೆ, your lordship feels both not necessary.
ಎರಡು ಬೇಡ, ಎರಡು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಎರಡು ಬೇಡ ಅಂತಂದ್ರೆ
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ
ಸಿಮಿಲಾರಿಟಿ ಮೇಲೆ ಒಂದ್ ಸ್ಟೇ ಮಾಡಿ, then your lordship.
ವಾಟ್ ಸಿಮಿಲಾರಿಟಿ?
ವೆರಿ ಸೇಮ್. ಒಂದರಲ್ಲಿ ದಿವಾನ್ರಿಗೆ
ಜಗದೀಶ್ ನೋಡಿ ಅದು.
ಆಮೇಲೆ
ವಾಟ್ಸ್ ದ ಸಿಮಿಲಾರಿಟಿ?
MLC ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನೂ ಇಲ್ಲ.
ಅದೆಲ್ಲ ಬಿಡಿ, ದಟ್ ಇಸ್ ಆನ್ ಮೆರಿಟ್ಸ್. ಅಲ್ಲಿ ಮಾಡಿ. ಐ ಆಮ್ ಓನ್ಲಿ ಆಸ್ಕಿಂಗ್ ಹಿಮ್ ಟು ಲುಕ್ ಇಂಟು ಇಟ್ ಬಿಕಾಸ್ ಯು ಸೆಡ್ ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್, ಅಲ್ಲ ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್, ಟೂ ಕಂಪ್ಲೇಂಟ್ಸ್. ಅಷ್ಟಿದ್ರೆ ಮಾತ್ರ, ಇಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್ ರೈಟ್ ಅವೇ. ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್.
Same incident. This is a fact.
I'll just verify. One is on 29.
Virtually same. Same 29, 12, 24, same time. 9:15.
ಯಾವ್ದು ಬೇಕು?
The second one.
Your lordship may club and
0,
state
2,
one
3, 4.
witnesses in case if the other witnesses.
ಅಲ್ಲ ಒಂದೇ ಇನ್ಸಿಡೆಂಟ್ ಮೇಲೆ ಎರಡು ಕ್ರೈಮ್ ಹೆಂಗ್?
Witnesses, I'm only saying that the witnesses in both cases should be clubbed and.
That is.
It will become one trial. I'm not
but
saying
on
two trial.
similarity.
I'm not saying two trial. If the witnesses are different in both the cases.
That is at a later stage.
No. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಅದೇ ಇರೋದು. ಐ ಆಮ್ ಓನ್ಲಿ ಆನ್, ಯು ಶುಡ್ ಹ್ಯಾವ್ ಕಮ್ ಅಟ್ ದಿ ಕ್ರೈಮ್ ಸ್ಟೇಜ್. ಒಂದೇ ಕಂಪ್ಲೇಂಟ್, ಒಂದೇ ಇನ್ಸಿಡೆಂಟ್ ಮೇಲೆ ಎರಡು ಕಂಪ್ಲೇಂಟ್ ಇದೆ, ನಾಟ್ ಆಫ್ಟರ್ ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜಸ್.
Let's say 2, 3, 4 stay ಆಗಿಲ್ಲ. 0, 2, 3, 4 ಅದರ ರನ್ ಆಗಿ.
ಯಾವ್ದು 0, 2, 3, 4?
FIR crime number 17215 criminal petition. CC number 731 of 25.
Witnesses are different.
Different.
Therefore, let the witnesses be witnesses in the whatever case your lordship.
I'll ask the court to club the two and conclude it. Witnesses ಬೇರೆ ಇದ್ರ.
It is virtually the same.
ಏನಿಲ್ಲ. ಅರೆ ಹೆಂಗೆ ಎರಡಿರಲ್ವಲ್ಲ, ಒಂದೇ. ವಿಟ್ನೆಸಸ್ ಬೇರೆ ಇದೆ ಅಂತ ಮುಗೀತು.
I'll produce a judgment next date.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ತಗೋಬಾ, ಯು ಕ್ಯಾನ್ ಎಂಟರ್ಟೈನ್ ಅಂತ. Not in all cases.
Because Krishna Bhatt has given the complaint, police out of over enthusiasm they have abused the process.
ಗೊತ್ತಿಲ್ಲ, but you should have come then, sir.
ಅವಾಗೆ ಬಂದ.
ಎಲ್ಲಿದೆ ಅವಾಗಲೇ? ಎಲ್ಲಿ ಬಂದಿದ್ದೀರಾ?
ಅಯ್ಯಪ್ಪ ದರ್ಶನ
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? ಅವಾಗ ಬಂದಿದ್ದು ಎಲ್ಲಿದೆ? ವಿಚ್ ಪಿಟಿಷನ್?
ಅಯ್ಯಪ್ಪ
ಅಯ್ಯೋ, ವಿಚ್ ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ
ಹಾಕಿದ್ವಿ, ಅದ್ರ ಇಷ್ಟ ಆಗ್ಲಿಲ್ಲ. ಅದೇ
ಯಾವತ್ತು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು?
9/10/25.
ಯಾವತ್ತು ಹಾಕಿರೋದು ನೀವು?
16/12/25.
ಬರ್ದು
ಆಯ್ತು ಸರಿ, ವಿಟ್ನೆಸಸ್ ಬೇರೆ ಇದ್ದಾರೆ. ಒಂದ್ ನಿಮಿಷ,
ಅಲ್ಲಿ ಹೆಂಗಾಗುತ್ತೆ ಅಂತ.
ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್ ಸರ್, ವಿಟ್ನೆಸ್ ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಕೋರ್ಟ್ ಟು ಕ್ಲಬ್ ದ ಟು ಬಿಕಾಸ್ ವಿಟ್ನೆಸಸ್ ಆರ್ ಡಿಫರೆಂಟ್. ಟ್ರೈ ಅಂಡ್ ಕನ್ಕ್ಲೂಡ್ ಇಟ್ ಫಾಸ್ಟ್.
ಅಲ್ಲ, ವಿಟ್ನೆಸ್ kindly see, same issue. Police are over enthusiastic to because it comes from the mud, the complaint.
No problem. When witnesses are different, complaints definitely can be
They
more
will-
than one.
They will create the witnesses in
No,
so
sir.
that.
Can I
it is
examine
done.
that? Can I examine that
Alla,
here, sir?
Materiality of the complaint, the
no.
similarity of the complaint, you must examine matter, sir. There are judgments
sir.
which say
No,
that.
no, sir.
Where complaint same, it is the same.
Definitely.
It is liable to be stated.
Definitely, no problem.
ಅದನ್ನ produce
Then,
ಮಾಡ್ತೀನಿ,
then not, ಅದ್ಯಾಕ್ ನಾನೇ ಕೊಡ್ತೀನಿ, ನಂದೇ judgment.
ಮತ್ತೆ
There cannot be multiple complaints on same incident.
Same issue.
But here witnesses are different.
ಅಲ್ಲ witness different ಇದ್ರು
Complainant
ultimately
ಯಾರು?
they are narrating the same thing.
Complaints are also different. Only issue is that those people who are different will be examined in this case, that's all.
If complainant is different, witnesses are different, the same incident, multiple affairs can spring.
ಒಂದರಲ್ಲಿ the divan says, otherರಲ್ಲಿ the security guard says, but they are commenting on the same set of events. ಇಷ್ಟಕ್ಕೆ ನಾನು ಕೇಳ್ತಾರೆ.
Assault ಒಬ್ಬೊಬ್ಬರಿಗೆ separate ಆಗಿದ್ರೆ they are entitled to do it.
ಅದೇ ಇನ್ಸಿಡೆಂಟ್ they are commenting on that.
I'll direct the trial to be conducted together. Witnesses will be examined.
Next date ನಾನು
Evidence is also.
next date judgment ತೋರಿಸ್ತೀನಿ. I'll show the
ಯಾವ
similarity.
judgment?
On that point I'll
On
show
which
you.
point?
On the similarity.
Which
That it is
similar?
liable to be
Ayyo, I
stated.
have written 10, sir.
ಅದನ್ನೇ ನಾನು
Not
ಹೇಳ್ತಾ
at this stage, sir.
even at the crime stage.
Not, ಈ crime stage
ಅಲ್ಲ,
ಬನ್ನಿ.
charge sheet stage.
No,
ನಾನು
charge
ತೋರಿಸ್ತೀನಿ.
sheet stage also, no problem.
But the
ಬನ್ನಿ.
other day we have got one
Not
state.
when the evidence has commenced and trial is on.
But recently we've got one matter stayed in public representative court on that issue. ತರ್ತೀನಿ next date ಗೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದು ಇಲ್ಲ, sir.
We'll proceed your lordship.
No, I will. Because what happens to all the other advocates whom I am saying charge
I'm
frame
not
ಆಗಿದೆ
saying,
ತೊಗೊಳಕ್
but
ಆಗಲ್ಲ
ಎರಡು
ಅಂತ.
charge sheet ನಾನು ಕೇಳ್ತಾ
No,
ಇದ್ದೀನಿ.
charge sheet.
ನಾನು ಎರಡು charge sheet ಸ್ಟೇ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾ ಇಲ್ಲ.
ಸರ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ ತಾನೇ ಎರಡರಲ್ಲೂ.
ಆಯ್ತು.
ಮತ್ತೇನು?
ಸಿಮಿಲಾರಿಟಿ ಮೇಲೆ
No, no.
ತೋರಿಸ್ತೀನಿ. ನೆಕ್ಸ್ಟ್
ಅಯ್ಯೋ ತೋರಿಸ ನನಗೂ ಗೊತ್ತು.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಾಕು.
ನೋ ಹಾಕೊಂತೀನಿ, ಅದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಬಟ್
Lord, we'll try and pursue.
no, I would be being partisan to you then.
ಇಲ್ಲ ನಾನು ಪಾರ್ಟಿಸಾನ್ಶಿಪ್ ಬೇಡ, ಏನು ಬೇಡ.
ಅಲ್ಲ, because charge frame ಆದ್ಮೇಲೆ I don't entertain anybody else.
Next date I'll show, Lord, it is how it is similar. Your lordship will see the abuse on the face of it. Merely because, Lord, we have nothing against Krishna Mart. They have given a complaint.
No, I have nothing against anybody.
Yes.
It's only what I'm only on consistency that I have to follow.
That complaint on Krishna Mart cannot be converted into two.
That's all. I'm not on the merit of the matter at all, sir.
Cannot two.
Not on the merit of the matter at all.
Two FIRs cannot spring out of the same issue.
Sir, that is too rudimentary for me even to get a judgment and see it. On one day incident ಮೇಲೆ too, ನಾನು 21 ಲೇ ಬರ್ದೇನೆ ಬೈರೇಗೌಡ judgment ಅಲ್ಲಿ. That is too rudimentary, sir.
ಬಿಟ್ರೆ
ಇದು ಟೈಪ್ಡ್ ಕಾಪಿ. ನಾನು WG ಜಗದೀಶ್ ಸುಮಾರು 39 ಲಿಂಗಾಯತ ಜನಾಂಗದ ಗೃಹಿಣಿ 3ನೇ ಕ್ರಾಸ್ ದರ್ಜೆ ಕಾಲನಿ ಚಿತ್ರದುರ್ಗ ವಾಸಿಯಾಗಿದ್ದು, ನಾನು ನನ್ನ ಗಂಡ ಮತ್ತು ಮಕ್ಕಳ ಜೊತೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದು, ನನ್ನ ಗಂಡನಾದ ಜಗದೀಶ್ ಬಿನ್ ಬಸವರಾಜಪ್ಪ ಅವರು 20 ವರ್ಷಗಳ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದು, ಸುಮಾರು 2 ವರ್ಷಗಳಿಂದ ಅಮ್ಮ ಕೃಷ್ಣ ಮಾಲೀಕರಾದ ಆನಂದಪ್ಪನವರು ಮತ್ತು ಅವರ ಮಗನಾದ
We'll get the complainant. Yes.
ನಮ್ದು ಪ್ರೆಷರ್ ನಾವು ರಿಲೀಸ್ ಕೊಟ್ಟಿದ್ದು ಒಂದು ಬಿಟ್ರೆ ಮತ್ತೇನು ಅಲಿಗೇಷನ್ ಇಲ್ಲ.
So accused number 1, sir.
Accused number 1 provided my lord, there is no allegation. ಅವ್ರ ಡೆತ್ ನೋಟ್ ಅಲ್ಲೂ ಕೂಡ ಏನು ನಮ್ಮ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಏನಿಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ ಇನ್ನು.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ.
ಟೋಟಲ್ ಅಲಿಗೇಷನ್ ಇದೆ.
ಅದು ಗೊತ್ತು, ಅದಕ್ಕೇನೆ. ಎಸ್. 1 HCGP2 ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ಇಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಬರ್ತೀರಾ. ರೆಡಿ ಇದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಟು ಬಿ ಫೈಲ್ಡ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ.
It is here.
Yes.
Yes. It may have a better case later.
Yes.
Generally 306, it's better later.
Please.
The petitioner charge sheet coming after charge sheet. ಗೊತ್ತಾಯ್ತಾ? Charge sheet format ಅಲ್ಲ. The Learned Counsel is appearing for the petitioner after arguing the matter at length would seek leave of this court to withdraw the petition and file and reproach this court if the In the event the charge sheet is filed and the final report is filed, the final report would go against the petitioner. Reserving such liberty, keeping all contentions open, the petition stands disposed. Ready, the ಹಾಕ್ತಾರೆ immediate ಆಗಿ ಹಾಕಿ.
Non-compliance of Priyanka Srivastava.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಈಗ?
This is the case, my lord. We have filed an affidavit and lordship may recall, my lord, the investigation was not taken forward because bank was not giving.
Oh, Axis Bank.
Yes, yes.
ನೀವು 1 and 2
Only accused number 1.
ನೋಟಿಸ್ ಮಾಡಿ. 1 HCGP 2 emergent notice. ನೋಟಿಸ್ ಆಗಿದೆ ಇಲ್ಲ ಅಲ್ಲ? 1 HCGP 2 emergent notice.
Admissions. Next at merit. Democracy case also no.
No, we'll see, sir.
The entire transaction done with the complaint name, Lord. Complaints
Well returnable by 6th, 7th. Next.
Seal number 8.
So. ಮ್ಯಾರೇಜ್ ಆಗ್ತಾರೆ ಅಂತ ಹೇಳಿ ರಿಲೀಸ್ ಮಾಡಕ್ಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ರಿಲೀಸ್ಡ್ ಆನ್ ಬೇಲ್.
ಎಲ್ಲಿ ಮ್ಯಾರೇಜ್ ಆಯ್ತು ಇನ್ನು ಬರಲೇ ಇಲ್ಲ ಈ ಕಡೆ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ನೋಡಿ.
For the petitioner, my lord, requesting for a short accommodation in this matter, my lord.
What's the matter?
Is that explosive
My lord, this is regarding 2 goats being killed
goats
while, please, my lord. My lord, on the last occasion had said that my lords will impose a fine and close this matter. My lord may kindly have it on another day. We'll appear in person, my lord.
Yes, list the matter on 1st July. Interim order subsisting will continue to the next date of hearing.
Grateful, my lord.
Yes, next.
10.
10 and 11.
Release of money.
Release of money?
Yes, my lord. I invested something. Trusting the
Application is rejected,
ಹೌದು. ಒಂದು 10 and 11.
ಅಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಾ?
ಹೌದು. ಹಾಕಿ ಆಮೇಲೆ ರಿವಿಷನ್ ಕೂಡ ಆಯ್ತು. ರಿವಿಷನ್ ಅಲ್ಲಿ ಕೂಡ rejected.
ಆಯ್ತು, ನೋಟಿಸ್ ರಿಲೀಸ್ ಏನ್ ಮನಿ ಇದು?
Covered by
They are the complainant.
someday judgment.
The petitioners both cases. The petitioners are before this court calling in question 2 orders, one of the learned magistrate and one of the revisional court, seeking release of an amount seized by the police during investigation quantified at 14,90,731. Both the courts have concurrently denied the relief to the petitioner by rejecting the applications under section 497 and 503 of the BNSS. It is an admitted fact that acute agidira.
Complainant.
Huh?
I'm complainant.
Complaint. It is an admitted fact that the amount belongs to. Illen complainant ಕೆಳಗಡೆ ಹಾಕಿದೀರಾ ಅದಕ್ಕೆ I thought. It is an admitted fact that the amount belongs to the petitioner as it was seized from the hands of the accused. In identical circumstances, this court has held as follows. Full ಹಾಕ್ಬಿಡಿ. In the light of the issue standing completely answered and on the same reasons, the petitioner is entitled to the same relief, same order. Yes, both the petitions.
12.
Preparing for petitioner. Offense under section 108, 351 sub clause 2.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿಲ್ಲ sir. Petitioner is the accused, sole accused.
Investigation papers ಕೇಳಿದ್ದೀನಿ last time. ಡೆತ್ ನೋಟ್ ಇದೆಯಾ?
Death note ಇದೆ ಸ್ವಾಮಿ, but ನನ್ನ ಹೆಸರಿಲ್ಲ ಸ್ವಾಮಿ.
Death note is on that. Death note ಅಲ್ಲಿ she exonerates him.
Exonerate. Santosh Kumar BG.
Husband ತಾನೆ?
Who died?
ಅಲ್ಲ, sorry. She does the death note ಅಲ್ಲಿ she exonerates the husband, not the.
That's what I'm saying. Yes. Well, let the complainant come. 1 HCGP2 emergent notice,
Date can be fixed.
returnable by 7th July.
Grateful, grateful.
Next.
13.
Counsel for petitioner, my lord. The accused
138.
Sorry, complainant, petitioner.
138.
138.
Ah.
So, the company is in insolvency and managing director was suspended and the case is pending in NCLT. Number one. Number two, ಈ ಕೇಸ್ನಲ್ಲಿ ನಮಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. ಪರ್ಟಿಕ್ಯುಲರ್ ಚೆಕ್ ಇದು ಮಾಡಿದಾರ ಕೊಡಿಲ್ಲ, ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ.
ಅಪೀಲ್ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
ಸ್ವಾಮಿ ಅಪೀಲ್
20%.
20% ಕಾಲ ಅಂತ ಇದು ಮಾಡಿ.
Anything else?
ಸ್ವಾಮಿ ಡಿಫೆನ್ಸ್ ನಮಗೆ ಇದು ಲೇಟೆಸ್ಟ್ ರಿಪೋರ್ಟಬಲ್ ಇದಿದೆ ಒಂದು ಸೈಟೇಷನ್
ಕೊಡಿ ಸರ್.
ಲಾಸ್ಟ್ ಪೇಜ್
ಕೊಡಿ.
ಪರ್ಮಿಟ್ ಮೀ ಟು ರೀಡ್ ಮೇಡಮ್.
ಬೇಡ ಕೊಡಿ. ಇದೆ ಹೊಸ ಹಳೇದು.
ಲೇಟೆಸ್ಟ್ ಸ್ವಾಮಿ ಮಾರ್ಚ್ 2026. ಈ ಮಾರ್ಚ್ 26.
ಸಾರಿ ಮಾರ್ಚ್ 24 ಸರ್. 2 ವರ್ಷ ಹಳೇದು. ಲೇಟೆಸ್ಟ್ ಅಂತ ನನಗೆ
ಥರ್ಡ್ ಬೆಂಚ್ ಗೆ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ ತೊಗೊಳ್ಳಿ. Yes. Petitioner to serve on the council who represents the response. Sir, moratorium proceedings will be applicable only to the company and not its directors. Yes. Next.
Liberty may be given to address in the trial court, session court, argument liberty may be given, my lord. At least that 3-7 case ಇದೆ in Hassan. Liberty may be given to argue on the merit.
ಮಾಡಿ ತೊಂದರೆನೇ ಇಲ್ಲ.
ಆಮೇಲೆ ಬೇರೆ ಬೇರೆ ಚೆಕ್ಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ನೋಟಿಸ್ ನಲ್ಲಿ.
ಎಲ್ಲ ಮಾಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್ಸ್.
Liberty may be given, please.
The petitioner, after arguing the matter, then seeks leave of this court to withdraw the petition and reserve liberty to urge all the contentions before the concerned court, I mean criminal appeal. Reserving such liberty to urge all the contents before the concerned court, the petition stands disposed. Yes.
14.
Hearing for the petitioner. Sir, this matter was directed to be listed on 17th, my lord, sir. Yesterday it had come up before the court.
ಆಯ್ತು, ಇವತ್ತಾಕೆ ಬಂತು ಮತ್ತೆ? ಟ್ಯಾಗ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ನನ್ನ ಯಾರು ಹೇಳಿದ್ರು ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ. ಅದು ಪೆಟಿಷನ್ ಯಾವುದೂ ಇಲ್ಲ ಅಲ್ಲಿ.
The petitions have to be filed, my lord, sir. Actually 6 matters I have mentioned.
Correct. ಹಂಗಂತ ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ರೆ ನೀವು?
ಇಲ್ಲ, before that I would have filed it, my lord, sir.
No, not this way. We'll take it on 17th.
17th.
No interim order. ಅದು ಹಾಕಿ ಮಿಕ್ಕಿದೆಲ್ಲ ಫಸ್ಟ್.
So far as the tabulation aspect is concerned, she was not in that section at all, my lord.
We'll see. List on 17th ಯಾವ ಇದೆ ಎಲ್ಲ ಹಾಕಿ.
Yes, madam.
Next.
The SC/ST Act, my lord. The case and counter case are there. In this case, they filed charge sheet. In counter case, they are not filed charge sheet.
Same investigating officer?
Charge sheet not at file, my lord.
Investigating officer same or different?
My lord.
Just secure instructions. The learned additional SPP to accept notice and secure instructions. Secure instructions as to the secure instructions with regard to non-filing of the charge sheet in the complaint given by these petitioners, while the charge sheet is filed on the same offences against these petitioners on the next date. List the matter on 18th agata? 18th.
The complainant is also made as party in this.
Yes.
Case act.
The further proceedings shall remain state till the next date. Yes, next.
16.
My lord, application under 436A was filed by the petitioner on the ground that he has
Yes, madam.
My lords, on the Honorable Supreme Court on 24/2/2026 rejected the bail. Not rejected, my lord, they have withdrawn it.
No, they have withdrawn it. There is a direction by the apex court that including medical problems, other things also can be urged here.
Now, my lords, the same grounds they had taken before the SLP so far as the period of imprisonment, my lords. I have produced the SLP.
A judgment ಯಾವ್ದು ಕೊಡಿ.
My lord, on the last occasion I have.
And my lords, there are only 15 witnesses I undertake.
So let my witnesses, sorry.
Supreme Court judgment is in page number 70, my lord, but this has been dealt by Vijay Madan Lal Chaudhary, my lord. Exactly in the same scenario. I have produced on last.
Yes, madam ಕೊಡಿ. ಏನು citation ಎಲ್ಲಿದೆ?
Even copy was also. I don't know.
Statement of objections ಇದೆ ಇಲ್ಲಿ.
Judgment ಕೊಟ್ಟಿದ್ದು.
ಅವರು ಕೊಟ್ರಾ?
My lords,
More than 600 page, my lord.
The Gotto, yeah. Then how do I?
Kindly pass on, my lord.
Pass forward, yes. Nodi madam ಇದೆ. Next. Hmm.
17.
Enter order ಇದೆಯಾ?
Yes, sir.
Post immediately after service of notice upon the respondent. Enter order continues. Next.
18.
Matter pertains to Jargo.
Why is the learned SPP waiting?
Fine, my lord, in this case.
SPP or ಯಾಕೆ wait ಮಾಡಿ?
Serial number 24.
20?
24th.
All right. Hey, 5 minutes.
Yes.
Hmm.
18.
The orders challenged by the state, 3 orders of attachment, my lords, which have been set aside, which is challenged here. My lords, all the 3 orders which the investigating officer has done has to go on the ground that 107 is not complied with, my lords. Now 107, about 10 high courts and 19 judgments have taken view, it is mandatory. Now in this case, the orders that have been done is without following 107. So the 3 orders will have to go. Even on the merits, my lords, probably after they submit, I will point out, because court was under the impression, probably Jar Gold has been filing litigations to circumvent this proceeding. That is not the case.
Litigation ಅಲ್ಲ, accounts open ಮಾಡಿದ್ರು.
I will point that out. Let them say what the ground of challenge is, my lords. If 107 is not complied with, then these orders will have to go. The whole compilation on 107, I'm passing it on, my lords. 10 high courts have taken the same view, but 19 decisions are there on that. Even the coordinate bench has taken that view, my lords, because after BNSS has come in, the investigating officer can't straight away freeze any account. He needs the order from a magistrate. And ultimately, my lords, even for an interim order, my lords, the magistrate can pass it without hearing a party. But IO does not have the power. Now, in this case, my lords, one is attachment of the bank accounts. The other is, my lords, direction for the gold to be kept frozen. The third is sealing of the office premises. All the 3 will have to go because 107 is not complied.
ನೀವು ಯಾರಿಗೆ?
ಇದರಲ್ಲಿ ನಮಗೆ there is a direction to the AU bank to defreeze the account.
Hmm.
Lord, the state has intimated to us to defreeze the 2 accounts.
Hmm.
Lord, we after receipt of the letter from the CID, superintendent of CID,
Hmm.
my lord, since there is another freezing order from the KPID,
Hmm.
we intimated the KPID.
Hmm.
Madam.
Can I give a clarification, my lords, to this? Can I just give a clarification by virtue of my lord's order, my lords? We brought it to the notice of the court that GST payments have to be made.
Correct.
My
I
lords was
permitted
pleased to-
GST
Yes, my lords.
payments.
So we wrote to the IO wrote to the 3 banks to defreeze for us to pay the GST. 2 banks obliged, and we were able to get a crore odd from each of those banks. The bulk of the amount was with the present bank, AU Bank. So even the IO had written to them to defreeze. In the meanwhile, my lords, under the KPID Act, the competent authority wrote to them that they're freezing it. My lords, we challenged the action of the competent authority, his appointment under the KPID Act, on the ground that once Buds Act is invoked, you can't have KPID Act. And in that, my lords, there's an order of stay granted by this honorable court, and after which there is no impediment for them to release the amount. Now, without releasing the amount, they have now filed an application to implead themselves to get clarification from the court whether they can release the amount.
13/5/2026, KPID wrote a letter to us, my lord, the annexure F, page number 20.
Yes.
Wrote, we have narrated everything to the KPID since there is the order passed by the honorable court, we need to comply the order. My lord, KPID, my lord, in turn wrote a letter to us. My lord, I am permitted to. Further, your attention is invited to the cautionary letter dated 8/4, wherein this was clearly stated that the freezing order.
ಆಯ್ತು, clarification ಕೇಳಿದ್ದೀರಾ?
My lords, the order is there of this honorable court staying the KPID proceedings. At page 64 is the order, detailed order, my lords. Page 64, 3/6/2026, after their letter. Page 64, the court deals with the 2 acts, my lords, Buds Act and KPID Act, and the order of stay of the appointment of the competent authority and all the proceedings thereafter. That should in fact be a reply, my lords, that there is no impediment for them to release the amount so far as we paying the GST is concerned, my lords. Now it's only for the payment of GST. Now from GST we have received 2 notices actually pointing out the default. Now we will be open to proceedings under that act, my lords. my lords may recollect, my lords, once Buds Act has come in, my lords, KPID Act was an earlier act. Various states had acts similar to KPID Act. 4 of the states now have repealed it because Buds Act deals with the very same subject matter of deposits. So, my lords, 4 of the states repealed it. So, when we pointed out here, we have a central enactment vis-a-vis a state enactment. This order, what is passed, my lords, it's staying.
In fact, Lordship may have it either afternoon. I wanted to place 2 documents. One, the additional document, Your Lordship may recall, Your Lordship has dismissed challenge for FIR which taken to Supreme Court and Supreme Court has confirmed it. While in that SLP pending, they have filed an additional document including the fact that where Your Lordship stayed these orders and brought to the knowledge of the Supreme Court. And when the matter was pending before this court and the Supreme Court, fresh accounts have been opened. And this petition, my lord, was filed in coordinate bench. I'll place the pleadings also, my lord, claiming that they are not an accused. They are nothing to do with the jar gold. And on the other side, they say that they're subsidiary of jar gold. And I'll place all those things.
Nale tagon, tomorrow.
Please.
List tomorrow in the fresh matter. Heard the learned senior counsel Sandesh Chota appearing for the petitioner. List tomorrow in the fresh matters list at the request of the learned additional SPP.
My lords, in this memo of documents I have given, the 7 events that have taken place post my lord's order.
I'll also go
Yes,
through
my
it.
lords, post my lord's order, when we went to the SLP, liberty was given to challenge the charge sheet. Meanwhile, these attachments and the order.
Charge sheet आगे दिएगा.
Allah, liberty given by Supreme Court, enabling you to challenge it if a charge sheet is filed. My lord's order was upheld, but liberty granted. Then comes this attachments, which my lords was pleased to pass the interim orders to safeguard the GST. The whole sequence, 7 events, I put it together, my lords.
And
Char Gold also, my lords, the writ which they filed in the vacation. Char Gold is a parent company, my lords. I'm sorry. Chains Char is a parent company which approached the court. They were not an accused in this matter. They approached the writ petition on the ground, my lords, 107 was not complied with, was interim order. The whole sequence
We'll
is there.
see, yes. Tomorrow, no, I'll also go through. Respondent. Oh, sorry, for the respondent.
And for the
Heard
response, we should be interchanging. But
Heard the learned additional SPP appearing for the petitioner and the learned senior counsel Sandesh Chowta representing the respondents. Yes.
Please.
List tomorrow at the request of the learned additional SPP. Yes.
Fresh matters.
Fresh matters.
21.
bring for petition. Petitioner challenging.
Be report. 306 cell.
File live, Lordship may have it.
Huh?
Not rejecting of the report, taking cognizance
That's what.
without hearing of the petition.
You are not heard. ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನಿಮ್ಮನ್ನ ಹಿಯರ್ ಮಾಡೋ ಪ್ರಶ್ನೆ. Anyway, list the matter. One additional SPP2 emergent notice. The issue in the list is with regard to the offence under section 306 of the IPC. It is surprising as to how in an offence under section 306 of the IPC, the police could file a B report. The B report is rejected and the concerned court has taken cognizance of the offence. While so doing, the order of the concerned court does not comply with the mandate of the judgment of the coordinate bench in the case of Ravi Kumar so and so, ILR 2018 Karnataka 1725. As also the fact that the ingredients of section 107 to be present in the for an offence under section 306 also. ಯಾವ stage ಅಲ್ಲಿ ಇದೆ ಈಗ?
Summons.
Also is not met in the case at hand. In that light, as also in the light of judgment of the apex court in Yadvinder Yadav 2023. Gotala 2332. Yes. Next, there shall be an interim order of stay of further proceedings before the concerned court. Next.
22.
7 April.
Serve on BB Patil. Counsel BB Patil is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel. Emergent notice to the complainant returnable by 2nd July. List on 2nd July.
23rd framing of charge.
ಯಾವ್ದಾಗಿದೆ?
23rd
23rd of.
The concerned court shall defer its act of framing of charges till the next date of hearing. Yes, next.
23.
And for the petitioners in this matter, my lord.
Hmm.
This is the dispute between the mother and son, my lord. And the respondent has filed the petition under section 12 of the DV Act before the learned magistrate, my lord. The learned magistrate has granted partial relief in favor of the respondent, which is in page number 104, my lord. Kindly be seen, 104. The respondent is hereby restrained from withdrawal of the capital gains arising
In
out
DV
of
Act.
DV Act, my lord.
Hmm.
Trading in respect of demat.
What are you
account.
challenging now?
Now, the challenging this order, the respondent has filed the criminal revision petition before the Honorable Sessions Court, my lord, which is in page number 20. And the learned session judge has passed.
Who is the second petitioner?
Second petitioner is the wife of the petitioner number 1, my lord. And
Who is the first petitioner?
First petitioner is the son of the respondent, my lord. And in the revision petition, the session judge has passed a series of orders, which is in page number 20. There is an alternative remedy. In fact, there is an alternative remedy under section 29 of the DV Act. But here in the case, the learned session judge has passed a series of orders. Virtually, the learned session judge has encroached upon the powers vested under section 12 of the DV Act.
Emergent notice to the respondent petitioner to serve on the counsel who represents the respondent in the trial proceedings. Further proceedings before the concerned court till the appearance of the respondent shall remain stayed. List on 7th. Yes, next.
24.
And pursuant to the order passed by the learned session judge, the public prosecutor has filed a separate case against the petitioners, my lord.
Then interim order vacated.
ಅಲ್ಲ, ಇದ್ರಲ್ಲೇ.
ಅದಕ್ಕೆ interim order ಆದ್ಮೇಲೆ argument ಮಾಡಬಾರದು.
Yes, much. Yes. Sorry, my lord.
24.
Matter is already stayed.
Stayed?
A1 and A2, page 36.
30?
Page 36. That they will have to move under.
One moment,
chapter 14
one
of the
moment. My order?
ಇಲ್ಲ vacational move ಮಾಡಿದ್ರು. We are moving for vacating the interim order in floods. We appear for the de facto complainant.
One minute. What's the matter, sir?
But matter involves certain disputes between directors, where one set of directors, the complainant is pointing out certain issues with respect to the running of the company. And not those issues, if the complaint is seen, page 21.
Yes.
It elaborately sets out various aspects. I'm not under section chapter 14 of the Companies Act. These issues have to be brought to the notice of, it's covered by a decision of this honorable court. Justice Suraj Govindraj's decision. It says, judgment Tandila, which says that investigation, section 210 of the Companies Act, investigation into affairs.
That is SFIO.
That is
serious fraud investigation.
There are four methods by which it is indicated. And this honorable court has said in that judgment that unless that procedure is followed, IPC provisions are not open, BNS provisions are not open. Judgment on Tandila will bring that judgment. So therefore,
tag ಮಾಡಿ here ಮಾಡೋಣ ನಾಳೆ.
Tomorrow, my lord, could it be connected also with?
ಅದನ್ನೇ ಹೇಳಿದ್ದು. Connected with Justice R. Nataraj. ಅದೇ ಅಲ್ವಾ?
ಅದೇ.
Page?
ಅದು ಕಾಪಿ ಇಲ್ಲ. 7 connected matter.
Connected matter number
11/2006.
Page ಹೇಳಿದ್ರಲ್ಲ.
7411 of 2026.
Of 26.
ವಿವೇಕ್ ಸರ್ ಪೇಜ್ ಎಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ ಈಗ.
36.
Page 36.
36.
35. Annexure D.
Yes.
ಇದನ್ನ ಇದ್ರ ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ ನಾಳೆ ತಗೊಳ್ಳೋಣ.
ನಾಳೆ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ವೆನ್ಸ್ಡೇ. ನಾಳೆ ಇಲ್ಲ.
ನೀವಿಲ್ವಾ? ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಬೈ ದೆನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕಿ.
Please.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅಲ್ಲ ಅದು ಇದರಲ್ಲಿ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ಇದನ್ನ.
will take notice for de facto complaint.
The learned
ಇಲ್ಲ.
The counsel for the advocate on record shall serve a set of papers upon the counsel on record for the respondent and the state forthwith. Tuesday.
In the meantime.
Tuesday.
ಅಲ್ಲ
ಅಲ್ಲಿವರೆಗೆ ಏನಾಗುತ್ತೆ?
ಅಲ್ಲ ಬೇಡ ಇರ್ಲಿ.
ಏನು ಮಾಡಲ್ಲ ನಾವು.
ಏನು ಮಾಡಲ್ಲ
ಅಷ್ಟೇ. Learned additional SPP submits that nothing would be done.
ಅಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಟಿದೆ ಇರ್ಲಿ ಅಲ್ಲಿವರೆಗೂ ಇರ್ಲಿ. ಆಮೇಲೆ ವಿಲ್ ಕನ್ವಿನ್ಸ್
But interim order ಇದೆಯಲ್ಲ.
ಕೊಟ್ಟಿದೆ, ಬೇರೆಯವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರು ಟೈಮ್ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ, ಆದ್ರಿಂದ ಏನು ಮಾಡಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ.
That is.
Interim order ಬೇರೆಯವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದೆ.
We'll hear it on Tuesday in the fresh matters list. ಮತ್ತೆ
ಹಾಗಾದ್ರೆ ಸ್ಟೇ ಬೇಡ.
ಒಂದ್ ದಿನಕ್ಕೆ 24 ಅವರ್.
ಆಯ್ತು. List the matter on Wednesday, 18th ಅಲ್ಲ? 17th in the fresh matters list. In the light of the interim order subsisting qua the co-accused, there shall be an interim order till the next date of it. Don't file vacating stay. We will hear it.
Please.
On
The
17th.
name of Madhur Kalyan Shetty may be.
What? ಎಲ್ಲಿ?
ಇದನ್ನಲ್ಲಿ ಕಾಸ್ಟ್ for the petitioner.
ರಿಜಿಸ್ಟ್ರಿ ಟು ಕೆ ಎನ್ ಸುಬ್ಬಾರೆಡ್ಡಿ ಬೇಡವಾ?
ಇಲ್ಲ.
ಆ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇವ್ರದ?
ಅಲ್ಲ, ಇವರೇ ಫೈಲ್ ಮಾಡಿರೋದು ಇದು.
ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿದೆ?
24.
ಓ, ಬಾಲಗೋಪಾಲ್ ಮೇಲೆ. ಸಾರಿ. Registry to print the name of
Madhur Kalyan Shetty
in place of Balagopal. Yes. Wednesday, fresh matters, same order. Page 35, tag.
Please.
We'll not file formally, but we'll argue the matter on the day of
No problem,
application.
whatever it is.
Please.
The previous day, my lord. Yes, on the previous day, your lordships had
Where?
already. Sorry, ma'am.
Who are they behind you?
May I request one?
I'm just saying one thing.
I'll place the record. There are certain communications which during the stage.
Kodi. Yes.
Can I say one thing? Lordship, may see those. I have no difficulty. The lordships had orally remarked on the previous statement that rape of a foreigner is a very serious offense. I just want to make one clarification. It was carried all over the media. One clarification. Yes, ma'am. I am not for a minute saying that no such incident happened or whether it was consensual, non-consensual. I'm not going into that now. The only question is not whether, however serious an offense is, can the state violate the rights of accused with impunity? Yes, my simple case is.
I will definitely answer that.
Yes.
But you tell me these homestays need to be regulated. Because
the function of
they
the
have
state.
mushroomed to such an extent that we don't know where are they and what happens there.
But somebody's
So everybody's security is at risk.
No, there are thousands of homestays.
That's exactly.
We are a licensed homestay. We
That's
are not a-
all licensed day. Gram Panchayat license ಕೊಡ್ತಾರೆ. Yes.
No, can I just take your lordships to the FIR and just point out one thing so that the state has an answer on that? Just please come to the FIR at page 37. Lord, there were 4 offences in the FIR. Please come to page 37.
Yeah, tell me.
64-1, 238, 239, and 351. 64-1 is rape. 238 is destruction.
Rape obviously is not against you.
Now, in her complaint itself, she says that the incident happened between 1 to 3. She identifies who it was. A bald man names the accused. Lord, she says 17 minutes after the incident, thank you for giving me Wi-Fi access. You're ready. You can upcharge me because you have been helping me out. That WhatsApp message, my lord, is at page 51. Your lordship will only see at page 51. She says, thank you. I just received Wi-Fi and I'm now back up and running. Do let me know or feel free to send me a request for the dollar amount for me to pay you back. And you can absolutely upcharge me as you're helping me out. This is 17 minutes after the incident. I was not at the site at all. Now, please see, my lord, 12th, between 1 to 3, the incident happens. 4 o'clock, I come to the property, I give her Wi-Fi. She specifically in a complaint says, I did not disclose to the owner at that time what had happened. On 12th in the night, for 16 minutes, she has spoken to her friend on call in the US. Again, 8 minutes. 13th, she herself states in her complaint that she has received call back from the same friend. 14th, she gets a call from the US consulate. She's in touch with the US consulate as well. On 13th, 14th, CCTV footage captures the family and the victim going out. We have written to the sub-registrar office in the district lot to secure the CCTV footage and keep it safe. 13th, she goes out. 14th and 15th, she goes on a solo excursion. Everything captured on CCTV. 16th plot and then 18th, the FIR comes to be registered. FIR is for 64-1, 238, 239 and 351.
Yes.
Now on 18th evening, I'm picked up. 19th at 5 a.m., the arrest is shown. Now, my lord, all the 3 offences, which admittedly at its highest, even if they are attracted, against me are classified in the BNSS as non-cognizable and
Non-cognizable
bailable.
offences.
So at 19, on 19th at 5 am when I'm arrested, I am arrested for a non-cognizable bailable offence. Not, please remember, not in the Rajya Sabha case which your lordships had decided. It is not my case that no FIR could have been registered. There is rape, so cognizable and mix of cognizable, non-cognizable, FIR gets registered. The question is, could I have been arrested for what is admittedly a non-cognizable bailable offence?
You're still in custody?
I'm out on custody,
Oh, yeah.
Lord. Your lordships had pointed out why compensation to repair the homestay, Lord, not to repair the homestay, to
That's
repair
all
my
right.
reputation. Lord, I have been arrested for a non-cognizable, bailable, vicarious liability has been imposed on the owner for having helped the victim. The victim has travelled with the accused on the very next day, has written. Now, please see what the parents on 13th. Just see this email communication at page 53. If Wi-Fi has been cut off for 3 days, then and locked, she's been locked in a room. Just please see page 53. This is an email communication from her parents in the US she has received, which she has replied in 30 minutes. Just please see 53. Lord, your lordship will see at the bottom the date, April 13th at 9:12 a.m. This is on the following day. If she had no Wi-Fi, she would not have received this email. She would not have replied. Just please see what the parents say. So and so, I'm not taking the victim. The urgency to connect with you is because we are very concerned about you and want you to come home safely. Your trip has taken a toll on us. Your mom is running back and forth to Haley's weekly, caring for this constant worry about you is wearing on her and me. And then she has to field calls from friends that are seeing your posts and are also very concerned. You are halfway around the world without anyone else we know in the middle of nowhere. Why wouldn't we as loving parents naturally be worried about you? Now, please mark, this is very important. We don't understand why you cannot grasp that. Also, the issue with antidepressant meds amplifies this whole concern. Your lordships are there, Lord?
Yes, yes.
I know more than you might believe about this subject and have known many people that stop them like you did and end up in a world of hurt with extreme mood swings. Please consider going back to a smaller dose, maybe 0.5, 0.10 mg if you're experiencing negative thoughts. As far as me dismissing you, that couldn't be further from the truth, and so and so. She replies to this, Lord. That reply is at page 52. 45 minutes after this incident, she replies to her parents, which is forwarded to 7 other friends. In this entire email, there is no mention of any incident. She didn't maybe perhaps to not disclose it to her parents, but I want to only show your lordships at page 53. Just please see page 53 at the top.
Yes.
I'm working, she's replying to her parents. I'm working my job right now. My work understands me and they are extremely happy for me and have blessed me too much by letting me stay here longer. And that I'm allowed to work. I don't even have to work, but they're letting me and it's wonderful. I'm able to make my American living here at least for a few weeks longer. Why is it that you want me to come back to the US so urgently when I'm learning and experiencing firsthand that miracles really do happen? God really does exist. And I'm finally, for the first time in my life, feel healthier than I ever have. No constant body pain. I have no want, thought, desire for abusive, addictive substances. My bowel movements are aligned and I'm so much physically closer to God. The unenlightened so-and-so would have continued to put up with this trend of trauma and abuse. I am finally taking a stand and being who I truly am for the first time in my life. This happens on the very next day. Now, please see what her friend says. Not her friend writes to us. Your lordships will see that email 57. She names this woman who has sent us an email as a friend in the complaint. Please see what the friend says. At 57. Dear Aparna, as informed to you over the phone, so-and-so and I have been friends for 2 years and she has visited me multiple times in India. However, from the day I have known her, she has always been an enthusiastic, energetic and friendly person. I have a personal bond with her and think of her as my sister. However, during a most recent visit to India in March 2026, I came to realize that she has abruptly stopped taking her prescription medication, also known as escitalopram, used to treat major depressive disorder and generalized anxiety disorder. I understand from my discussion with so-and-so that she suffers from ADHD, OCD, anxiety and depression. I believe she had abruptly stopped taking her prescription medication. Her behavior has taken a turn for the worse, which is something I observed when she landed in India in March 2026. She's been experiencing emotions in the extremes, such as extreme happiness, extreme sadness. She seems to be showing paranoid thoughts and imagining things such as seeing visions and experiencing the presence of her late grandparents and her late boyfriend and becoming upset with me for not believing her. Her parents and her close friends have also observed extreme changes in her behavior and had requested my help in
How is all that got to do with the allegation now?
Lord, my point is very simple. Now your lordships have seen what were the 4 offences that have been named that have been added in the FIR. Admittedly, all those allegations against me The allegation being that I've suppressed this case.
You're on bail right now.
No, it's not
Then-
about bail, no,
then-
it's not on bail.
then what?
Then please see this. My prayer is for a declaration that the arrest is illegal, to stay the FIR insofar as 64(1) concerned against me. No, it's not about bail. There are pre-arrest safeguards and post-arrest safeguards. I'm not coming saying that my post-arrest safeguard of a written grounds of arrest is not given me, therefore it's violated. The pre-arrest safeguard is, Lord, if an offense is punishable less than 7 years, you should give me a 35(3) notice, comply with Arnesh Kumar. I'm not even saying that has been breached. That is admittedly breached. Something more serious, the breach is, there is a jurisdictional bar to arrest somebody for an offense which is non-cognizable. 35(2) is a non-cognizable offense. 35(2) says there is a bar on the police to arrest for a non-cognizable offense. How is it that, however serious this offense is, whether she's an Indian or a US citizen, merely because there is one cognizable offense, you go and arrest me? Because of the arrest, I have suffered humiliation. Booking.com, on which I have my listing, has written to me saying, we are going to permanently cancel your listing because there are sexual misconduct allegations against you. Not vicariously, not the owner. Not if this trend is continued, then nobody can do business in India. Whatever has happened, whether regulation should happen or not, that is state's responsibility, executive's responsibility. They're doing it. They need to crack down on homestays which are operating without license. We had a license. We have done the due diligence. We have done it. There's an unfortunate incident that's happened.
We'll see. Yes.
Look, your lordship will see. Your lordships will only see, Lord, what has happened in the remand application. Also, I have shown. Your lordship will see the remand application.
We'll see.
At 5 a.m. I'm arrested. At 11:30 in the night, I'm produced before the magistrate, not for remand purposes. At that time, 3(5) is added in the remand application for the first time. 3(5) is common intention to rape. I'm not even in the site. Supreme Court says two things to invoke common intention. There has to be prior concert and there has to be physical participation. That's the only way on which they've arrested me.
We'll see. Yes, sir.
We are not saying there is a common intention to rape. We are saying common intention to destroy the evidence. We are saying common intention to threaten the witnesses. The very fact, my learned friend has received the copy of the grounds of arrest. We have said what is the allegation against him. If he is not taken advantage of that and then wanted to come here and cry, we can't help. We have very specifically said what is the allegation against him. And the grounds of arrest we have served to him. The copy is there and shows that what is the allegation against him. That's one. Second, my learned friend is speaking about depression. Is he saying that she was not subjected to sexual assault? I'm sorry.
No. Depression is a separate thing. That has nothing to do with what he's wanting to project. That is accused number one will.
No, I started
not
by
accused
saying,
number one.
I'm
There are
not
two
for a
people.
minute saying,
No, in fact,
I'm not for a minute saying
not
that
one.
there is
There
no
are two
rape.
people.
There's someone arrested, he's in custody. The question is not whether an allegation of rape can stand against the owner.
We'll
We are not saying. We are not saying. Your Lordship, the very day she came into the state, she was subjected to sexual assault. She communicated. It's not that she never communicated. She did communicate.
To the owners.
Not to the owners.
Then?
To the parents
Only,
outside.
that is in the US.
Yes. At the back, because she did not know. In fact, the conversation between them saying that, okay, I will tell them. And subsequently, friend tells the owner that something like this has happened. After that, she's supposed to go and, in fact, everything is there in the chat before she files a complaint. She collects even the tissues which she was, the accused used after commission of offense. She collects everything. She carries all these documents with her. She wanted to, it's not that, my lord, she happily went out and etc. The very fact that she shifted from tent to the house is to say that she wanted to get locked and stay inside. She did not know. She was subjected twice by two different people.
Please come to the
and she collected the mat.
For a minute, I'm not appearing for the named accused who is apparently.
No, he's telling the facts.
I'm telling the fact. Yes, I'm telling the fact. She wanted rape. She has not taken a bath. She wanted to preserve the evidence. She says all these things. She collects the rape kit. Then the arrangement was made to shift her to Mysore, and then she files a complaint. It's not that, my lord, in the remand application and the grounds of arrest, we have specifically said what is the role. We have not said that he's committed a rape. We have said only this. We have said that, in fact, the grounds of arrest have given the copy. It very specifically said he is the person running. Chances of destroying the evidence, chances of threatening the witnesses. Of course, it is his property. The accused are there. Not all the accused was arrested. Second accused got arrested subsequently because the DNA. Now the DNA is matched with one of the accused. Second DNA was not matched. Therefore, all these things was there. So it is our obligation to protect. We have done it.
But my learned.
And the grounds of arrest is, if my learned friend has read the grounds of arrest, he should have filed an appropriate application before the court. He did not even file a bail application.
Not my learned friend not answering the argument. I'm not on a post-arrest violation of a safeguard. There are post-arrest safeguards, grounds of arrest. I'm not on that. I'm on a pre-arrest safeguard, whether you had the jurisdiction to arrest me in the first place. There is a bar, all offenses. And my learned friend supports my case if he says that there was a common intention to destroy evidence. Not if there is a common intention to destroy evidence, that does not change the classification of the offense from non-cognizable to cognizable. The question is whether you could have arrested me. No one is for a minute saying no incident has happened. There is an incident which has happened that is being investigated. We would be happy for it to be investigated by a specialist agency like CID. Because in a complaint she says, I was served with a welcome juice, was a guava juice. In the seizure form, in the property form, what has been seized is pomegranate juice. If that is the level of investigation which that Kutta police station is doing, then not necessarily it should go to a more specialist agency. Let this investigation be done properly. I'm only saying.
We'll see.
Yes, but I'm only saying your lordship will see the complaint once. In the complaint.
Heard reserved. Yes. We'll see. Yes. But you sought quashing of the proceedings also?
I've sought, not, if your lordships are reserving it on this point, not, then your lordship will only show, I'll show the complaint, not, your lordship will only see the complaint.
And before my learned friend answers, he has an obligation, when the foreigners comes, he has an obligation to report to the jurisdictional police. He has not reported. Running a home stay, just because you have a license doesn't mean that, in fact, my lord, the WhatsApp communication, if your lordship reads, reads sketchily discloses.
No, you have challenged the FIR also?
Yes, I have challenged the FIR insofar as offense of rape against me is concerned.
No, 64 against you is not there at all.
Yes, no.
No,
Now,
there can't be there.
Then your lordship will have to answer this question.
That we'll see.
If 64 goes against me, then your lordship will have to answer this limited question, whether I could have been arrested. Not your lordship may record my submission, whether I could have been arrested. My arrest is shown at 19th at 5 a.m. I'm remanded. 3-5 is added without a requisition. The complete violation of procedure. If you want to add an offense in the FIR, you had to add it by way of reference, not there.
But the challenge is there to the FIR also?
There is a challenge to the FIR insofar as my implication for offenses of rape and for the other offenses not, because she in her own complaint says that I have not informed the owner. Can I just show your lordships that not? How do they show that I was having prior information of this incident? Only then can they show I've suppressed. And if they're saying I've cut off Wi-Fi for 3 days, your complaint only says in 3 parts that on 12th I was in communication with a friend in US, 13th the same friend. Please see the complaint.
Okay, Wi-Fi ಬೇಕಾ 4G ಇಲ್ವಾ?
Then
Wi-Fi ಇದ್ರೇನೆ ವರ್ಕ್ ಆಗೋದು, ವಾಟ್ಸ್ಆಪ್ ಅಂತ ಇಲ್ವಲ್ಲ, 4G ಆಗುತ್ತೆ.
No, the allegation is that she was locked in a room in order to suppress and hush up this case.
That will see.
In communication, not this is entirely the.
No, in communication, yes, you don't need Wi-Fi at all for communication.
So, not, the only allegation is against me to suppress.
You need network, whether it's Wi-Fi or
and
mobile.
not, please see, I have written to the sub-registrar of the local Kutta jurisdiction to preserve the CCTV footage. We have submitted the CCTV footage for this court's perusal, even for the state, because the CCTV footage captures that 13th, 14th, 15th, she had full access, no, nothing prevented. If the allegation is that I was suppressed, not.
We'll see. The offense is serious. We'll see what is your role and pass orders.
But not if the arrest is illegal, your lordship will have to arrest is not person specific, allegation specific. Merely because the FIR will have one cognizable offense, there are 10 accused. The police not.
No, we'll answer that.
US passport holder bringing pressure from embassy, not you cannot just.
No, that's not the issue. But
my fundamental rights are also involved here. The US citizen.
Bail is granted now, right?
Bail is granted. Not the question is whether I could have been arrested now. If this becomes a precedent, then.
Let's see. Yes.
I'm grateful.
Heard reserved.
26.
Yes.
Almost the entire BNS is incorporated. It looks to me that it is a case of AI and the complaint. Otherwise, in Barika, chances illa. And half a dozen enactments. My lord, the marriage was on 30th of April 2025. Lord, prior to the marriage, they would send a biodata to me. That biodata your lordship would get at page 80. Even 78 also your lordship would get. Kindly have a look at page 78 and then 80.
Yes.
Cast. Counter.
Yes, sir.
Even 80. 1 year counter. In the date of filing of the complaint, I was not even aware of any other caste which she was having other than being a gounder. But on the very date of marriage itself, her grievance is, although the party of the bride had fixed the chowdhury and all that, in the room that was given to me, some narcotic drugs was found. Not today, my lord. It was about 1 year.
23.
Yes, my lord.
23 ಅಲ್ಲಿ.
And just on the sample ಮಾತ್ರ ತೋರಿಸ್ತೀನಿ ಅಷ್ಟೇ, ಒಂದೊಂದಕ್ಕೂ I can deal with it. May I just request your lordship to kindly take section 3 and 4 of the Protection of Civil Rights Act for a second.
ಕೊಡಿ.
ಒಂದೊಂದು ಆಕ್ಟ್ ತೋರಿಸ್ತೀನಿ, ಏನ್ ತೊಂದ್ರೆ. Have a look at section 3 and 4. ಇದು ಕೊಡಿ ಸಾಹೇಬರು, ಕೊಡಿ. Section 3, my lord. Whoever on the ground of untouchability prevents any person from entering any place of public worship which is open to other persons professing the same religion or any section thereof as such, or from worshipping or offering prayers or performing in a religious service in any place of public worship or bathing in or using the waters of any sacred tank, wellspring or water course, river, etc. ಇದು ಮನೆ ಒಳಗಡೆ ದೇವರ ಮನೆಗೆ ಬಿಡ್ಲಿಲ್ಲ ಅಂತ. The provisions of the Protection of Civil Rights Act will have absolutely no application whatsoever at all. But the other offense for which the crime has been registered, investigation is taken up is for an offense under the Atrocities Act. But 31R, S, U and ZA. ಅದೆಲ್ಲ ಪಬ್ಲಿಕ್ ವ್ಯೂ ನಲ್ಲಿ ಆಗಬೇಕು, ಮನೆ ಒಳಗೆ ಆಗೋದಿಲ್ಲ ಅದೆಲ್ಲ.
31 R&S ಬರಲ್ಲ ಬಿಡಿ.
ಐ ಆಮ್ ಸಾರಿ ಮಲೋಡ್.
31 R&S ಬರೋದಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಏನು ಅಂತಂದ್ರೆ ಇದು ಆರ್ಮ್ಸ್ ಆಕ್ಟ್. ಹ್ಯಾವ್ ಎ ಲುಕ್ ಅಟ್ ಆರ್ಮ್ಸ್ ಆಕ್ಟ್ ಮೇಲೆ ಸೆಕ್ಷನ್ 25 and 27. ಇದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್, ಸೆಲ್ಲು, ಟ್ರಾನ್ಸ್ಫರ್, ಕನ್ವರ್ಟ್ಸ್, ರಿಪೇರ್ಸ್, ಟೆಸ್ಟ್ಸ್, ಪ್ರೂಫ್ಸ್, ಎಕ್ಸ್ಪೋಸಸ್ ಆರ್ ಆಫರ್ಸ್ ಫಾರ್ ಸೇಲ್ ಆರ್ ಟ್ರಾನ್ಸ್ಫರ್. ಸೆಕ್ಷನ್ 25. ಅಲ್ಲ 27 is penal clause. ಅದು ಆಗಲ್ಲ. But your lordship have ruled and the Supreme Court has ruled blindly the officer in charge.
Atrocities Act
prevent ಇದು ಬರೋದಿಲ್ಲ.
Arms Act
ಬರೋದಿಲ್ಲ. Protection of Civil Rights Act ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ, Protection of Civil Rights Act ಇಲ್ಲ, ದೇವ್ರ ಮನೆ ಒಳಗೆ ಬಿಡ್ಲಿಲ್ಲ ಅಂತ. Arms Act, what is Arms Act is para 22.
ಹೌದು.
At page 45.
ಹೌದು.
The allegation.
ಹೌದು, ಅದಾಗೋದಿಲ್ಲ. 25, 27 ಆಗಲ್ಲ. 25, 27 ಆಗಲ್ಲ. They have registered the crime for 25 and 27. That has got to go along with section 5. It should be for sale. Possession is for sale, not otherwise. ಇದು ಆಗಲ್ಲ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ NDPS. Well, 8(1), 8C, 20 and 27. ಅದು ಆಗಲ್ಲ. ಏನಂದ್ರೆ ಮೆಕ್ಯಾನಿಕಲ್ ಆಗಿ without even adverting to the allegations made in the complaint, a crime has been registered. And after 1 year of the filing of the proceedings before the family court at Bangalore, ಇದು ಇದು ಕಂಪ್ಲೇಂಟ್ ಅಷ್ಟೇ, ಇನ್ನೇನಿದೆ.
appears to be.
It looks to be like that. ಯಾಕೆಂದ್ರೆ ಒಂದು BNS ಅಲ್ಲಿ ಎಲ್ಲಾ ಅಫೆನ್ಸ್ 61, 74, 75, 79, 85, 109, 115, 117, 118, 126, 127, 308, 316, 318, 324, 351, 352, 350 ಯಾವ್ದು ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ನನಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಸರ್, and she stayed in the matrimonial house for 1 month. ಗೋಸವೆ
1 month ಅಲ್ಲಿ ಇಷ್ಟೊಂದ?
1 month ಅಲ್ಲಿ ಇಷ್ಟೊಂದು. ಆ ಜೊತೆ ಯಾವತ್ತಿದೆಲ್ಲ ಆಗಿರೋದು on the date of the marriage itself. A complaint is 1 year, 1 month later. And that too, after I filed a petition before the family court at Bangalore.
All of you are out on bail?
I'm sorry, my lord.
Bail ಸಿಕ್ಕಿದೆ ಎಲ್ರಿಗೂ?
ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
Bail ಇಲ್ವಾ? Bail.
Bail ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ bail?
ಎಲ್ಲ ಹಾಕೇ ಇಲ್ಲ.
ಹಾಕೇ ಇಲ್ಲ.
ತಮ್ಮಂದೆ ಬಂದಿದ್ದೇನೆ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
Yes.
No, I'll secure the record, my lord, because.
Secure the records.
Yes.
ಯಾವಾಗ ಆಗಿರೋದು crime?
35/2020.
ಈಗ ಮೊನ್ನೆ.
35.
ಈಗ ಮೊನ್ನೆ.
ಓಯ್, ಒಂದ್ ವಾರನೂ ಆಗಿಲ್ಲ. ಅಲ್ಲ, 10 ದಿನ ಆಗಿದೆ ಅಷ್ಟೇ.
ಎಲ್ಲ ಡಾಕ್ಟರ್ಸ್ ಇವರೆಲ್ಲರೂ, ಒಬ್ರು ಯೂರಾಲಜಿಸ್ಟು, ಇನ್ನೊಬ್ರು ರೇಡಿಯಾಲಜಿಸ್ಟು, ಇನ್ನೊಬ್ಬ PhD. Entire family has been legged into the case.
ಇಲ್ಲ, ಅದಕ್ಕೂ 498 ಒಂದು ಸಂಬಂಧ ಇಲ್ಲ. But too many offenses.
ಅಲ್ಲ, ಬಟ್ ದೇವ್ರ ಮನೆಗೆ ಬಿಟ್ಟಿದ್ರೆ ಮನೇಲಿ ಇರ್ತಾ ಇದ್ರು.
ಅಫೆನ್ಸ್ ಏನು?
ಮನೆ ಬಿಟ್ಟು ಹೋಗಿದ್ರು.
ಅಫೆನ್ಸ್ ಏನ್ ಹೇಳಿ? ಅಲ್ಲಲ್ಲ, ನೀವು ದೇವ್ರ ಮನೆ ಬಿಡೋದಕ್ಕೆ ಗೌಂಡರ್ ಅಂತ ನನಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು. ನನಗೆ ಗೊತ್ತೇ ಇಲ್ಲ. You're a member belong to scheduled caste or scheduled tribe community. You see the biodata which you have given to me.
It's arranged marriage.
Yes, arranged marriage, my lord. I don't know whether I would have married her or not had she disclosed her real caste.
I'll secure the record.
The records.
Yes. Tomorrow, my lord.
Tomorrow.
Yes.
Yes. ನಾಳೆ fresh matters. Just tomorrow in the fresh matters list. Learned additional SPP to place, heard the learned senior counsel, C.V. Nagesh appearing for the petitioners. Learned additional SPP to secure the records and place it before the court tomorrow.
ನಾಳೆ ಒಂದು ಅಪೀಲ್ ಇದೆ ಅಲ್ಲಿ. ವಿನಯ್
After tomorrow.
ಅಲ್ಲ, let me see the records. I have heard you ಅಲ್ಲ. Let me see the records.
ಅಲ್ಲ, ಅಲ್ಲಿ ಒಂದು ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ತೀನಿ ಕೊಡ್ಬೋದು.
ಅಲ್ಲ, ನಾಳೆ.
ಅಲ್ಲ, ಎಲ್ಲ ಡಾಕ್ಟರ್ಸ್.
ಅಲ್ಲ, look into the records and do it.
Because
So many offenses are there.
Yes, my lord. ಈ FIR ಬಿಟ್ರೆ ಬೇರೆ ಏನೇನಿಲ್ಲ.
ಅಲ್ಲ, correct. So many offenses.
ಹೌದು, ಅದನ್ನ ಹೇಳ್ತಾರೆ.
Arms Act, NDPS, then attempt to murder.
ಅಲ್ಲ, ಇನ್ನೂ ಇದೆ. ಡೌರಿ ಪ್ರೊಹಿಬಿಷನ್ ಆಕ್ಟ್.
ಅದಿದೆ, that is foundational.
ಅದು ಫೌಂಡೇಶನ್. ಆಮೇಲೆ SC/ST ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್, ಆಮೇಲೆ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಸಿವಿಲ್ ರೈಟ್ಸ್ ಆಕ್ಟ್.
But if anybody looks into the complaint, it is so gory that it is impossible to even entertain the petition. Let me see the records.
ಅಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಏನೂ ಇಲ್ಲ other than the FIR.
ಇಲ್ಲಲ್ಲ, ನೀವು ಏನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿಲ್ವಾ? ಏನ್ ಕೊಡಿ ನೋಡ.
Whatever happened 10 days, my lord.
Yes.
ಇದು a plain look at the allegations made, my lord.
Allegations are gory, I told you.
Alwa, it looks like that.
Right, it is.
But a careful examination of the allegations made in the complaint, whether it would certainly.
How do you carefully examine at this stage?
No, a plain reading.
No, plain reading, yes, may not make out a few offenses,
So,
may make out a few
what the
offenses,
Supreme Court
but
has said.
en masse staying it, all the offenses without even looking at it, that's the.
As my lord is aware, what the Supreme Court has said is where it is not possible for the court to quash the entire first information report. Still, my lord, in relation to offenses where
No, that
the ingredients are found lacking.
ನಾನೇ ಬರ್ದಿದ್ದೀನಿ, where it is found lacking, definitely we will. Let me just see the records tomorrow. Yes.
ಅಲ್ಲ, ಅಲ್ಲಿ ತನಕನೂ ಇವರು ಡಾಕ್ಟರ್ಸ್ ಕ್ಲಿನಿಕ್
Don't precipitate till tomorrow.
ನಾಟ್ ಟು ಪ್ರಿಸಿಪಿಟೇಟ್ ಅಂತ ಏನಾದ್ರು ಒಂದು.
ಅಲ್ಲ, ಇವ್ರು ಹೇಳ್ತಾರೆ ಬಿಡಿ.
ಇಲ್ಲ ಅವ್ರದ್ದು.
ಅಲ್ಲ, Jagdish will instruct not to precipitate till tomorrow. When he says it, he will do it.
Certainly, my lord, I respect his words and your lordship would certainly.
Yes.
ಯಾತಕ್ಕೆ ನಾ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ, ಡಾಕ್ಟರ್ಗಳು ಎಲ್ಲಾನು ಲೇಡೀಸು, ಲೇಡಿ ಡಾಕ್ಟರ್.
Let's see.
And a complaint is after 1 year, after she left the matrimonial home.
No, you know the threshold bar of entertaining a petition under 482 and staying it or quashing it. So those parameters, I should draw it. Let me see the records. ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದ್ರೆ ಈಗಲೇ ಸ್ಟೇ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೆ. ಬಿಕಾಸ್ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಒಂದು ವಾರ ಆಗಿದೆ ಅಷ್ಟೇ. And so many offenses. Whether it is true or not, whatever it is, so many offenses. You're consuming marijuana, then alcohol, beating, ಏನೇನೋ ಇದೆ.
ಯಾವತ್ತದು ಅಂತಂದ್ರೆ ಮದುವೆ ದಿನವೇ. Who had gone and kept it there in the room?
Allegation is against the husband.
ಹೌದು, ಬಾಕಿಯವರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಇರ್ಲಿಲ್ಲ.
ಬಾಕಿಯವರು ನೋಡೋಣ, ಒಬ್ಬೊಬ್ಬರ ಮೇಲೆ ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ಸ್ ಇದೆ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 7 ಏನ್ ಮಾಡಿದ್ರು, ಅಕ್ಯೂಸ್ ನಂಬರ್ 4 threw hot coffee on the face. All that is there as accusations.
Well, the basic question is, after a lapse of 1 year after she left the matrimonial home, that too when the proceedings were pending before the matrimonial court, she goes and files a complaint.
Correct. Sometimes
that also needs to be taken into account.
We'll see. Sometimes women endure that settlement ಆಗ್ಬೋದು ಅಂತ. When the endurance level goes, when it is driven to the wall.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡೋದು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಇಂದ ರೆಫರ್ ಮಾಡೋದು ಅದನ್ನ ಕನ್ಸಿಲಿಯೇಷನ್ಗೆ. ಶಿ ರೆಫ್ಯೂಸ್ಡ್. ಅದು ಹಾಕಿದ್ದೀನಿ ನಾನು. ಶಿ ರೆಫ್ಯೂಸಸ್.
So delay in cases of 498A or these, sometimes, not in every case, this may be a different case, but in every case you can't paint it with the same brush that delay would, because
498 ತೊಂದ್ರೆ ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್
ಅಲ್ಲ ಅದೆಲ್ಲ ನೋಡೋಣ,
ರೇಟ್ಸ್ ಆಕ್ಟ್
ಕೆಲವು offenses ಎಲ್ಲ definitely we can do it, but endurance of a woman to set the family right will always be a continuing cause of action. When it becomes impossible, then complaint is
in the
registered.
instant case it is not so.
That's why I said, this case may be different, we'll see. Nale, tomorrow.
Management would communicate to
ಅದ್
the
ಮಾಡ್ತಾರ,
investigation.
nothing will happen.
Please.
Yes. Surgery ಏನ್ ಮಾಡ್ತಾ ಇಲ್ಲ ತಾನೆ. Yes.
27.
Petitioner sole accused, my lords. Concerned 316 clause 2 and 318 clause of PNS. Partnership firm, my lords, it was closure.
In the meantime, yes. Next.
28.
Page number 23 may kindly be perused. Legal notice was issued, my lord, on 28/10/2021. Lord, sale agreement executed. I produced it at page number 18. This
Who is the
was-
complainant?
Complainant is the buyer, my lord. Sorry, complainant is the buyer. Seller is accused number 1. A2 is an advocate. A3 nothing to do with that. A3 and A4, my lord, they purchased the same property after lapse of 4 years.
So having entered into an agreement with this lady, you have sold it to someone else.
My lord, that is sold by A1, my lord. A2 is A2 and A3 nothing
Now
to do with it.
who is 1 minute?
My lord, one is the seller, my lord.
1 minute. This Shaheen Shah.
She is the owner of the
Shaheen
property.
Shah, ಏನು ಇಲ್ಲಿ ಶಹೀನ್ ಶಾ ಅಂತ ಹಾಕಿದ್ದೀರಾ? Yes.
Yes, she is the owner of the property, my lord. Notice is issued by Shaheen Shah.
ಅದೇ.
On page number 23, under instruction from my client Shaheen Shah. My lord, the next page 24, my lord, with the notice, my client herewith informs you that the said sale agreement.
1 minute. Who are the witnesses to this? Where is the complete agreement?
Agreement
Where is the sale deed?
No sale deed was registered, only agreement.
A1 ಸೇಲ್ ಮಾಡಿದ್ರು ಅಂದ್ರಲ್ಲ ಆಮೇಲೆ.
ಅದು produce ಮಾಡಿ.
ಮಾಡಿ.
F4 and F5.
ಅದು
ಅದು
ಮಾಡಿ.
not, there is no allegation.
No, ಮಾಡಿ ಅದನ್ನ.
ಆಯ್ತು.
Who are these purchasers ಯಾರಿದ್ರಲ್ಲಿ?
Purchasers A3 and A4. A2 and A3. they
That's
are-
all right. A3 and A4 produce that sale deed which A3 and A4 has
Please, my lord.
purchased.
Meanwhile, the
No,
second.
meanwhile you produce it.
but-
When do you want? Friday or Monday?
Lord, tomorrow I'll produce. Second petitioner is an advocate. It's unable to go to the court.
Yeah, ಒಂದಿನ practice ಮಾಡಿದ್ರೆ ಏನು?
Nothing to do with
Tomorrow.
this.
List tomorrow.
Fresh matters.
Fresh matters. Produce that sale deed.
Please, my lord.
A2, what is the role of A2?
A2, my lord, he drafted the sale agreement, only that. And they say that he received rupees 1 lakh as per the complaint.
Yes. ಒಂದು ಕೆಲಸ ಮಾಡೋಣ. Learned additional SPP to secure the records and place it before the court. The learned counsel of the petitioner also to place the entire papers of the subsequent sale. Insofar as the accused number 2, the advocate is concerned, the allegation against him is only that he has drafted the agreement of sale or the sale deed as the case would be. This would not mean that the advocate would be drawn into the web of proceedings. Therefore, there shall be an interim order stay of further investigation only against accused number 2. Insofar as the others are concerned, it would be considered after after perusal of the records.
Monday, my lord.
Let him cooperate with investigation.
Advocate.
Advocate.
Ah,
But
yes,
in
he
case
will.
if they want to leave him, we will
If
leave him.
in the event the accused number 2 would be required for investigating the alleged the allegations square the other accused, he shall cooperate with it. Yes.
Please.
Stay there, but the only other accused.
Yeah, date may kindly.
Next 16th.
Please,
Sorry, 16th, Tuesday. Yes, next.
29.
498A, in-laws petition, husband is not before the court. Sisters husband. Petitioner number one, my lord, is the sister's husband. Petition number two, my lord, father-in-law aged 74 years. Petition number three, my lord, sister of the complainant, respondent number two.
Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
P6 is a complaint.
Complaining.
36 is a complaint.
The husband is not before the, ಅವರು anticipatory bail file ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Petitioner number one, my lord, is residing in Nelamangala. Incident is, my lord, is.
ಪರವಾಗಿಲ್ಲ. ಇದು come to page 14.
Please, my lord. Please, my lord. ದೂರಿನ ಸಾರಾಂಶವೆಂದರೆ ಫಿರ್ಯಾದಿಯವರು ಕಳೆದ 8 ವರ್ಷಗಳಿಂದ ನಾಗೇಂದ್ರ ದಟ್ ಇಸ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಅವರನ್ನು ವಿವಾಹ ಆಗಿ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಿದ್ದು ಫಿರ್ಯಾದಿಯವರು 7 ವರ್ಷದ ಗಂಡು ಮಗು ಇತ್ತು.
ನವನೀತ ಯಾರು?
ನವನೀತ ಸಿಸ್ಟರ್ ಆಫ್ ದ ಕಂಪ್ಲೇನೆಂಟ್. ಅವರು ಓನ್ ಸಿಸ್ಟರ್ ಮೇಲೆನೆ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಅವರು. ಅವರು
ಸಿಸ್ಟರ್
ಕಂಪ್ಲೇಂಟ್ ಸಿಸ್ಟರ್. ಇವರು ಇಂಡಸ್ಡ್ ಇನ್ ಸಮ್ ಎಕ್ಸ್ಟ್ರಾ ಮ್ಯಾರಿಟಲ್ ಆಕ್ಟಿವಿಟೀಸ್ ಅಡ್ವೈಸ್ ಮಾಡಕ್ ಬಂದ್ರು ಅವರು. ಅವರೆಲ್ಲ ಸೇರಿ
ಅಡ್ವೈಸ್ ಮಾಡಿದ್ರೆ ಸರಿ. ಮಿಕ್ಸರ್ ಜಾರ್ ತಗೊಂಡೆಲ್ಲ ಹೊಡೆದ್ರೆ
ಅವರೆಲ್ಲ ಹೊಡೆದಿತ್ತು.
ಇಲ್ಲ ಇದೆ ಅದೇ ಪೇಜ್ 14 ಅಲ್ಲಿ ನೋಡಿ ಇದ್ರಿ.
ಇಲ್ಲ ಅದನ್ನ ಅವರು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿಲ್ಲ. ಟೈಪ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್
and crime is registered
ಪೇಜ್ ನಂಬರ್ 20 ಅಲ್ಲಿ
will stay only against accused number 2
ಅಲ್ಲ
accused number 3 sorry
accused number 3 4 ಅವರ ಓನ್ ಸಿಸ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ ಸಿಸ್ಟರ್ ಏನೇ
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ ಅವ್ರು ನೋಡ್ಕೊಂತಾರೆ.
ಅವರು 3 years ಸ್ಮಾಲ್ ಚೈಲ್ಡ್ ಇಸ್ ದೇರ್ ಮೇಡ್. ಅವರು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವ್ರು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿಲ್ಲ. ಪೊಲೀಸರು ಪ್ರಾಪರ್ ಆಗಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಲಿಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 20 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿ 3 ದಿನ ಆಗಿದೆ.
ಹೌದು ಅದಕ್ಕೋಸ್ಕರ ಇಲ್ಲಿ
ಬೇಲ್ ತಗೊಳ್ಳಿ ಸರ್.
ಬೇಲ್ ಅಲ್ಲ ಅವರು ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಫೈಲ್ ಮಾಡಲಿಲ್ಲ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮಾತ್ರ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಎಸ್ ಒನ್ HCGP 2 emergent notice. There shall be an interim order of stay only insofar as accused number 3 petitioner number 2 is concerned.
ಅಲ್ಲ ಅವರು petition number 2 3 ಸ್ವಾಮಿ ಅವರು ಓನ್ ಸಿಸ್ಟರ್ ಇದ್ದಾರೆ ಅವರು.
ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್ there is direct allegation against 3 ದಿನ ಆಗಿದೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್.
ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್
secure bail.
petition number 1 ಮೇಲೆ ಇದೆ. I do understand.
No 1 and that 1 2 and that 3 yes
ಅಲ್ಲ 3 ಮೇಲೆ ಇಲ್ಲ.
3 ಅಲ್ಲ ಸ್ಟೇ ಮಾಡಿದ್ದು ಯಾರ್ದು 4 ಮೇಲೆ ಇದೆ. ಎಸ್ ನೆಕ್ಸ್ಟ್
30. But compensation I have dispersed. The aggrieved party, my lord, before this honorable court had filed a writ petition, where this honorable court held that he has no title. Page 37.
Complainant.
Complainant mele. He has no title.
Page
37 para 4 in judicial this honorable court. During course of these proceedings, shall I read?
No title.
37 para 4. During the course of these proceedings, this court pointedly asked the learned counsel for the petitioner as to whether there were any documents produced along with this writ petition to show the title of.
ಯಾರು ಲಕ್ಷ್ಮೀ ನಾರಾಯಣ ಅಂತ.
Lakshmi Narayan.
Complainant ರೂಪೇಶ್ ಕುಮಾರ್ ಮಗ.
Lakshmi Narayan represented by Rupesh Kumar.
The learned senior counsel Vivek Reddy appearing for the petitioner. The complainant's father was before the coordinate bench in writ petition 51194 of 2015. The specific question that the coordinate bench sought for is left unanswered, as the complainant's father did not have any documents to prove that he was the owner of the particular property. The property becomes the subject matter of acquisition, and the petitioner has secured compensation on the strength of him being the owner of the property.
Petitioner is the SLAO.
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 The disburses compensation in terms of law. The complaint therefore is instituted with malefides. Therefore, there shall be an interim order of stay of further investigation.
Please.
Sway the petitioner till the next date of hearing.
Please.
31. For the rest.
Passport. ಏನು?
Is an offense is my lord 279 and 304A. Engineer.
You are the driver.
I was driving. Yes.
ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕೀಗ?
UK man.
ಯಾಕೆ?
I am an engineer my lord. Aerodynamic is engineering. Because I work at Airbus.
ಗಾಡಿ ಹಂಗೆ ಓಡಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ?
For upskilling program my lord from July to October my lord I am supposed to attend my lord upskilling program.
Yes. Affidavit.
For the respondent.
Lord, I have already filed an IM.
Affidavit, itinerary.
Please.
Ella, where is it?
Itinerary I will file.
Itinerary, affidavit, reason why you are going. Ella
What reason I have stated in my IM?
Not stated. You give me that program. whatever.
Please,
Yes,
I request tomorrow, my lords,
tomorrow. File everything tomorrow.
in the fresh matters.
Yes, sir.
Please.
Next, same stage, next tomorrow.
Sorry, 32.
32.
For the petitioner.
7A?
DA, my lords.
Yeah,
13
Objections, Haki.
Yes, sir.
That's
Two-
covered by the latest judgment of N. Satish Babu.
Justice Krishna Kumar. Aayತು ನೋಡು. List the matter on 2nd July. Objections if any. 7th July, objections if any, by then by the respondents. ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. Yes. Next.
33.
Correspond DA case, my lords, ಇದರಲ್ಲೂ.
Huh?
This is an interim order, my lord. We've taken up some of the
Same day. Next.
Interim order needs to.
Continue.
13.
Same.
DA case.
It's 7th.
Please,
DA ಎಲ್ಲ 7th.
please, please. Wait.
34.
There were petitioner. They have served a copy through email and 11:45. They have not given copy, hard copy.
ರಾತ್ರಿನಾ?
ಈಗ
Objections, my lord.
They have not given. hard
Copy ಕೊಡಿ.
My lords, I have given.
Give it.
My lord, kindly have it, my lord. In this case, my lord, the court bench, my lord, Sunil ಸಾಹೇಬ್ರು ಅದ್ರಲ್ಲಿ ಮಾಡಿದ್ರೆ ಮೇನ್ ಟೈಮ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಇಟ್ಟು ನಾನು ಅದನ್ನ
ಆಯ್ತು ಕೊಡಿ, ಅದು ಯಾವ್ದು ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅದು.
ಅಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್
ಯಾವತ್ ಬೇಕು?
29 and 30 lords.
30th. ಆಯ್ತು 30th.
Please, lords.
Placed on 30th. Rejoined, ಇಲ್ಲ sorry, blip ಇದ್ದಾನೆ. Next.
Please.
35, copy given.
Coffee?
Copy given.
Coffee.
Please.
30 of the respondent, my lords. 35, my lords, 7A.
The small submission. Sorry to interrupt.
Coffee ಕೊಟ್ಟಿಲ್ವಾ?
Copy, my lords. The name of BB Patla has not been.
ಇಲ್ಲ ಇದೆ BV.
BV and the lords.
List the matter on 2nd July. The registry to print the name of BB Patil in place of BV Patil. Objections if any by the next date.
There is no interim order, my lords.
No interim order. 7L ಯಾವ್ದಿಲ್ಲ. Yes.
My lords, after 2 years after the incident, they have registered this crime.
We'll quash it, not a problem. But
And
ಒಂದು
you are
interim order
covered-
7L ಕೊಟ್ಟರು.
Covered by your lordship judgment itself.
Covered by Supreme Court ಈಗ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
From 2022, they have not even filed charge sheet all,
We'll see.
but they are taking, sir.
4 years in charge sheet ಹಾಕಿಲ್ವಾ?
They are
ಯಾಕ್
taking
sir?
coercive steps, sir.
Because I'll take instruction.
2022.
Charge sheet if not filed as on today shall not be filed without the leave of the court. 4 ವರ್ಷ ಯಾಕೆ? ACB ಮಾಡಿದ್ದಾ? Yes.
I'll secure the file and I'll.
ACB ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾ?
ಹೌದು.
Next.
36.
Please.
There's some bereavement in the family ಏನಲ್ಲ?
Yeah.
All okay?
Colleagues.
Colleague.
The report was placed, my lords, before your lordships.
Yeah, road rage.
We have
Oh,
not
yes.
had an
Spider-Man.
opportunity- We have not had an opportunity to inspect the report.
ರಿಪೋರ್ಟ್ ನನಗೆ ಕೊಟ್ಟು ವಾಪಸ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಇಲ್ಲದೆ ಇಲ್ಲ ಇಲ್ಲ. ಅಲ್ಲ ಮಟೀರಿಯಲ್. You want it? Investigation material, wait. But ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ.
One issue, my lord. There is a counter case also. Let them resolve it. Can be closed.
ಕೌಂಟರ್ ಕೇಸ್ ನೀವು ಹಾಕಿದ್ದೀರಾ?
Yes,
ಅವ್ರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
the case we went to the police station to register the case. And then later, my lords, on the instructions of some technicians, they dictated the terms of investigation.
307 ಹಾಕಿದ್ದೀರಾ?
Stretch-ಅಲ್ಲಿ video ಇದೆ. There is one stretch, my lord, because of the metro construction issues. The video, CCTV video is not there.
ಅದೇ it has sprung, it's now amplified and glorified because of that.
The only
But
thing
if you
is,
see the papers, there is nothing.
I've seen.
There's absolutely nothing against.
Only thing is, he should not have-
307 ಗಂತೂ ಇಲ್ವೇ ಇಲ್ಲ.
he should not
ಇವ್ರೇನ್
have,
ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿಲ್ಲ. ಬಂದ್ ಬಿದ್ದಿರೋದು.
like, he wanted to stop.
He had to stop.
Yes, should have stopped.
But you don't know the psyche, what happens when
Therefore,
someone falls like that.
let them close it, my lord, amicably.
Case, counter case close ಮಾಡಿ. Who's the complainant?
He himself said that even complainant is not interested in pursuing. Let them.
He was not interested in pursuing the case because this post went viral on social media, my lords.
Now let
They
them close
dictated the terms of investigation. Some technicians
ಆಯ್ತು, ಈಗ ಅವರೇ ಹೇಳ್ತಿದಾರಲ್ಲ, you just, I'll just issue notice, get the complainant, we'll
notice
close
is
it.
issued.
ಬಂದಿಲ್ವ ಅವರು? ಅಲ್ಲ ಯಾರು ಇದಾರಲ್ಲ ಇಲ್ಲಿ? ಕಾರ್ತಿಕ್ ಕುಮಾರ್ ಎಸ್ ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್, somebody is here. Registry to print, ಇದೆಯಲ್ಲ?
ಇದೆ. Karthik Kumar for R2.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ? ನಾಳೆ ತಗೊಳ್ಳ? ಇಲ್ಲ ಥರ್ಸ್ಡೇ ಸಾರಿ ಫ್ರೈಡೇ ತಗೊಂತೀನಿ. We'll take it on Friday. We'll close this issue.
I just want to highlight Manoj.
See, sometimes I'll tell you, social media, whatever transpires in it, sometimes it's a double-edged sword. Sometimes things that don't come into light at all will come out. Sometimes exaggerated versions come out like this. So we can't paint everything with the same brush and say it should be completely. It should be regulated. You can't. The police sometimes will not do anything. It's only because of certain reports that come up in social media or the electronic media. The investigation commences. Things have taken up. Things are taken up. You can't altogether, say it should be banned or these things should be
Not
done.
banned, Manoj.
It should be regulated. Yes.
The invocation of 109 Manoj damage.
Invocation of 109, yes, see, that's a FIR. FIR ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ತಾರೆ. ಕ್ರೈಮ್ ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ. ಈಗ ನಾಗೇಶ್ ಸರ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಕೇಸಲ್ಲಿ ಏನ್ ಕ್ರೈಮ್ ಎಲ್ಲ ಇರೋ ಬರೋ ಆಲ್ 7-8 enactments in a 498A case.
And
So that is how the crimes are registered.
how they created content, posted on their official handles.
We'll have to
Manoj.
respond. Somehow we'll have
No,
to respond to social media
when
also.
that comes about, the state cannot shut its ears and say, no, it's coming, leave it. So there is some incident. It is not that it is AI generated reel. It was real in the form of a reel. So they had to do it. If it is AI generated, they also will not bother. Because today a lot of AI generated reels are there.
Allah, now, I mean, they would make memes of us and post it on their official
Correct.
handles.
That you may, whatever legal action you should take, you can take. But that doesn't mean these incidents should not be brought to light or state should not take
I agree.
note of.
In fact, I
It
placed
is the electronic media, sir. Today, so many things are investigated into only because of that. Otherwise, crimes would have been closed.
In fact, I would take this opportunity to place on record my appreciation of the social media team of Bangalore City Police. Manoj. They do a fantastic job.
That is
but
why, yes.
that should not drive investigation.
No,
Manoj.
that is, see, those things, and you are here anyway. We'll see
Very good.
when you are before the court. But you can't say, just because something becomes viral, they cannot register. They can't shut their eyes.
Obliged.
And many of this road rage issues, my lord, is to an
Today,
extent.
every road rage issue is being projected only either in the electronic media or in the social media. Why is it not happened? They are not fake reels. Things have happened. That's why it is bringing it to the notice of the regulatory authorities. And the regulatory authorities, when it's brought to the notice, they can't say that, no, we will not even look into it because it is a reel.
I'm at your lordship.
That's what. AI adre, yes. Reels are AI generated too much these days.
Friday.
Reels that are real need to be seen, sir. Yes.
Well, let them also file a petition and then can be closed on.
We'll close it.
Ask the petition.
ಅಲ್ಲ ನೀವು ಹಾಕಿರೋ ಕೇಸ್ ಯಾವ್ದು?
ಅಲ್ಲಲ್ಲ ಅವ್ರಿಗೆ ಕೇಳಿ complaint
Counter complaint.
ಅಲ್ಲ ಕೌಂಟರ್ ಕಂಪ್ಲೇಂಟ್ ಕಾರ್ತಿಕ್ ಹೇಳ್ಬಿಟ್ಟು ಹಾಕ್ಸಿ ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಬಟ್ ಜಗದೀಶ್ ಸರ್ ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ. No, nothing is. No, what you have done is done. Investigation ಮಾಡಿದ್ದೀರಾ. You can't just keep quiet with that incident, but there's nothing.
We don't know what
But how did he come on your bonnet? Nobody knows.
No, he charged onto our car. Manoj.
All charged onto your car and come on the
aggressor.
bonnet. How?
He was.
ಅದಕ್ಕೆ ಏನು ಸ್ಪೈಡರ್ ಮ್ಯಾನ್ ಅದು. Yes.
He jumped on it and he was there, Manoj.
Huh?
He jumped on the bonnet.
Well, that's correct. Exactly. From where?
He followed him. He was supposed to take a ride somewhere else and then
All
he
right.
followed the.
Yes.
No, that what happened previous, that video is not available. Therefore,
That's the problem.
That's the problem.
Now, what is available is from the point where he is on the bonnet. What triggered him to go on the bonnet? ಎಲ್ಲೂ ಇಲ್ಲ.
That's because
ಆ
somebody else,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸಿಗಲ್ಲ. Complainant is not interested.
that's because somebody else shot that video and it's available.
In fact, it's a busy street, Manoj, Trinity Circle.
No, anyway, it has happened. You know, he was on your bonnet. It's not a fake video anyway.
And in all fairness, I agree, Manoj, I should have stopped the car.
Yes,
But
that's
how
the only thing you had to. No, even there, that was a danger. If he suddenly stops the car, he will fall down, and the wheels go on him. Then it will become a problem. Yeah, he has also tried to do something. We'll see. Yes.
Obliged.
Now get that. Our karkom money close man. Yes.
37.
The DA cases, my lords, previous order 4/6/2026. I in fact pointed out Satish Babu's case, my lords, the coordinate bench.
Oh, idu, this,
So I think
13.
previous order.
yes.
I'm ready.
Covered,
Covered by? Covered by Sudhakar Reddy.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ನೀವು?
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸುಧಾಕರ್ ರೆಡ್ಡಿ ಅಲ್ಲ ಸರ್.
Covered by Sudhakar Reddy.
Satish Babu's case, coordinate bench, the view that was taken on the previous occasion.
Have you not given a copy of?
Yes, I have it. So they're going back to Sudhakar Reddy.
Sudhakar Reddy
Sudhakar
ಅಲ್ಲ.
Reddy was considered, Chennakesha was
Yes.
considered.
ಜಸ್ಟಿಸ್ ಕೃಷ್ಣ ಕುಮಾರ್ ಅವ್ರದ್ದು ಲೆಟರ್ಸ್ ನೋಡಿಲ್ವಾ?
ನಾನೇ
We argued it for a number of days, Manoj, there.
Number of days.
ಅಲ್ಲ ಅವ್ರ number of days are total argument number of days. But anyway, my lord, we have filed SLP against this order. And I will also demonstrate how that order may not be applicable, my lord, to the facts of this case, and how Sudhakar Reddy is applicable, Chennakesha is applicable. I will demonstrate. I am ready.
Then we'll pass it over.
Please.
Ready ಇದೀರಾ?
ಹೌದು. I've done a small note to show how even this source report is lacking in details.
And I hear
That's the only point, my lords.
We'll take it at 4 o'clock.
Oblige.
ಫ್ರೀ ಇದಿರಲ್ಲ ಬಡ್ಡಿ ಸರ್?
Some.
ಫ್ರೀ ಇದ್ದೀರಾ ತಾನೇ?
ಅಲ್ಲ ಅಲ್ಲ.
Yes.
38.
Petitioner. The allegation is that, my lords, I was, my lords, cutting the tree, acacia tree, and my lords, taking it away. Lords, it is, my lords, exempted, my lords, under the state government order. Lords, when that being the case, my lords, the invocation, my lords, of
Forest Act.
Forest Act.
No, it's exempted. Now we didn't book it when he was cutting. We booked when he was transporting. It is exempted provided he shows us from where he has cut the trees. If it doesn't show, then it becomes a government property. Let him show where he from where he is.
ಎಲ್ಲಿ ಕಟ್ ಮಾಡಿದ್ರಿ?
Lords, from the private property, my lords.
Whose private property?
Lords, my private property.
ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲೇನಾ?
2022 in the ಇನ್ನೂ pending ಇದೆ. No investigation, no nothing.
No.
From 2022, my lords, it is pending.
ಇದು 2022 crime ಆ?
2022 crime.
Now the property
date,
has been
my lords.
attached. Property has been attached.
Property-
Order has been
4
passed.
ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಿದ್ದೀರಾ?
Allala, property has been attached and already the order has been passed.
Please, that is challenged before this court. Lords,
What has happened?
Lords, it is pending because, my lords, the coordinate bench, my lords, said that I have to give, my lords, bank guarantee insofar as the truck is concerned.
Appealable order, I don't know how coordinate bench because
Lords, appeal
75,
ಆಗಿ
71D.
dismiss ಆಗಿ revision dismiss ಆಗಿ I filed it.
Bank guarantee for the lorry ಆ?
Sorry.
Allala, not for the lorry. We are not a lorry. Your Lordship, you see the property which we seized is attached.
Madam.
By order dated 27/3/2026. Now this is an appealable order before Sessions Court.
That we are unaware, my lords, of 27/3/2026. Lords, let them, my lords, keep the acacia, but, my lords, the crime insofar as, my lords, the
No, if they show the place where they uprooted, we will close it.
2022, my lords, since 2022, they have not called, my lords, for investigation. Lords, the annexure C, my lords, is a notification.
Yes, Satish.
The notification, if you show, we have issued a notice, asked him to show from where he has uprooted, cut this tree. If he shows that.
Lords, 2022, now, my lords, from
Not
where I go
now,
and
then
show.
only. 2022, you should have showed. Subsequently, we have.
My lords, they have not
They
issued.
traveled all the way and seized the property and then
Let them
attached those
show, my lords,
properties.
what notice they have given to say, my
We'll
lords.
see. We'll take it on Monday, fresh matters.
Lords,
I'll see it.
Until then, interim order. my
Monday,
lords.
Monday. Yes.
39.
Yes, Ganesh.
I embarrass myself, Lord.
That's it. Yes.
Lord, dual FIRs, very same occurrence that took place way back in September 2024. 16 months later, another FIR is registered on the same set of facts. Investigation is already complete. My mobile is seized, my body is searched, the dustbin, so-called dustbin from which money is recovered has been seized. So practically investigation happens. I'm not named as a FIR accused. 16 months later, without any rhyme or reason, an FIR is registered against me.
Yes.
Lords, I have received the copy yesterday.
Hmm.
Lords, I have taken a preliminary instruction. Lords, to show the delay in FIR is only to get the consent of the state government because general consent was withdrawn.
All right.
Therefore, my lords, 2026.
No, he's saying two crimes.
My lords, there was a joint inspection raid which was done. From different officers, cash was seized.
Hmm.
Milords, to rope in into the same crime, Milords, there has to be some connivance. This is out of a raid which has happened, a joint surprise raid.
Offense under
7 and
711.
ಹೌದು. ಇನ್ನೊಂದು ಕನ್ಸೆಂಟ್ ವಾಸ್ ಅವೈಲಬಲ್ ಟು ದಮ್ ಆನ್ ದಟ್ ಡೇ 4 days later. ಹೌದು 21/9. This is 24.
We'll see.
2023 consent was
Get
withdrawn.
complete instructions.
Great.
Yes. We'll take it on Tuesday, fresh matters. Tuesday, Agatha?
Agatha.
Yes. List on Tuesday in the fresh matters list at the request of Rahul Reddy appearing for the CBI.
Great.
Tuesday. Yes. Interim order ಇದೆ.
Essential Commodity Act.
ಅದಕ್ಕೆ ಅವ್ರು interim order ಆದ್ಮೇಲೆ ಬರಲ್ಲ ಕೋರ್ಟ್ಗೆ.
Fertilizers Act ಎಲ್ಲ ಇದೆ.
List no representation on behalf of the petitioner. List the matter on 1st July in admission. But ಹಂಗೆ ಇರಲಿ. Yes, next.
41,
Same.
42,
Yes, Jagdish. Defreezing ನೆನ್ನೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೆ.
Password ಮೇಲೆ get it recorded.
Password.
Please.
43,
Ritvish.
I appear, my lord. Would your lordship permit?
13, huh? 13 or 7?
Sanction, my lord. The IPC offences. First sanction order was granted, co-accused quashed. Second sanction order for different offense. Let's page 110, my lord. I made a chart.
Tuesday, my lord, I'll
Last
sanction.
four times.
Washed by KT.
Coordinate bench. No, my lord.
Coordinate bench. Page?
Yes, my lord. Let the coordinate bench order is the last annexure, my lord. Page number K1, page 129. I'm sorry, my lord. Page 106.
106, sir.
106. I'm sorry. 106. No, my lord. When the matter was
No,
going
for
on,
want of sanction, it was quashed.
no, my lord. The offences alleged in the charge sheet is one. Sanction order is for another. And then cognizance is for
ಆಮೇಲೆ ಈಗ ಮತ್ತೆ sanction is appropriately taken?
ಇಲ್ಲ ಈಗ sanction ಅಲ್ಲೇ fresh order of sanction page 110 now 37 is included for which no charge sheet is there. Please come to page 110, my lord.
Yes, the chart is here.
Yes, my lord. The offences
ಇಲ್ಲ,
first
charge
70
sheet ಬೇರೆದಕ್ಕೆ sanction
37 ಗೆ.
ಫಸ್ಟ್ ಆಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಯಾಂಕ್ಷನ್ ಬೇರೆದಕ್ಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಬೇರೆ.
Page 105. Sanction order.
105.
Yes.
ಆಯ್ತು.
Apart from 102, that 105, my lord.
105 ಯಾವ್ದು 408, 409, 465, 477A.
Read the 34 of
ಅರೆ 34 ಆಯ್ತಾ?
Yes, lordship, it is page 71.
ಈಗ ಸ್ಯಾಂಕ್ಷನ್ ಇದು ಅಲ್ಲ ಅಫೆನ್ಸ್.
Offense.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Correct.
ಇಲ್ಲ
Yes, Prithvish.
34 and 37 is the difference, my lord. Charge sheet is for 37. Now, my lord, the impure fresh sanction order annexure G is for 34. My lord, 110 I have highlighted.
One
my lord,
ನಿಮಿಷ.
the-
1 minute, sir.
Yes.
PC Act is not invoked, of course.
Not invoked at all, my lord. Originally it was granted, not invoked at all.
ಅಲ್ಲ
No.
ಸ್ಯಾಂಕ್ಷನ್ ಯಾಕೆ ಬೇಕು?
That's no sanction by public servants ಅಂತ.
197.
197. My learned friend is wrong. Your lordship may see page 62, my lord. Page 62.
Yes.
Head of the charge sheet.
Yes.
ನಂತೆ ಹಾಕಿದೆ ಅಥವಾ ಕಾಲಂಗಳನ್ನು ಬದಲಾಯಿಸಲಾಗಿದೆ, ಕೈ ಬಿಡಲಾಗಿದೆ. ಕಾಲಂ
37 is given up.
ಬಿಟ್ಟು
Correct.
for IPS ಅನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ.
Yes, sir. Where are you?
My lord, if your lordship were to see 62, my lord. My lord, in 62 column 5, my lord. 408, 409, 465, 477A and 34, my lord. Now the sanction is for section 34. Cognizance is taken for 34. Charge sheet was filed for section 37, my lord.
Come to the charge sheet, sir. Page 62.
Page 62, page 71.
Please, my lord.
71.
Yes, my lord.
Look at the offences.
71.
Yes, sir. Column 17.
Yes, ma'am.
Mhm.
Yes, minutes. 408, 409, 465, 477A and 34.
Come to the sanction order, sir.
First sanction order, my lord, your
First
lordships
bit
will
pidi, sir.
see.
First is
Yes,
quashed
my lord.
already.
Now
You
on
come
the
to the
basis
second.
of that cognizance is taken, my lord.
On the basis of first order.
Yes, my lord. Annexure F.
Annexure?
F, page number 73.
37 ಇದೆ ಅದ್ರಲ್ಲಿ ಅಷ್ಟೇ.
Yes, my lord.
ಹಾ.
Now if charge
ಆಯ್ತು,
sheet is for 34.
will restrict the order of cognizance to the offences without 37 ಅಷ್ಟೇ.
My lord, what the coordinate bench did was, my lord, since the order of cognizance was without, quashed it and directed it to redo it, my lord, from the stage of cognizance. Page
ಆಯ್ತು.
number 100. That's all that I'm seeking, my lord. That's all. 106.
ಅಲ್ಲ, ಈ 37 ಇಲ್ವಲ್ಲ ಈಗ.
Please, my lord. Therefore, my lord, the cognizance when it was taken.
I will continue at 230.
Please.
Lord, may I make a one submission? In 47, say SFIO matter, I have been requested to appear in this matter.
ಯಾವ್ದಿದು?
47.
Petitioner Abhishek.
I will need just 1 or 2 days to get ready. Mala. I have been requested to appear. Friday afternoon,
My lord, I am basically on 4 or 5 important and serious legal issues.
which is why I
not
need
go-
some time.
ಹೌದು, ಅದಕ್ಕೆ let there be an interim order. If your lordship is persuaded to accept at least one of the legal submissions.
Then I'll hear it in the afternoon.
At 2:30.
ಅಲ್ಲ, ಅವ್ರು ಕೇಳ್ತೀನಿ, ನಿಮಗೆ ಕೊಡ್ತೀನಿ ಟೈಮ್ ಟು ರಿಪ್ಲೈ.
In fact,
I
the
will
matter
need
was moved before the vacation bench. The vacation bench was about to grant us the benefit of an interim order of stay.
Why did not grant?
Why? ಯಾತಕ್ಕೆ ಅಂದ್ರೆ
They sought time, saying that it was served on them that day. That is
That
how
day
the
ಬಹಳ
matter
ತೊಂದ್ರೆ
was-
ಅವಾಗಿಂದ ಇಲ್ಲಿವರೆಗೆ you did not get ready in the matter?
Unless we have filed objections.
Then
ಅಲ್ಲ,
what?
ನನಗೆ no. I want time. I mean, she may be ready. I have been requested to
Lord, I
appear in
shall
this
make
matter.
submissions, a
I
couple
got
of
the file
submissions
this
only
morning.
on legal
There are
issues.
several
Lord,
issues
the basic
involved,
legal
Lord.
issue which I am raising is this, my lord. Your lordship may recall to your lordship's memory when my
Before
lord
the
was
trial
sitting in
court, I
Dharwad
told it
bench.
is in 27 July.
When my lord was sitting in Dharwad bench, my lord, I invited my lord's kind attention. What is the procedure that is required to be followed on the basis of a client that has been filed? My lord, your lordship may recall to your lordship's memory that a full bench of the Allahabad High Court and thereafter a coordinate bench of this honorable court speaking through Justice Natarajan, my lord has said where cognizance has been taken subsequent to the new act coming into force, that is subsequent to 1/7/2024, the procedure that is required to be followed is one under BNSS and not under CRPC. Well, now the whole controversy has been set at rest by the Honorable Supreme Court in a judgment which came to be announced just about 10 days back. The date on which the cognizance is taken assumes all the
Paramjit Singh.
Yes, Paramjit Singh. ಅದರಿಂದ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ is ಒಂದೇ legal submission 223 ಪ್ರಕಾರ ಮಲಡ್ I should be given an opportunity even prior to the taking of cognizance.
That has to go back because
ಅಲ್ಲ, ಅದೊಂದೇ ಅಲ್ಲ ನನಗೆ any number
no, that is one factor. If you are on that, it has to go back
No,
for the
that is not
reason
the only factor.
that 175 under 223,
Yes, my lord.
the accused is required to give an opportunity. It applies even to PMLA proceedings, is what is said.
That is
there.
what, well, that is why I am.
It's completely covered by Apex Code.
Well, that is what, just about 10 days back, the judgment has
There is
come.
Paramjit Singh.
whole
If I am
controversy
right,
has been set
Paramjit
at
Singh.
rest.
Tane? Yes. Parminder Singh.
Well,
Some
well,
Singh.
that is not the only ground on which I am making my submissions. Company is not made a party. Only directors are made accused. That is the second legal issue. The third legal issue is provisions of CRPC are made applicable under 225. I am a resident of Delhi.
202.
202, old 202, present 225. ಇದೆಲ್ಲ ಬೇಕಾದಷ್ಟಿದೆ. ನಾನು ಸ್ಟೇಗ್ ಮಾತ್ರ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ, ಇನ್ನೇನು ಹೇಳ್ತಾ ಇಲ್ಲ ನಾನು. If my lord is pursued,
ಅದೇ ಪರ್ಮಿಂದರ್ ಅಲ್ವಾ?
Paragraph 37, my lord.
Justice Pardiwalar.
Yes, ಅಲ್ಲ
ಯಾರಿದು?
ಇವರು Sundaresh
Ah,
and
yes,
Honorable Justice Sundaresh and
The
26.
question was that
Yes.
whether 223 is applicable to PMLA proceedings also. There was a doubt. Supreme Court has stated it clear now that it is applicable.
I have not looked into what the legal, I will need.
All right, ಅಲ್ಲಿ
Idu,
ತನಕ
there
stay
are,
ಆಗ್ಲಿ.
there were two matters. Tomorrow I have posted it. There are other matters also on this very issue. So it's straight away covered.
If it is
And
taken up
ಜೊತೆಗೆ
day after, my lord, I'll get it
under
in.
212(1)(d), my lord, prior to investigation, there should be a sanction. ಇಲ್ಲಿ ನಮ್ಮ ಮೇಲೆ sanction ಏ ಇಲ್ಲ for investigation.
Or investigation?
Yes, my lord. Under the company, offense is under the Companies Act. Sanction ಏ ಇಲ್ಲ. Permission ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಮ ಮೇಲೆ investigate ಮಾಡಿ ಅಂತ. ಅಲ್ಲ, number of points are, legal issues are there. My lord, probably ultimately limitation also.
Limitation also is there. 166 is the offense, punishable
6
with
months.
6 months.
6 months.
After 4.5 years cognizance.
Cognizance system.
Cognizance ಯಾವ ಕಂಪ್ಲೇಂಟ್ ಯಾವಾಗ?
No, my lord, complaint also, we will point it out.
ಕಂಪ್ಲೇಂಟ್ ಡಿಲೇ ಇದ್ರೆ ಹೇಳಿ, ಕಾಗ್ನಿಸೆನ್ಸ್ ಯಾವಾಗ ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ.
Sarah Matthew, it gets covered under that.
Sarah Matthew doesn't speak of cognizance, it is date of the complaint.
Yes, my lord. Here it is.
Limitation is only qua the complaint.
Yes, my lord, here it is post that. It is post that.
Anyway, it involves a good number of legal issues which needs to be thrashed out by your lordship. Your lordship may kindly grant me the benefit of an interim order of stay, and then let him take his time and do it.
Madhyana I'll take it. No.
For me, I will need some time.
All right.
No problem. I will permit you. Friday ಮಾಡ್ತೀರಾ, Monday ಮಾಡ್ತೀರಾ, Tuesday ಮಾಡ್ತೀರಾ ಮಾಡಿ.
Monday, Tuesday, ಮಾಡಿ.
Again, what is the stage?
Process, cognizance.
Summons.
Summons.
Next date
They
is
are from
24th
Delhi, my
of
lord.
July.
All right, yes. We've, Madhyana, what is it? We'll see. Yes. Vacation lidmele, you should have got ready.
Yes. It is
You
not
should have
that today
briefed
we have
the,
filed or yesterday we have filed.
briefed the learned ASG earlier. If it was in the vacation and they wanted an interim order, you stalled it saying copy is served today.
Yes.
Vacation,
On the last date of vacation.
whatever, 12 days ago. Is it not 12 days ago?
Because I have filed.
They have filed their objections.
I have to brief, my lord. That's the-
I had, since yesterday, I was
To your lordships to grant me the benefit of an interim order and then grant the request.
We'll see.
But considering that the next date is 24th July, Lord, I would request that any grant of any interim order may be done after hearing me. I will need 1 or 2
Why?
days. Lord, there is no prejudice which will be caused till before the next date.
Well, if I am
It is
able to make
24th
out a
July.
prima facie, that is
July.
not the question to what
Nothing
date
is
it is
going to
posted.
happen
That is not the
before
issue.
24th July.
The issue is,
All that I'm seeking is 2 days' time, and my learned friend is already admitting that it involves serious questions of law. Let
Yes.
me get ready and assist your lordships in this.
quite right,
Right, we'll see. ಅದು ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತಾ
please.
So you put somebody.
Your Lordship, may I make one submission, my Lord? Serial number 24 in the second list, Your Lordship, I agenda it on 17th. There is some difficulty, Your Lordship, one of my colleagues is getting engaged. May I request it for 18th, my Lord, because I have informed senior counsel.
ಏನ್
Mr.
ಮ್ಯಾಟ್ರ್ ಅದು? 17th.
Oh, yes, Your Lordship. Serial number 24, my
You're for
Lord.
the respondent, right?
I am for the respondent.
ಹಾ.
So I have informed the other side, Your Lordship, some difficulty.
From the
because
other
one of-
side, ಯಾವತ್ ಬೇಕು?
Hey, could it be taken up on 18th, my Lord, subject to Your Lordship convenient, my Lord?
18th. ಅದಾ? All right.
Because my colleague is getting engaged, that's the reason.
All right. 18th, ಅವ್ರಿಗೆ ಹೇಳಿದಿರಲ್ಲ?
I informed, my Lord.
I will, you have.
I informed Mr.
All right, yes.
Grateful, my Lord.
All right. Tomorrow, 10:30.
My lord, list number 2, my lord, serial number 58 and 61, my lord. I have filed memo for retirement.
Thank you.
So
Yes.
kindly adjourn the case for.
Don't, when it is called, we'll do it. Memo for retirement gain urgency, 2:30. Yes. The urgency ಏನಿದೆ 127. 127 urgency ಇದೆಯಾ? Expunging. ಏನ್ DPC ಇದೆಯಾ?
Initiated the process. Based on that, on that remark, my lord, made by the trial court.
I'll take it at 4 o'clock.
Please, ma'am.
127 first list ತಾನೆ? Second list ಅಷ್ಟೊಂದು ಇದೆಯಾ? ಇಲ್ಲ ನಾಳೆ ಹಾಕೋಣ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಸೆಸ್ಮೆಂಟ್ ಅದೇ ಎಲ್ಲಿ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ. Yes, Pratish.
Sanction, can I just clarify this one?
Let's.
The FIR was for 408, 409, 465, 477 and 37, page 40, my lords.
Yes, sir.
Charge sheet, my lords, is filed for section 37, page 63, my lords. My lords,
Cognizance is taken for 37?
no, my lords. Cognizance is for 34.
Yes.
Sanction.
No, 1 minute. Sanction was for 37.
No, my lords. The first sanction, my lords, was for 34. 201, 409, 465. There was no sanction for 408 at all.
All right.
Trial court takes cognizance for 408 and
that is quashed.
Insofar as co-accused is concerned. Now, my lords, insofar as this person is concerned, my lords, there is no order. During the pendency of proceedings of the co-accused before this court, without withdrawing the earlier sanction, they would pass a fresh sanction order. First section, sanction is granted.
What became of that sanction order?
Now, my lords, that is before your lordships.
What is Justice Suresh Govindrat's order?
The first sanction order against the
By
first
the other accused.
Qua the other accused.
Yes.
First sanction order and cognizance qua the first.
So that sanction goes, it goes.
Yes.
Now a fresh sanction is taken.
Yes, Manoj.
For what?
For section 34, 465.
Correct.
Now charge sheet is filed for section 37. There is no charge sheet for 34 at all.
We will restrict, we will take away 37 and 30, whatever sanction is not taken.
Yes, but cognizance is taken for section 34.
We'll restrict the cognizance to that.
Very
We'll
well.
take away that, that's all.
Very well.
ಮತ್ತೆ ಅದನ್ನ set aside ಮಾಡಿ ಕಳಿಸಿ ವಾಪಸ್ ಅದೇನೇ ಬೇಡ.
So very well. So, but the cognizance was taken pursuant to the first sanction order.
No, now the first sanction order goes qua the co-accused.
Yes, Manoj.
You have not challenged it. The sanction.
I have challenged it here, Manoj.
You have challenged it here. I know.
Yes.
Sanction is that order itself is gone.
Yes.
It was a common sanction or an individual sanction order?
Individual sanction.
Then your order will remain.
Yes.
All right. Now we have challenged that here.
Yes.
By then the second sanction order has come.
Yes, Manoj.
Second sanction order gives sanction for 34.
Yes, Manoj.
While the cognizance is taken for 37.
34, Manoj.
34 correct ಆಗಿದೆ ಮತ್ತೇನು?
ಅಲ್ಲ, charge sheet is for 37.
Charge sheet is also 34.
Manoj, charge sheet.
Sir, come to the charge sheet, sir.
Yes, Manoj. Would your lordship?
What is all this?
Yes, Manoj. Would your lordship just come to
page 71, sir.
64, Manoj, for a moment.
71 ಬನ್ನಿ.
ಅಲ್ಲ, ಅಲ್ಲಿ 64 in 63 and 64. 63 ಅಪರಾಧಿ ಸಂಖ್ಯೆ 2 ನಾಗಭೂಷಣ್ 63 ಅಪರಾಧಿ ಸಂಖ್ಯೆ 2 ನಾಗಭೂಷಣ್ HP 64 ಅಲ್ಲೇ.
ಸರ್ ನೀವು ಅದೆಲ್ಲ ಬಿಡಿ. Come to page 62 head of the charge sheet.
Yes, Manoj.
ಕಾಲಮ್ ನಂತೆ ಹಾಕಿದ ಅಥವಾ ಕಾಯ್ದೆ ಕಾಲಮ್ ಆಯ್ದೆ ಬದಲಾಯಿಸಲಾಗಿದೆ, ಕೈ ಬಿಡಲಾಗಿದೆ. 37 ಕೈ ಬಿಟ್ಟು 34 ಅನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಅಗೇನ್ಸ್ಟ್ ಆಲ್. It's a common intention, sir.
My lord, we are public servants, therefore 37 is invoked. All of us are public servants.
I to 37 is given up now.
Very well.
34 is there.
Yes, my lord. Your
Yes.
lordship may restrict.
Sanction is under 197.
Yes, my lord.
Yes.
Your lordship may restrict it only insofar as that.
ಅದು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ ಕರೆಕ್ಟ್
ಇಲ್ಲ,
ಇದೆ ಎಲ್ಲ.
ಇಲ್ಲ, column 5 at page 62, my lord, in my opinion. That is for 34 ಅಂತ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಸರ್ 37 ಬಿಟ್ಟು 34 ಅನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಹೌದಾ?
Yes, my lord. But the cognizance order was pursuant to the first sanction order.
Correct.
Therefore, I leave.
Where is the order of cognizance?
Order of cognizance, my lord, is at page number 80. Page 80.
Bail order, cognizance order.
This is
ಯಾವ್ದಕ್ಕೆ
19/3/25
cognizance ಯಾವ್ದಕ್ಕೆ?
for 34 minutes.
34 is the
As on the date
Correct
of,
ಆಗಿದೆ.
as on the date of that cognizance order, there
37 was the charge.
no, my lord, 408 sanction was not given.
Oh, that's all. Now it is given.
408 is in the new sanction order.
Now it is given.
Yes, my lord. Therefore,
Again
my lord,
ಮತ್ತೆ cognizance ತಗೊಳಕ್ ಹೇಳ್ಬೇಕಾ?
ಅಷ್ಟೇ ಈಗ ಎಲ್ರಿಗೂ ಅದೇ ಆಗಿದೆ, ಇಬ್ರುದು ಅಲ್ಲೇ ಹೋಗಿ ಅವರು ಒಟ್ಟಿಗೆ ಆಗತ್ತೆ ಅಷ್ಟೇ.
ಏನ್ ಬೇಕಾಗಿಲ್ಲ. We'll just clarify we'll clarify that sanction is now accorded to all the offences.
Yes, my lord.
Yes, 408 was not there then, now sanction is accorded.
Yes, my lord.
Accordingly it will be tried. What is the technical, hyper technical?
Let's info, but we are also, my lord, exonerated in departmental I'll on technical ground.
26. 26, SSC online SC, page 26, yes.
At other grounds, my lord, I cannot touch right now.
ಬೇರೆ ಗ್ರೌಂಡ್ಸ್ ಎಲ್ಲ ಅಲ್ಲಿ ಮಾಡಿ. If something doesn't happen there, you can come later.
Very well. I'll file for application for discharge.
That's the best thing you can do. Now that the cognizance order is in consonance with the sanction order,
Yes.
better you file discharge. If they don't, you can come.
Very well. I'll do that.
Yes, then we will not answer anything.
Please.
Madam, discharge format haki. Petitioner is at liberty to urge all the contentions, including the contentions that are advanced in the case at hand. It is needless to observe that the concerned court, while answering the application for discharge, would answer all those contentions that are advanced.
Please. I'll do that.
Liberty is reserved to the petitioner to knock at the doors of this court at at a later point in time.
Please.
Please, my lord. Step in.
40.
44, please, my lord. Sorry, this is the Tahsildar, my lord. The FIR is registered for the Prevention of Corruption Act, my lord, so section 13. On the allegation that, my lord, certain Sagoli chits, my lords, they have been set up, they have been bogus Sagoli chits have been set up. And therefore, she is arraigned as the accused. What emanates is this, my lords. Initially, my lord, she was the petitioner, was the Tahsildar of Tharikere, my lords. Then she was transferred. After transfer, it was found, my lord, certain persons have set up fake Sagoli chits. And the Tahsildar concerned reported, my lord, these are all fake documents. They are required to be, I was not the Tahsildar at that time. It has to be cancelled. Then a notice came to this petitioner, what do you say? And the petitioner sought the information, my lord, regarding issuance of the Sagoli. There is no Sagoli chit. Then it's found, my lord, the Sagoli register, my lord, certain interpolations are there in the Sagoli register. So she said, my lords, this requires inquiry as to who has interpreted it in the office. I was never there. I was already transferred in 23. That interpolation requires inquiry, my lords. And there was no, these persons who are the grantees, my lords, they failed to produce any original documents. Originals are not there. And they produced certain Xerox copies when the forest officials went to their lands. And those documents are fake documents. We ourselves it's fake documents. Now, my lord, what happened is the FIR, my lord, they registered the FIR showing me as the accused. Absolutely no allegation against me. I have not done anything and no allegation that I have done, my lord. They have set up the documents. My lord, the grievance is...
FIR agidya.
FIR agidya. Grievance is about the FIR, my lords. FIR is at page 133. They registered for Prevention of Corruption Act, section 13, 1A, read with 13.2 and 409, 420.
Criminal misconduct.
Yes, no. This document, they're saying that the signature was forged one. The Sagoli cheat was issued at his term. And those documents, the Sagoli cheats, her term. Lord, the Sagwali cheat was issued were for the fictitious persons who are not in possession of the property.
ಸಾಗುವಳಿ ಚೀಟ್ ಯಾರು ಇಶ್ಯೂ ಮಾಡಿದ್ದು?
This Tahsildar only.
All right.
She is now denying the signature.
Ah.
Matter of investigation, the preliminary stage, my lord.
What was it? Instead, what was the date of issuance of the ಸಾಗುವಳಿ ಚೀಟ್?
Sagwali cheat, my lord, after taking charge. That is on, my lord,
Date ಕೇಳಿದ್ರೆ
12/10/2022.
12/10.
2022. One of the Sagwali cheat, my lord.
How many ಸಾಗುವಳಿ cheats?
5 Sagwali cheats are issued. And she was taken charge as a Tahsildar on 29/6/2022.
29/6/2022. She was there up to what date?
31/7/2023.
31/7/2023.
Yes.
When did you come to know that it was forged or?
Now, Lord, the Lokayukta has prepared a preliminary report on the saying that is on the publication of article in the newspaper about the creation of all these Sagwali fake fictitious Sagwali seats in favor of the persons who are not in possession. On the public grievance, Lord, it's credible information. We are source report was reported, and we obtained a 17-year order. Now the investigation is under progress. There was one more FIR was registered by the forest department about the encroachment of forest lands. Even these lands were under forest department, and that case also is under investigation. Here there is an specific and serious allegation against the petitioner about the creation of Sagwali cheat.
Well, issuance of ಸಾಗುವಳಿ cheat.
Yes, bro. She is now denying the signature.
Now denying her signature, saying it is forged.
Yes.
May I submit, my lord?
Yes, sir.
The allegation itself is, my lord, the facts emanate like this. On 22/10/2024, my lords, forest officials visit certain properties. And these are the forest lands, why you are encroached it. And those persons alleged to have given some Xerox copies, my lords,
Of ಸಾಗುವಳಿ cheat.
Saguli cheat,
All
which
right.
are non-existent. I beg to submit, my lords, non-existent document they show to the forest officials. And there is no Saguli cheat issued at all. We have not issued any Saguli cheat. Tahsildar has not issued. These persons created certain Xerox copies and showed it and kept mum. On this basis, my lord, the publications are made. Now, my lord, during this extent commission issued notice, we have said we are not issued. And the records also revealed no Saguli cheat is issued, my lord. No Saguli cheat.
Furthermore, the documents.
Where are the records revealing that no ಸಾಗುವಳಿ cheat was issued?
Not the application. We secured the records.
Where is the records?
ನಾವೇ ಹೇಳಿದ್ವಿ ಇಶ್ಯೂ ಇಲ್ಲ ಅಂತ Saguli cheat.
ನೀವ್ ಹೇಳ್ಕೊಂತೀರಾ ಇಲ್ಲ ಅಂತ?
Even, my lord, even your lords may kindly see the Tahsildar, the current Tahsildar himself reported, my lord.
Where is
kindly see page number 118. Please, my lord.
We secure the records saying that the applicants are totally different, and the name of these the beneficiaries were added in the middle of the ledger entries, and they are not at all in possession of those properties. More than 20 acres of land has been.
Page 112, please. 112, please.
20 acres where?
Tarikere. Please, 112, my lords. Notice issued to me, my lords. First para is the notice issued to this petitioner, my lord, 8/11/2024. ಅದನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಗಂಡಂತೆ ವರದಿ ಸಲ್ಲಿಸಿದ್ದೇನೆ. ವಲಯಾರಣ್ಯಕ ತರೀಕೆರೆ ವಲಯ ಸೋ ಅಂಡ್ ಸೋ ಎಂದು ಬರೆದ ಪತ್ರದಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಎಕ್ಸೆಟ್ರಾ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಮೈ ಲಾರ್ಡ್ಸ್, ಎಕ್ಸೆಟ್ರಾ, ಅದು ಅದರ ಬಗ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. ಅಂಡ್ ದೆನ್ ಐ ಸೇಡ್, ಮೈ ಲಾರ್ಡ್ಸ್, ದಿಸ್ ಈಸ್ ಆಲ್ ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂಡ್ ಐ ಹ್ಯಾವ್ ನೆವರ್ ಇಶ್ಯೂಡ್ ಎನಿ ಸಾಗುವಳಿ ರಿಜಿಸ್ಟರ್. ಅದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಸಾಗುವಳಿ ಚೀಟಿ ಇಲ್ಲ. Now, my lord, if there is any Saguli cheat issued, my lords, I am liable. Your lords may kindly appreciate, my lords. No Saguli cheat is there, my lords. No Saguli cheat has been issued. They set up certain documents, and then, my lord, FIR should have been registered against them, my lords.
We will investigate. We will send the signature for the FSL. We will ascertain that.
My lords, they can very well do. Kindly see, my lord, making the petitioner as the accused. Instead of the persons who set up the documents, who show the documents, they are not added as accused.
ಇನ್ನು FIR, sir.
FIR ಅಲ್ಲಿ they make me as the accused.
ಪರವಾಗಿಲ್ಲ, you are the starting point.
No, my lords, your lords may
ಆಮೇಲೆ ಆಡ್ ಮಾಡ್ತಾರೆ ಯಾರನ್ನ ಬೇಕಾದ್ರೆ.
The issuance of
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ they will add.
My lord, prima facie I have to submit if they are able to show even now, my lords, that if there is some Saguli cheat issued by this petitioner.
Sure, they will investigate.
Every Saguli cheat with the signature is only the petitioner has signed.
No, my lord,
now they are disputing that signature.
Let them show some document which is signed by her, my lord. There's nothing, no document.
Investigate ಮಾಡ್ತಾರೆ ಬಿಡಿ.
No, there is no such document, no such Saguli cheat
you
issued.
may say
No, my lord, even other, my lord, no inquiry was held. What we did was, my lords, I issued the reply, my lords. And they found the register, Sagoli chit whether issued or not. In the office, there is no Sagoli chit issued, my lord.
ಅದು ತೆಗ್ದ್ಬಿಟ್ಟಿದಾರಾ?
Sagoli chit, it is no issued, no issuance. Sagoli chit has never been issued from the office. Kindly appreciate the two. One is where Sagoli chit has actually been issued, my lords. And where Tahsil has committed an offense. When no Sagoli chit is issued, some persons, my lord, set up Xerox copies and say it is a Sagoli chit.
Mainly see the signature sheet, the affidavit.
And
the
Xerox
Sagoli.
copies. What they do is Xerox copies. Some Xerox copies are set up by third parties, my lords. Now those third parties also, we ourselves said in the explanation, we have not issued any Sagoli chit. Xerox copies should be inquired into. We ourselves said, my lords. Now showing us as the accused, without there being any prima facie material and subjecting the petitioner, my lords, a public servant to the criminal prosecution based only on this, my lords. She has not signed any document. She has not issued any document. I do consider this, my lord. If she has signed a document, she is liable. She has not issued any document. When third party set up the documents, fake document, my lord. She is arraigned as the accused. Your last KDC, only FIR is now against her.
Will pass there.
Not against
A petitioner, working in the cadre of Tahsildar in the government, is before the court calling in question registration of a crime in crime number 2 of 2026.
One sentence.
Heard the
Kindly pardon me, my lord. Your lordship asked one question I could not answer at that time. Page 84 it is there, my lord. Kindly see.
84 is the?
Page 84, my lord. The report of the present Tahsildar, my lords. Page 84, please, my lords. 24/10/2024, submitted to the Assistant Commission. Kindly see, my lord. By the present who was in charge at this present, my lords. Presently. Manyare, Tarikere Taluk so and so, or Raddu Padu Magge. And then, my lord, kindly see, my lord, last paragraph.
ಖುದ್ದು ಚೀಟಿ ನೀಡಿ ಸ್ಥಳ ಪ್ರದೇಶವನ್ನು ಪರಿಶೀಲಿಸಿದ್ದು ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಕಾಡು ಮರಗಳಿದ್ದು ಯಾವುದೇ ಸಾಗು ಮಾಡಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದರಿ ಪ್ರವೇಶವನ್ನು ನಕಲಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ಸಾಗುವಳಿ ಪಡೆದಿರುವುದು ಸ್ವಯಂ ಪ್ರೇರಿತ ಪ್ರಕರಣ ತೆಗೆದುಕೊಂಡು ಲಿಂಗಹಳ್ಳಿ ಹೋಬಳಿ ಸೋಣ್ಸು.
Last paragraph that may read, my lords.
ಇಲ್ಲ ಅಂತ ಇಲ್ವಲ್ಲ.
ಲಿಂಗದಳ್ಳಿ ಹೋಬಳಿ ನಂದಿ ಗ್ರಾಮದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 161 ವಿಸ್ತೀರ್ಣ 3 ಎಕರೆ ಪ್ರದೇಶ ಶ್ರೀಮತಿ ಲತಾ ಸೋ ಅಂಡ್ ಸೋ ಕಚೇರಿಯಲ್ಲಿ ಕ್ವೆಶ್ಚನ್, ಮೈ ಲಾರ್ಡ್ಸ್,
ರದ್ದುಪಡಿಸುವಂತೆ ಕೋರಿದೆ.
ಅದರಿಂದ ಪೇಜ್ 84 ಲಾಸ್ಟ್ ಪ್ಯಾರಾ, ಮೈ ಲಾರ್ಡ್ಸ್. 84 ಪ್ಲೀಸ್, ಮೈ ಲಾರ್ಡ್. ಲಾಸ್ಟ್
ಆದ್ದರಿಂದ ಅದಲ್ಲೇ ಓದಿದ್ ನಾನು.
ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್
ಖುದ್ದು ಭೇಟಿ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್
ಅಲ್ಲಲ್ಲ, ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್, ಮೈ ಲಾರ್ಡ್ಸ್. ಲಿಂಗದಲ್ಲಿ ಹೋಬಳಿ ಸೋ ಅಂಡ್ ಸೋ ಶ್ರೀಮತಿ ಲತಾ ಸೋ ಅಂಡ್ ಚೀಟಿ ನೀಡುವ ಸಂಬಂಧ ಕಚೇರಿಯಲ್ಲಿ ಸಾಗುವಳಿ ರಿಜಿಸ್ಟರ್ ವಹಿಯನ್ನು ಪರಿಶೀಲಿಸಿದ್ದು ಯಾವುದೇ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. No Sagoli chit was issued, my lord. Now third party set up documents.
ಈಗ ಸಾಗುವಳಿ ಚಿಟ್ ಎಲ್ಲಿದೆ?
They have produced it.
Page
54. And second Sagoli chit at 64.
ಸಾಗುವಳಿ ಚಿಟ್ 1.
This is a Xerox copy, my lords, which they have set up and given to the forest officials.
ಆಮೇಲೆ
this is the copy, my lords. Third parties, my lord, when forest officials went to the spot and questioned on what basis you are in possession, they give this Xerox copy. And there's
investigate,
my lords, and no objection for investigation. Only prayer is, my lords, directly arraigning me as the accused, my lords.
Bail ತಗೊಂಡಿಲ್ವಾ?
We have obtained subsequently now anticipate bail is obtained, my lords. But my lords, your lords may kindly see the effect on the public servant, my lord. The third party set up this document that the office registers show, my lord, there is no such Sagoli chit issued, my lord.
Why is this? Please, Tahsildar given this report like this?
No, my lord, the name of this, my lord, the applicant is, husband name is totally different from this Shivappa's original application. I verified that.
They set up fake documents, my lords. This person set up fake documents.
Yes. Will pass.
And
so. Crime number 2 of 2026 for offences punishable under section 13(1)(a) of read with 13(2) of the Prevention of Corruption Act. Heard the learned senior counsel P.P. Hegde appearing for the petitioner, counsel B. Latif representing the Lokayukta, the learned additional SPP for the state. The petitioner at the relevant point in time was functioning as the ex officio secretary of the Bagair Hukum Committee of Tarikere Taluk from and after joining the said office as Tahsildar, after joining the office of the Tahsildar on 29/6/2022 and worked up to 31/7/2023. The entire fulcrum of the crime revolves between these dates. It transpires that certain persons had encroached forest land. The forest officials are said to have investigated into the said matter, upon which certain Saguvali chits are produced before the forest officials by those persons who had allegedly encroached the forest land. This becomes the genesis of the problem. The forest officials then write to the state with the documents or the Sagoli chits that were produced to them to verify and take necessary action. This becomes, after a preliminary inquiry, the crime comes to be registered. Preliminary inquiry, an approval comes to be granted under section 17A against the petitioner for registration of the crime. It then becomes the impugned crime in crime number 2 of 2026 for the aforesaid offences. Registration of the crime is what has driven the petitioner to this court in the subject petition. The learned senior counsel would vehemently contend that the petitioner had not issued any Sagavali chit during her tenure, and therefore those Sagavali chits that were produced at the time when the forest officials inquired or investigated to the possession of those persons who were holding the Sagavali chit was forged. The Sagavali chits have been set up by those persons again on the signature of the petitioner. He would take this court through a particular document of the income of the Tahsildar who succeeded the petitioner to demonstrate that the Tahsildar himself has indicated that there is no Sagavali chit issued from the office of the Tahsildar. Therefore, on this circumstance, the learned senior counsel submits that the petitioner, being at no fault, must not be permitted to undergo the rigmarole of the procedure under the criminal justice system. The learned counsel B. Latif, appearing for the Lokaayukta, would, however, refute the submission, contending that the plea set up by the petitioner is that those persons who are holding the Sagwali chit have forged the signatures of the petitioner. This becomes a matter of evidence. No doubt the petitioner is now drawn as accused in the case at hand. The matter is still at the stage of investigation. Other accused may be drawn in at the time of filing of the charge sheet. He would submit that this court must not interdict or obliterate the crime against the petitioner for the reason that it has the hues and forms of corruption. The learned additional SPP would also toe the lines of the learned counsel appearing for the petitioner, appearing for the Lokaayukta, and contending that all the allegations are looked into by the state, and then only an approval under section 17A has been granted by the state. Therefore, there is no warrant of interference at this stage. I have given my source, therefore narrated source. The issue lies in a narrow compass. The period with which the issue is concerned is between 29/6/2022 and 31/7/2023, when the petitioner was working as Tahsildar Kadur Taluk. Kadur alla?
Tarikere
Tarikere Taluk. Tahsildar Tarikere Taluk. Being the Tahsildar of Tarikere Taluk, she was also the ex officio secretary of the Bagair Hukum Committee. Bagair Hukum Committee, chairman of which is the sitting member of the Legislative Assembly, and there are 3 other nominated members. The issue crops up after the petitioner exits from the post of Tahsildar of Tarikere Taluk, where certain lands belonging to 5 persons are allegedly issued Sagoli chits, and those lands were belonging to the Forest Department. The Forest Department has a separate claim over those lands and have initiated proceedings against those persons who were holding the Sagoli chits, and the present proceedings against the petitioner. The period of functioning of the petitioner between the said dates is not in dispute. The Sagoli chits being issued on 12/10/2022 and afterwards is not in dispute. Therefore, the Sagoli chits 5 in number in the case at hand have been issued during the tenure of the petitioner. The allegation is that the applicants were different. The Sagoli chits are issued to different persons and who have now become the alleged encroachers of a forest land. All because of the Sagoli chits so issued by the ex officio secretary of the Bagair Hukum Committee hyphen the petitioner. These are allegations. The learned senior counsel for the petitioner would project that the petitioner's signature has been forged and the Sagoli chits have been set up by those persons who are encroaching the forest land. Therefore, the issue of who has forged whose signature cannot be deciphered in a proceeding under section 482 of the CRPC. It is the evidence in the least is must be investigation in the least must take place in the case at hand as the period in which the Sagoli chits are issued is when the petitioner was functioning as Tahsildar, and the signatures of the petitioner are found on the Sagoli chits, whether it is forged photocopy, the original of which is available or not, the Tahsildar's endorsement that no Sagoli chit was issued in favor of those applicants found in the said communication, all of which are in the maze of disputed questions of fact. If it is a maze of disputed questions of fact, it would amaze this court to interfere under section 482 of the CRPC. The allegation against the petitioner, who was the ex officio secretary of the Bagair Hukum Committee, is she has acted Bagair Kanun. Yes, dismissed. Great. Please.
Appearing for the petitioner, my lord, the crime number 182 of 2025 is arriving out of the sumoto complaint filed by a superior police inspector against a police personnel, petitioner number 1, only when he tried to pacify the situation. This happened on 24/8 August 2025, where around 8:30 p.m. the police got some information regarding the liquor being sold without authorization license. Then they intervened and they checked. It was the petition number 2 is the owner of the Appu Fish Tawa Fry restaurant, who was Tawa Fry, my lord. It is a fish stall where he sells fish.
Tawa
fry style.
You should have made something else, masala fry.
So he
Yes.
was just selling the food, and the police inspectors came inside, lathi charged the customers who were having food. Later on, started throwing the food down, all the cooked food to the streets, and abused the petitioner number 2. Later on, petitioner number 1, who is the brother of the petitioner number 2, a police constable, he arrived and intervened, pacified the situation, saying that we have the food license and the liquor is not being sold by us, and because there is an adjacent Mahalakshmi bar next to the food shop.
Mahalakshmi Bara.
Please, my lord. Later on, after this, the police inspector, the respondent number 2, got triggered as the police intervened, and he filed an FIR against petition number 1 and 2. Later on, the next day, 25/8/2025, they were produced before the magistrate, and the magistrate saw that there was lack of sufficient grounds for their custodial detention and set them free. Later,
That's
immediately after that, they filed complaints in front of Commissioner of
ಈಗ
Police.
ಏನ್ ಗಲಾಟೆ ಮಾಡಿದ್ರ ಇವರು?
He has, in fact, my lord, the fact that the Tawa and fish are together before your lordship
Correct.
speaks volumes.
Appu fish tawa fry.
Yes, both speaks volumes about their conduct. Not only this, my lord, I have been told that he is also hand in glove with an NDPS cases in the past and other things.
My
I
lord,
have filed a charge. Let him file for discharge, my lord. If he
a
has
submission is that CCTV footage is there. We have captured the picture and we have attested in the
Come
complaint
to
saying
page
that
43, madam.
my lord, the CCTV footage is still now not secured, and the body cam footages are also not secured.
ಅಲ್ಲ ಅಲ್ಲಿ
My lord, my lord, they were asking for monetary perks which the petitioner did not oblige.
Oh,
That is the
ಯಾರು
reason.
police ಆ?
Sir, police
Please,
constable.
my lord.
ಏನ್
Respondent
ಕೇಳ್ತಾ
number
ಇದ್ರು?
2,
ಏನ್ ಕೇಳಿದ್ರು?
they were asking that.
Tawa fry?
No, my lord, because just it was right next to the adjacent of a bar. They were supplying food. They created a story saying that they're selling liquor also. If according to their
ಅಲ್ಲ
complaint, my
ಅದಕ್ಕೆ
lord,
ಮಾಡಿರ್ತಾರೆ ತೊಂದ್ರೆ ಇಲ್ಲ. ಹಂಗಂತ ನೀವು ಇದೆಲ್ಲ ಮಾಡ್ಬೇಕು ಅಂತಿಲ್ಲ.
submission, my lord, complaint, my lord, page number 50, if it is seen, ಈ ಘಟನೆಯನ್ನು ಅಕ್ಕಪಕ್ಕದ ಸಾರ್ವಜನಿಕರು ನೋಡಿದ್ದು ಅದರಿಂದ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳಿಗೆ ಸಿಬ್ಬಂದಿಯಂತೆ ಆತ್ಮಸ್ಥೈರ್ಯವನ್ನು ಕುಗ್ಗಿಸುತ್ತದೆ. ಅದರಿಂದ ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಮದ್ಯಪಾನ ಮಾಡಲು ಅನುವು ಮಾಡಿಕೊಟ್ಟಿದ್ದಲ್ಲದೆ ಅದನ್ನು ಪ್ರಶ್ನಿಸಿದ ನನಗೆ ಹಾಗೂ ನನ್ನ ಸಿಬ್ಬಂದಿ ಅವಾಚ್ಯ ತಪ್ಪುಗಳು. So that if it is so, if the liquor license is not there, let them go file a complaint before the statutory authority under the Excise Act.
Correct.
No need to file a false complaint against the
ಅಲ್ವಾ?
petitioner, my lord.
కదా?
Page 208, my lord, that inquiry report, Assistant Commissioner.
208?
8, my lord. He not only thereafter he tried to create an evidence to show that first para itself, my lord, page 208, internal page 5, Antima Abhipraya.
But where has he stopped the public servant
No,
from
he did.
performing?
What happened, my lord, that there are smokers, alcohol being served, and the police went there to detect and put a penalty on them and other
Fish
things.
ಜೊತೆ ಆಲ್ಕೋಹಾಲ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಎಲ್ಲ and that's the police, being a police officer, he is an hand in glove with the.
Who is police officer? Petitioner?
Petitioner number 1, he is accused. He was a constable in
police
Chamarajpet
constable.
police station.
And petition number 2 is the
He is
entire.
the brother of the petitioner number 1, man.
ಓ ನೀವೇ ಸೆಟಪ್ ಮಾಡಿರೋದ ಅಪ್ಪು?
ಅವರೇ.
Brother is carrying out the
Brother is carrying out that tawa fry.
He is leading the business, my lord. He is an uneducated person who has
That's all right, but
he knows good cooking skills. That's the reason they have helped him to lead his life. That is the main.
you are A1 is
police.
A2 is the brother.
Yes.
ಅಂತ ಹೇಳ್ತಾರೆ, but ತಂದೆ ಹೆಸರು ಬೇರೆ ಇದೆ.
Cousin.
My lord, if the charge sheet had seen the witnesses or other police officials, not a single person who have witnessed the incident. The CCTV is the main substantial evidence which is not secured. What was the lack to secure it, my lord? We have sent the photos saying that there are CCTV footages. That is still now not secured.
Right. File with this allegation, I will not interfere. Discharge.
My lord.
You can't support your brother and do everything.
My lord, he was never in the picture, my lord. The brother called saying that the disturbance is happening. Kindly come and help me. That is the reason he has come here. The brother is nowhere connected to this. He has helped his brother to lead his life. This is nothing, not a setup or anything.
There are 164 statements.
No. Page 43, I will not interfere. You being a policeman can't behave like this. Yes.
My lord, they have not done anything.
Discharge
My lord, they have
akkodi.
thrown the food to the street, my lord. The cooked food, everything was thrown and they have hit them. The police have in fact assaulted
ಇಲ್ಲ
them.
ಅವರು ಮಾಡಿರ್ತಾರೆ ಇಲ್ಲ ಅಂತಲ್ಲ.
My lord, they are innocent, my lord.
ಅವರು ಮಾಡಿರ್ತಾರೆ ಎಲ್ಲ
Brothers alva.
brothers.
Police brothers.
File discharge. Yes. Discharge format. Next.
For the petitioner, the accused and the victim have done the registered marriage, and
I asked you where is
issue
the
is regarding the date of the birth. and
date of
furnishing
birth,
the
correct.
victim's Aadhaar card only, my lord.
Aadhaar card. Where is the school records?
My lords, like the school records.
Aadhaar card date of birth edit ಮಾಡಬಹುದು ಕೊಡಿ. Where is the school? Where are the school records?
My lords, the school record, it is not prepared on any of the source.
You
identification
produce your
documents.
school records, the victim's school records. You are married now?
Yes, my lord.
You are
I am married.
now
I
registered.
don't have
Now
access.
this is a serious consequence. Now because of this, a marriage is registered of a girl who is 17 years, 10 months.
No, my lord, she has issued Aadhaar card to me, my lord.
Aadhaar card.
So
She
that
has
Aadhaar card,
given it.
If my learned friend says that if Aadhaar card was uploaded on the date of registration, I would have understood. They didn't. They goes to the doctor, get a certificate saying that she's 18 years. That document has been uploaded based on that measure, registration has been
No,
done.
my lord.
And she is 17 years, 10 months. Because of this, a marriage, so the registrar has registered the marriage of a minor.
My lords, he has registered solely upon the Aadhaar card, my lords. My lords,
Where are the school records? Give it, sir.
plus, it is
Where-
not there in the charge sheet, my lords.
What's the problem in you? Now, we are not answering it on merits. I have closed it or granted stay on the ground that both of you are married.
Yes, my lords.
And you said as on the date of marriage, she's beyond 18.
Yes.
Fact is that as on the date of marriage, she is 17 years and 10 months.
That's that Aadhaar card is,
ಅದಕ್ಕೆ ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ.
that's, I don't have,
Yeah,
access-
that she does.
investigation authorities
She's your
should-
wife, sir. She doesn't have the school records.
They are not together, my lords, like,
Not
she's
ಆಗ್ಲೇ
with her
ಬಿಟ್ಬಿಟ್ರಾ?
dad, she's with her.
You left her already.
Father. They're not staying together, my lords. The victim, like father, it is not letting us to stay together.
Then
He has
when
separated
where
the
did you get
couples.
married?
My lords,
When did you get married? Where did you get married?
plus I and her got married, like married, my lords. Then the victims, like father, like subsequent to the date of the arrest, the couple got separated, and they're not residing in the same house as of now. The
This is why
girl is staying with
we
the
should
father.
not grant stay on marriage, close on marriage. Marriage ಪೋಕ್ಸೋ ಹೋಯ್ತು ಅಂದ ತಕ್ಷಣ ಅಲ್ಲಿ leave the girl.
My lords, no, my lords, then why I will do the registration of the marriage, my lords? If I don't want to stay
this
with
is-
her, then why I went
Where is the,
all the way to register the marriage?
Page 109, school
ಅಲ್ಲ
certificate.
ಅದು ನೋಡಿದೆ. Who is the complainant here?
My lords, not even a
You
single
secure the
identity.
presence of this man.
I am for the complaint.
Yes, sir. Why have you taken away the daughter?
I am not. He is deserted.
My lords, I have done the registration of the marriage, my lords, then why?
Then let the crime continue.
My
Let the
lords,
POCSO proceedings continue.
Yes, I'm missing one citation.
No citation,
My
sir.
lords,
This is unique
the
case.
Aadhaar card, my lords.
ಯಾವ ಆಧಾರದ ಮೇಲೆ ಮಾಡಲ್ಲ ಈಗ.
My lords,
You have deserted the lady after having closed it for the offenses under the POCSO. I closed it on the ground that both of you are getting married. Well, you produce a registration certificate which is again faulty,
CS
and you have deserted her.
kind see the like victim statement, my lord, victim statement.
ಈಗ ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಮಾತ್ರ ಕೊಟ್ಟಿರೋದಲ್ಲ.
My lords, kindly see like for a moment, like see the like victim statement, my lords.
ಈಗ if they are going to be together, you are ready.
Look, if they have no issue, but the father is here. Lordship inquire from him. ಅವರೇ ಹೇಳ್ತಾರೆ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಅವ್ರ
Plus,
ಜೊತೆಗೆ ಇಟ್ಕೊಳ್ತಾ ಇಲ್ಲ ಅವ್ರನ್ನ.
Instruction I will take, my lord. I will see that.
I will revive
instructions.
all the POCSO cases that are against you now.
No, my lords, like it may be.
This is why I add a rider that in the event the boy would leave the girl in the lurch, POCSO will revive one. ಎಲ್ಲ ಕೇಸ್ ಕ್ಲೋಸ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು ಬಿಟ್ಬಿಡೋದು.
I have
Nothing,
went all
yes.
the way to like just register my marriage, my lord, and she's 18 years and above. Plus, like for a moment, either like
No
victim
problem.
statement, my lords. Just like victim statement. It's
Why
not-
why did you desert her?
my lords,
Why?
I don't have the instructions regarding why it is.
I'll vacate the interim
Just
order.
it will, like
Take him back to custody.
taken up tomorrow, my lords. My lords, it will like taken up tomorrow, my lords.
Because
I'll
even
just
he
seek
was in custody, I released him because of this marriage. Now take him back to
my
custody.
lords, just tomorrow, like tomorrow, my
Yes.
lord.
I'll
just
take
seek
it tomorrow.
instructions. Yes, my lords. Yes.
But get ready to go back. Yes. ಯಾವಾಗ್ಲೇ ಹೇಳಿದ್ದ?
Probably at this point of time, I think it would be suffice for me to invite my lord's kind attention to the order.
Razor pay.
Razor pay.
Razor pay the petitioners, huh?
ಇಲ್ಲ
Directors.
ಕಂಪನಿ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ, ಅಕ್ಯೂಡೇ ಅಲ್ಲ ಅವರು.
What's PMLA proceedings, huh?
ಅಲ್ಲಲ್ಲ, ಕಂಪನೀಸ್ ಆಕ್ಟ್. ಕಂಪನೀಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಅಫೆನ್ಸ್ ಹಾಕಿ ಕಂಪನಿನೇ ಪಾರ್ಟಿ ಮಾಡದೇ ಇದ್ರೆ ನಾವೇನು? Lord, may I just request your lordship to kindly go to the order of cognizance. ಅದು ಫೌಂಡೇಶನಲ್ ಆಸ್ಪೆಕ್ಟ್ ಇಂದಾನೆ ತಪ್ಪು. 371 ಫಸ್ಟ್.
Again, cognizance is taken, huh?
By the registrar.
Page.
371. ಕೆಲವು few legal issues I will submit to your lordship without troubling your lordship on the minutes of the matter. ಇದು ಇಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ 371 ಇಂದ.
ನೋ ಬಟ್ ಅವ್ರೇನು 2 ದಿನ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲಿ ತನಕನೂ why
ಅಲ್ಲ
should this
24th ಅಂತಲ್ಲ ನೆಕ್ಸ್ಟ್.
ಅಲ್ಲ why should this Damocles sword of the process ordered against me should be there?
Sword has become dormant.
ಅದಲ್ಲ ನಾನು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು, if my lord is persuaded to accept my submission that prima facie I have made out a case, your lordship may grant me the interim order.
No, let him finish. ಅವರು ಬರ್ಲಿ.
ಅಲ್ಲ ಬರ್ಲಿ, ಅದಕ್ಕಲ್ಲ. Kindly have a look at this, my lord. The order itself. She
He's
can't
asking
pass.
for a day's time ಅಷ್ಟೇ. Thursday, Friday. Friday fresh matters ಎಲ್ಲ ಹಾಕೊಂತ.
ಅಲ್ಲಿ ತನಕ ಒಂದು ಇಂಟರ್ವ್ಯೂ ಮಾಡಿರ್ಲಿ, ಇಷ್ಟೇ ನಾ ಹೇಳೋದು ಇಷ್ಟೇ. Whether is it justified, my lord, in passing an order under section 223 without issuing a notice? ಅಷ್ಟು ಸದ್ಯಕ್ಕೆ ಅದೊಂದೇ ಸಾಕು. ಲಿಮಿಟೇಷನ್, ಆಮೇಲೆ ಸ್ಯಾಂಕ್ಷನ್ ಇಲ್ಲ, ಅದೆಲ್ಲ ಆಮೇಲೆ ನಿಧಾನವಾಗಿ ನೋಡಿ.
ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ಟು ವಾಪಸ್ಸೇ ಕಳ್ಸೋಣ.
ಅಲ್ಲ ವಾಪಸ್ ಆಗೋಲ್ಲ, ಪೂರ್ತಿ ಹೋಗ್ಲೇಬೇಕಿದು. ಯಾತಕ್ಕೆ ಅಂತಂದ್ರೆ ಕಂಪನಿನೇ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ದಿ ಅಲಿಗೇಷನ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಕಂಪನಿ.
All that you have judgments and everything for that.
ಎಲ್ಲ ಇದೆ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
In fact, the investigation only could not have gone on.
Well,
without an order by the central government, the serious fraud, they don't get power, my lords. Now, the order which is granted is to investigate 33 companies.
Not us.
pay their pay.
Or its directors.
Yes, my lords. Despite that, now when they give their inspection report, they include us. Without an order, you can't even investigate. 212 is very clear to that.
We'll hear it whole hog on Friday. At 2:30, I will post it on Friday. No time will be granted.
And more than one legal issue is involved here.
Yeah, correct. All
and
those.
ಜೊತೆಗೆ 514 ನಲ್ಲಿ it is barred by time. ಫೈನು ಅಫೆನ್ಸ್ಗೆ, ಈ ಅಫೆನ್ಸ್ಗೆ ಫೈನು 166.
Why all this? Anyway, he won't be able to answer. Yes, Friday ತಗೊಂತೆ. Friday heard ಎಲ್ಲ senior councils ಹಾಕಿ madam. Friday fresh matters list.
Sada Matthews will point out, well, so offenses 2019 and 2020.
You
reporting in 2022. We don't have to go to
Reporting ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್.
Reporting a problem. Complaint is delayed. Cognizance is not a problem.
ಅಷ್ಟೇ.
The complaint itself is delayed.
If complaint is barred by limitation, it is over.
ಅಷ್ಟೇ.
That's what we'll point that out, fellows. 2019, 2020 is the offense. 2022 comes the initiation. For an offense which is
And the offense that is
fine.
compliant against me is under 166 of the Companies Act. Only sentence is fine.
And that's also compoundable. So they don't.
Then why at all these proceedings?
Really don't know, well, so many legal aspects are there.
And 212 1D ನಲ್ಲಿ the central government has to authorize for.
All that. Then we'll hear it whole hog. Not send it back on 175.
ಬೇಡ. Yes. If it is barred by time, my lord, the court.
If it is quashable, we'll quash.
Yes, the court should not have taken cognizance of the offense at all.
We'll see. Yes.
Provided your lordship would agree with us that it is barred by time.
That will. There's many legal issues ಅಂತ ಹೇಳಿದ್ರೆ.
Legal issues are there. And company is not made a party. Umpteen number of judgments of your lordship and also of the Supreme Court, commencing from Sunil Bharti Mittal.
One other aspect
And
intermediary methods.
I am an intermediary.
79 of the
I have provided my platform for this creditor and debtor.
Razor pay.
Razor pay. ಅಲ್ಲ ಒಂದು
3-4 razor pay ಬರ್ದಿದ್ದೀನಿ ನಾವು.
ಹೌದು.
ಇಲ್ಲ ಶುಕ್ರವಾರ ಮಾಡ್ಬಿಡ್ತೀನಿ. We'll take it on Friday. And it's not, next date is on 24th July ಅಂತ ಪರವಾಗಿಲ್ಲ.
ಇದು ಏನಾಯ್ತು ಅಂತಂದ್ರೆ ಮೊನ್ನೆ ಇತ್ತು 86 ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಇವತ್ತು ಬಂದಿರೋದು ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ.
ಮೊನ್ನೆ ಹೇಳ್ತಾ ಇರೋದು 86 ಗೆ ಇತ್ತು ಮೊನ್ನೆ ದಿನ. It did not reach on.
ನನ್ ಮುಂದೆ ಇತ್ತಾ?
ನಮ್ಮ ಮುಂದೆನೇ ಇದ್ದಿತ್ತು.
Oh, sorry.
It did not reach on that day. And then we made a motion and your lordship directed the registry to dish the matter today.
All right. Yes. Friday in the fresh matters list. Heard senior councils ಹಾಕಿ. ಅಲ್ಲಿ SG ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಮಾಡಿ. ಅರವಿಂದ್ ಕಾಮತ್.
Apply.
Yes. But give a note on the legal issues. Yes. Whatever it is. Yes.
In fact, Sunal Bhai case nalli, my lord has passed an order that in view of the protection that is given to an intermediary under section 69 of the information, 79 of the Information Technology Act, he can't be prosecuted at all. It's the law which my lord has laid down.
ಅದಕ್ಕೆ ಅದೆಲ್ಲ ಇದೆ.
Kunal Bhai.
Yes. That Kunal, yes.
Yes, madam. I wouldn't be.
Yes. Yes. ಶಾರ್ಟ್ ನೋಟಾ? 48 ಅಲ್ಲ? 40 ಅವತ್ತೇ ಕೊಡಿ.
My lordship, respondent has not been served with the notice and also the copy of the WT.
Petition in this case, my lordship.
Not with the copy of the WP also, my lordship.
Daughter-in-law
As there
file-
was a pending matter in.
Last
pending
time
bail
also you
matter.
appeared and made the same submission.
No, my lordship.
A1
Yesterday I
gets-
filed
A1
the
gets
wakalat,
stay, my
my
lordship.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಎನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದು my lordship.
A1 gets stay, my lordship. Daughter-in-law filed FIR against my lordship.
ಏನ್ offense ಏನ್?
SC/ST invoked, my lordship.
Atrocities Act.
Yes, my lordship. My lordship, since the time of the marriage, it's been 8 years. till
Marriage
today. Madhve agide, my lordship. Husband is staying with the respondent itself, but since the time of marriage, she is not allowed inside the house of the in-laws of the petitioners.
On the ground that you are a scheduled caste.
Yeah, keeping the caste intact. So I would
ಏನ್
submit-
ಎಲ್ಲದ್ರಲ್ಲೂ ಅದೇ ಅದ್ರಲ್ಲೂ ಇದೆ? ನೀವು ಹೊಸ
I'd file the
trend.
detailed objections, my lordship. Kindly give a short.
We will have to read between 3-1 R&S to include this also.
Kindly peruse page number 30, my lordship. She only clearly state, my lordship.
ಹ್ಮ್.
ಇರುವ ಸಂದರ್ಭದಲ್ಲಿ ವಿವಾಹ ಸಂದರ್ಭದಲ್ಲಿ ನನ್ನ ಗಂಡನ ಮನೆಗೆ ಹೋದಾಗ ಕೆಲವು ನನ್ನ ಅತ್ತೆ ಮಾವ ನನ್ನನ್ನು ಮಾತನಾಡಿಸುತ್ತಿದ್ದರು ಹಾಗೂ ನನ್ನ ಅಕ್ಕನಾದ ಕೃಪಾ ಕಿರಣ್ ಮತ್ತು ಅವಳ ಗಂಡನಾದ ಕಿರಣ್ ಬಗ್ಗೆ ಹಾಗೂ ಅವರ ಮಗಳಾದ ಸಾಕ್ಷಿರವರುಗಳು ನಮ್ಮ ವಿವಾಹ ಆಗಿರುವುದು ಇಷ್ಟ ಇರಲಿದೆ ಎಂದು ತನ್ನನ್ನು
ಆಯ್ತು, ಇದ್ರ ಕಂಪ್ಲೇಂಟ್ ಇರ್ಲಿ, ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಅವಳು ಸರ್, my lordship.
ನಾಟ್ ಟು ಅರೆಸ್ಟ್ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
ಆಗಿದೆ ಅದಕ್ಕೆ. ನಾಟ್ ಟು ಅರೆಸ್ಟ್.
ಹೌದು.
A1
coercive.
gets not arrest.
ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
No,
No, my lordship, it is not.
No coercive steps ಅಂತ ಹೇಳಿದೆ. But if what she is telling is the allegation,
I'll file the objections, my lordship.
is serve a copy.
Yes, my lordship.
The petitioner to serve a complete set of papers upon the counsel appearing for the second respondent. The learned counsel for the second respondent seeks 2 weeks' time to file statement of objections. List the matter on 30th in the fresh 30th for admission. Objections, if any, by then.
Not to precipitate.
Huh?
Not to precipitate.
Allah, the interim protection granted on 4/6/2026 shall continue till the next date of hearing.
Sublime, my lordship.
Look, summons issued to rice vendors in West Bengal without a predicate offense. There appears to be certain crimes registered as against Malad, who I supplied the rice to. And Malad, he appears to be a fraud. Because I've also done my research to find out, Malad, there are multiple FIRs registered against this particular entity, which I've also produced 2 bail orders, at least what I got the information from, Malad. Now, my only grievance is this, Malad. They issue a summons to me. I have supplied rice insofar as one particular company is concerned, PWIP Food Tech. That, Malad, is a fraudulent company, is what I can at least decipher from what is there on record. Now, the difficulty which I expressed is, Malad, one is to say, yes, there's no predicate offense. Second is, Malad, I am disabled. So I have a permanent disability. My lords also on the previous occasion had said that if they are willing to give whatever documents are there, let there be no coercive or persuasive action taken.
There are predicate offences, otherwise we will not reach the ECR.
Predicate offense ಇದೆಯಾ?
The point
ಇಲ್ದೇನೆ
is-
ECR ಮಾಡಲ್ಲ.
ಅಲ್ಲ ನಮ್ಮ ಮೇಲೆ ಅಂತ ನಾನು ಕೇಳಿದ್ದೆ.
The only thing what I would suggest or submit my lords is.
No, because of his medical condition.
My lords, petitioner number 2 can come. He is also the partner. And
Petition
then-
number 2 ಯಾರು ಇಬ್ರಿದಾರ ಇಲ್ಲಿ?
This is his
Alok
brother,
Kumar.
my lord, but he's a sleeping partner, my lord. He has
No, whatever it
I
is.
will send, my lord, I will send his son itself because he's the one he's the one who's conducting the entire.
They have accepted in page number 46 in the email that we will come on a separate date, another date.
ಸರಿ, ಆಮೇಲೆ
Let them come, at least let
ಏನ್
him come.
ಚಾಲೆಂಜ್ ಮಾಡೋದು ಅಷ್ಟೇನಾ? ಫಸ್ಟ್ petitioner I will
May I just send the
exempt.
I will just show the email, my lord, which I had sent out. I said whatever documents are
Send
required.
your security.
ಅಲ್ಲ security ಅಲ್ಲ, my lord.
ಮತ್ತೆ
It's the son who's running
ಏನ್ ಬೇಡ,
my lord,
ಹೋಗಿ
they send it.
ಬಿಟ್ರೆ ನೀವು ಸೆಕ್ಯೂರಿಟಿನೂ
May I
ಕಳಿಸ್ಬಿಡ್ತೀರಾ?
just make one submission, my lord. What they say is that they send it to a proprietorship. I clarify saying it's a partnership firm. I have nothing
Yes,
to
yes,
hide.
cooperate with the investigation. The first petitioners, because of his paraplegia,
As far as second petitioner is concerned, there's no difficulty. Only thing is, he may not be able to assist them in any manner because that's the issue. I may have a grievance against PWP myself because he's not paid me my money. Now, as far as the son,
Ilder, I will ask both the petitioners to appear.
I'm only
Yes.
saying, the nephew, because his petition number 2 son will come because he has all the documents, he has all the information. If that is because if they are only seeking for the information,
ಒಂದ್
let them-
ಸರ್ತಿ ನೀವು ಹೋಗಿ ಆಮೇಲೆ ಬೇಡ
No,
ಅಂತ
my lord,
go once with your son, then whatever is to be done, you do it and come.
please, if that not.
First
Please,
petitioner will exempt.
Nanige, because it's only documents they are asking for.
First
As far
petitioner
as-
I will exempt.
Agreed, madam. But just one more submission, madam. There is no predicate offense as against me. As against PWIP, it is there, not against me.
Company it is there.
Nan ಮೇಲೆ ಅಂತೂ ಇಲ್ಲ.
It is the firm, this firm against it is there.
ಯಾರು ಮುಕ್ತ ಕೇಶಿ ಮೇಲೆನಾ?
That is the case, my lords. I will produce the ECIR. and also the FIR.
Because
Without that, my lords, we don't
But
even register that.
Muktakesh email anto there is no FIR registered because there is.
Without that, we don't even register the ECI.
It may be
He
against
is
me.
making a statement that against your firm also there is the predicate offense.
Manoj, that is not something which I know of because 2024 ECIR, 2026 ಅಲ್ಲಿ summons ಬಂದಿದೆ ನನಗೆ.
My lords, this issue is with regard to the summons. My only submission is, my lords, let respondent petition number 2 along with the documentation come and we can dispose of the petition, my lords. A date may be granted by this court so that day it may be given. That is what he has written in page number.
We'll dispose the petition with a direction.
Please, my lords, please.
My lord, I would only request my lords to keep it pending only for this reason that first yes I will go and cooperate.
ಏನ್ ಯಾರು ಅರೆಸ್ಟ್ ಮಾಡಲ್ಲ ಸರ್
Because
ನಿಮ್ಮನ್ನ.
what happens here, my lord, if my lords were to recall in the grandmother case also same thing, they will make me sit from morning till about 4:30.
No, if they don't tell me how
That
to
is how
make
ED
them sit.
works.
They
They will
don't
make
tell
me
me how to
sit
make
from
them sit.
morning. That is a problem.
We'll make them sit
I
5
cannot
days.
say, don't make them
I
sit, don't
understand,
make
my
them
lord.
stand.
My lord, I understand, my lord, as far as
Reasonable
their,
demands.
what happens, my lord, in the morning they call us, they make us sit till about 4:35.
If they
Call
don't
us
give,
and
my
then
lords,
that,
we have
my
to
lord,
make them sit.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ?
my lord, I'm only saying let the petition be
Targeted
pending.
time ಅಲ್ಲಿ ಕರಿಬೇಕಾ?
Let the petition be pending, my lord. My lords may also see, because if there's anything, if they produce
For
anything,
what
my lord,
fruitful purpose?
Infructuous.
my lord, if there is anything, if there is no ECI as against me, if there's no predicate offense, my lord, this summons can be quashed.
Let them amend the petition in such a case.
If there is anything, let them produce proof. Now, as of now, my lords may give me protection.
I think
I will
first
go there.
ನೀವು ಹೋಗಿ.
I will go there.
The first petitioner who suffers orthopedic paraplegia is before the court on his inability to answer the summons and appear before the enforcement directorate to render evidence as is sought for. The second petitioner is the other partner of ಯಾವ firm ಇದು? Muktakeshi Rice Mill. The learned counsel for the petitioner submits that the second petitioner's son, who is in custody of all the documents, will produce all the necessary documents before the enforcement directorate. The first petitioner may not be insisted, first petitioner's presence may not be insisted. The learned counsel Madhu and Rao submits that the first petitioner's presence will not be insisted. However, the second petitioner should come and produce all the documents before the enforcement directorate to cooperate with the investigation. In the light of the aforesaid submission, I deem it appropriate to direct the first petitioner, direct the enforcement directorate not to insist upon the presence of the first petitioner for the purpose of rendering evidence in answer to a summon. Insofar as this, however, the second petitioner, whether with his son or without, shall appear before the before the enforcement directorate to tender such evidence as is sought for in accordance with law.
Those documents mentioned in the summons.
Everything.
Whatever, in accordance with law, answering the summons.
My lord, this is limited to only this summons because if he doesn't answer, then we have to call him only.
Correct, ಆಯ್ತು, so and so.
ಇಲ್ಲ ಅಂದ್ರೆ ತಿರ್ಗಾ
ಅದು
ಆಮೇಲೆ
ಬರ್ತಾರೆ ಬೇಡ, ಹೋಗೇ ಹೋಗ್ತಾರೆ. ಅದಕ್ಕೆ ಅವ್ರ ಪೆಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಹಿಡಿಯುತ್ತೆ. ಎಸ್, ಇನ್ ದಿ ಲೈಟ್ ಆಫ್ ದಿ, ಯಾವತ್ತು ಹೋಗ್ತೀರಾ?
Any day, maybe.
Yes.
One email may be
That-
sent to us. We come from West Bengal. One email may be sent.
ಆಯ್ತು, the second petitioner along with his son or otherwise shall appear before the enforcement directorate on 24th June. On 24th June, list this matter on 1st July.
No course of action to be taken as against petition number 2.
ಏನ್ ಮಾಡೋದು?
Let it be recorded, my lord, because tomorrow I'm cooperating based on my lord, the direction.
To move it, sir, if something
Allah,
happens.
because I don't even know anything.
That is not even an interim prayer.
My lord, on the previous
If you
occasion, my lord
move
had
it on that day, we will grant.
Please, my lord.
If they take coercive steps, you move the matter.
On 24th, my lord, I will not know, my lord, because if they're already, if anything is taken on 24th, then 25th, by the time I move it, my lord, it renders my entire.
You move it, sir.
Just one, my lord,
No,
because,
sir, I will not give any superfluous
my
direction.
lord, on the previous occasion, my lord had said that no course of action be taken, you cooperate with the investigation. I
You
said yes.
cooperate, sir,
I
nothing
said
will
yes,
happen.
my lord. I
Arrest
ನನಗೆ-
ಮಾಡ್ತೀರಾ?
ನನಗೆ ಗೊತ್ತಿಲ್ಲ. That is a problem. I don't even know, my lord, because
Unreasonable demands.
what my learned friend says is that today there's a predicate offense. I didn't even know
Unreasonable
about it.
demands.
Only no course of action, but nothing else.
Anticipatory bail ತರ ಅಲ್ಲ ಇದು. In anticipation, no order. Wait.
I am only saying, my lord, I'm cooperating. I'm not saying no. I will cooperate. Only say, my lord, that protection, limited protection, my lord, which I get. That's
You
the
move
only-
the matter if they do it, yes.
Please. Oblige.
For the petitioner, offences, my lord, alleged are criminal breach of trust and cheating. My lord, the petitioner and the second respondent, who is the complainant, together they start a private limited company, my lords, which is into real estate business. The company acquires land, my lords, and forms layout and sells the sites. But the complaint himself says, who is the one of the directors, that huge amount was invested by this petitioner.
Misappropriation.
ಅವ್ರ ಮಧ್ಯ ಎಷ್ಟು ಮಿಸ್ಅಪ್ರೋಪ್ರಿಯೇಷನ್?
ಏನಿಲ್ಲ my lords, company amount for the, in this very same incident,
35
he has
lakhs.
filed company petition also, which is pending before the NCLT. Still in the
2,35
state of objections.
1 minute.
Page 21.
And it was, he categorically says it is all my investments. The investment which I and my family members made was amounting to tune of 1 crore 23 lakhs. What I have withdrawn is the profit, 1 crore 32 lakhs 30,000. Page 20, my lords.
Till the appearance of the complainant, there shall be an interim order of stay of further investigation, list on 1st July. Yes.
Grateful.
Emergent notice, second respondent. Yes, returnable by 1st July. Next. First ಅದ್ ಬರೆದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದಾದ
Petitioner in this minutes, that allegation is that the petitioner has been prevented the public servant to do his duty matters.
Yes, Jagdish.
Page 32, my lord.
Passport.
My lords, two aspects, my lords. One, registration of the FIR. And the 353 of IPC, my lords. No ingredients of 353 of IPC, my lords.
ಇನ್ನೇನಿದೆ ಬೇರೆ?
And my lord, they said the money which is owed to the contractor has not been paid. They went and they said, they threatened the officer to pay the amount. And did not allow the officer, concerned officer, my lord, to go out of the.
Other offenses ಯಾಕೆ ಅಂತ?
Other offenses, my lord, 340 equal to present wrongful restraint, my lords. That she was not allowed to.
126 and 132 will.
Please, my lord.
ಇದು ಮಾಮೂಲಿ.
Even 132, they packed that, my lord, they restrained her.
What restraint? Restrained by use of criminal force.
They requested, in fact, my lord.
351.
Please, my
to
lord.
become 353.
Please, my lord.
Yes.
The
Heard the
ingredients.
learned senior counsel. P.P. Hegde appearing for the petitioner. The petitioner is accused, number 3, is alleged of restraining the complainant from performing his official duties. A perusal at the complaint would not indicate the ingredients of section 351 of the IPC being met for it to become an offence under section 353, as there is no allegation of use of criminal force to deter a public servant from performing his or her duties. Therefore, there shall be an interim order of stay of further investigation quae the petition.
Charge sheet ಆಗಿದೆ.
Further proceedings before the concerned court till the next date of hearing.
One humble prayer, my lords. Second prayer is because of this criminal case, my lords. They're not, police are not renewing the, giving
Police
letter for renewal of the, they have to give a letter for renewal, my lord. Have been doing
Passport.
business.
Let them seek for a shot.
The petitioner, in the teeth of the interim order, it is for the petitioner to seek file an appropriate application and seek police verification to be conducted for the purpose of renewal of passport.
Please.
ಅಷ್ಟು ಸಾಕು ಮಾಡ್ತಾರೆ.
This, grateful.
13 7
Under trial prisoner
Coca.
transfer from
Coca.
central. I am challenging only the transfer, my lord. Transfer from central prison Bangalore to my lord Kalburgi.
ಯಾಕೆ
Lord,
ಅಲ್ಲಿಂದ ಎಲ್ಲ ಇಲ್ಲಿ ಬರ್ಬೇಕು, ನೀವೇನು ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಇದ್ದೀರಾ?
the trial court has passed an order directing transfer of the my lord petitioner from Bangalore to Kalburgi, my lord. Requisition is filed on 15th. 19 case is advanced. Trial court passes the impugned order, my lord.
ಎಲ್ಲಿ ಕಳಿಸಿದಾರೆ ಈಗ?
Kalburgiಗೆ.
ಓ, ಅಲ್ಲಿ ಕಳಿಸಿದಾರ?
That order is under challenge.
Yes, sir.
Not covered by.
Without application of mind ಮಾಡಂಗಿಲ್ಲ ಕೊಡಿ.
Next, sir, F, my lord, page 176. This honorable court has held that, my lord. I should
ಅದೆಲ್ಲ
be heard.
ಬರೋದ್ನಲ್ಲ ಆ ಕೇಸ್. Where is that?
Page 179.
Yes.
Requisition is at, my lord, on 15th. Lord, 19th case is advanced, order is passed.
There is my judgment also where I have bought every prisoner back. ಇಲ್ಲಿ.
Pardosh Rao.
Paritosh, yes. Darshan's
Yes.
co-accused.
Paritosh.
Judgment ತರ್ಲಿ ಅಲ್ಲ also. ಅವ್ರು ತರ್ಲಿ ಆ judgment.
ಬೇಡ ಸ್ವಾಮಿ ಬೇಡ ಮತ್ತೊಂದಿನ.
Will quash it.
And liberty, my lord.
Liberty always, in accordance with law.
Yes.
ಈಗ ಬೇರೆ ಜೈಲ್ಗೆ ಹಾಕಿ ಕಲಬುರ್ಗಿ ಬೇಡ. The
ಅಲ್ಲ, ಇಲ್ಲೇ
petitioner,
ಹತ್ರ ಎಲ್ಲಾದ್ರು
ಮನೆ ಪಕ್ಕದಲ್ಲಿ ಬೇಕು. The petitioner is before the court. You are married?
Yes. But I have 2 children, my lord.
ಅಲ್ಲ ಅದಕ್ಕಲ್ಲ ನಾ ಕೇಳಿದ್ದು. ಎಸ್. ಅಲ್ಲ ಹತ್ರದಲ್ಲೆಲ್ಲ ಬೇಕು ಅಂದಿಲ್ಲ ಅದಕ್ಕೆ. The petitioner is before the court calling in question an order of the concerned court dated 19/5/2026 by which the petitioner, who was housed in the prison at Central Prison at Bangalore, is transported to the Central Prison Kalburgi on the requisition made by the prosecution. Heard so and so. The petitioner is accused number 3, na?
Yes.
Accused number 3, who is alleged, gets embroiled in a crime in crime number 353 of 2024, initially for offences punishable under section 341, 302 and 34 of the IPC. During the subsistence of the investigation, the offences under the Karnataka Control of Organized Crime Act 2000 COCA bracket, and Indian Arms Act is invoked. The petitioner then gets convicted of the offence. The petitioner, the under trial prisoner, is now facing trial after the police invoking COCA and filing the charge sheet before the concerned court. The issue in the list does not relate to the merit of the matter. It transpires that on 15/5/2026, during the pendency of the trial in special CC 2055 of 2024, a requisition springs from the chief superintendent of the prison to the concerned court to transfer the petitioner from Central Prison Bengaluru to Kalburgi on the score of alleged prison administration and security concerns in the prison. The matter is advanced before the concerned court, and 4 days thereafter the concerned court passes the following order. Page
161, my lord. 160. ನೋಡ the certified copy ನಲ್ಲಿ
160 ಅಷ್ಟೇನಾ?
160 160 and 161, my lord. ಉಲ್ಟಾ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ certified copy ನ. It starts from 161.
161 madam. Yes. A perusal at the aforesaid order would clearly indicate that it suffers from blatant non-application of mind as to why the petitioner has to be shifted from Bangalore to Kalburgi. In identical circumstances, this court, answering the issue of shifting the prisoners from one place to the other, as in the case of Pardosh S. Rao, WP number 23848 of 2024, considered the same issue and has directed the prison authorities to directed those prisoners who had been shifted from one prison to the other on an order which suffered from non-application of mind, has held as follows. Madam Adirbek Nodi, number haki, date gotil. Has held as follows. In the light of the issue standing completely answered by this court in the aforesaid petition of Pardosh S. Rao, the petition deserves to succeed. However, reserving liberty to the state to act in accordance with law if need so arises. The consequence of the order shall be implemented.
I may be reshifted to Bangalore.
Consequence of the order.
But
The consequence of the order shall be implemented without broking any delay.
yes, but
ಭಾಷೆ ಮಾಡಿದ್ನ.
But our notice to R5 may be dispensed.
R5 ಯಾರು?
Office has raised an objection. Original complaint.
Office objections overruled. Yes. ಆಮೇಲೆ
R5
R5 dispensed with memo.
I'll file. I'll give it.
ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅಂತ ನೀವು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಮೆಮೊ ಕೊಡೋದನ್ನ ಆಗಲ್ಲ.
ಇಲ್ಲ ಹೀಗೆ ಕೊಡ್ತೀನಿ. ಇಲ್ಲೇ
I'm appearing for the petitioner.
ಅದು ಚೆಕ್ ಮಾಡಿ ಮೇಡಮ್. ರೆಡ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಇಲ್ಲಿ ರೆಡ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಚೆಕ್ ಮಾಡಿ.
Correct.
ಪಾರದೋಷ್ ಕರೆಕ್ಟಾ? ಎಸ್.
Serial number 53, I'm appearing for the petitioner mode.
53.1, I am appearing for petitioner, my lord.
It's a case and counter case, my lord.
There is it is not a case and counter case. After filing my complaint, my lord, it was registered on 4
ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಫೇಲ್
Fail.
ಯಾಕೆ
ಆಗ್ತಾ ಇಲ್ಲ, ಸೆಟಲ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಆಗ್ತಾ ಇಲ್ವಾ?
ನಾವು ರೆಡಿ ಇದೀವಿ, my lord, sir.
ನೀವು ರೆಡಿ ಇದ್ದೀರಾ? ಜಾಸ್ತಿ ಹೊಡೆದಿರೋದು ಯಾರು?
But
ಅವರೇ
ಅವರೇ ಹೊಡೆದಿರೋದ?
there are no document to show that there is assault, my lord.
1 year ಹಾಸನಲ್ಲಿ 1 year ಹಾಸನಲ್ಲಿ ಮೆಡಿಷನ್ ಹೋಗಿದೆ.
1 year?
1 ವರ್ಷ
ಏನಾಗಿದೆ?
ಮೆಡಿಷನ್ ಬನ್ನಿ ಅಂದ್ರೆ ಬರ್ತಾ ಇಲ್ಲ.
ನಾವು ಬರ್ತಾ ಇದೀವಿ, my lords, ಅವರೇ ಬರ್ತಾ ಇಲ್ಲ.
ಇದು
ಇದು ಅದನ್ನ ಕಾಸ್ಟ್ ಮಾಡ್ತೀನಿ ಈಗ.
My lords,
ನಿಮ್ದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ.
my lords, the husband is not before this honorable court, my lords.
ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್
Please, my lords.
ಅತ್ತೆ ಮಾವ.
In-laws, ಅತ್ತೆ ಮಾವ ರಿಲೇಟಿವ್ ಅಲ್ಲದೆ ಇರೋರು ಅಕ್ಯೂಸ್ಡ್ ಆಗಿದ್ದಾರೆ, my lords, in this matter.
ಹಸ್ಬೆಂಡ್ ವೈಫ್ ಪ್ರಾಬ್ಲಮ್ ಅದು ಮೀಡಿಯೇಟ್ ಆಗೋದೇ ಇಲ್ಲ. ಯಾಕೆ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ನಾನು ಅವ್ರು ಮೆಡಿಟೇಷನ್ ಹೇಳ್ತಿದ್ದಾರೆ.
Mediation ನಾವು
ಎಂಸಿ ಹಾಕಿದ್ರು, ಡೈವರ್ಸ್ ಪಿಟಿಷನ್
MC
ವಾಪಸ್ ತಗೊಂಡ್ರು,
ಹ್ಮ್
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
my lords, husband is
ಮಗು ಇದೆ ಒಂದು.
husband is ready to take
ಹೆಣ್ಮಗು
back
ಅದು.
the wife, my lords. They are not coming, my lords.
2 ವರ್ಷ.
Now we have also issued a notice for restitution of conjugal rights, my lords.
ಅದು ಇಶ್ಯೂ ಮಾಡೇ ಮಾಡ್ತೀರಾ ಬಿಡಿ. The mediation is supposed to have ended in failure. Therefore, post this matter for admission next Tuesday. Yes.
ಇಂಟ್ರಿ ಮಾಡಸ್
Interim order subsisting will continue to the next date of hearing.
ಯೂಸ್ ಬೇಡ.
Interim order ಇಲ್ಲದೆ ಇದ್ರೆ that also will continue to the next date.
ನಂದ್ರಲ್ಲಿ ಇದೆ.
ಸರಿ.
ಎರಡರಲ್ಲೂ ಇದೆ.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಮಾಡೋಣ.
Next Tuesday. Yes. Beginning stage. Under the caption interlocutory application.
Please, ma'am.
I represent for petitioner in the above matter, my lord. My lord, I seek before your lordship for quashing of the proceedings against me.
Beginning stay.
Vacating is my application.
Yes, sir.
That is at the trial.
Offense.
138, my lord.
138, Lord.
138.
Yes, my lord.
Ground.
My lord, I am not a signatory to the check, and as well as my lord, the complainant have no locus to file a case against me.
Why?
My lord. Because if at all the issue arises, my lord, the demand has to be made by the firm, my lord. Here, the demand has been made by the wife of the complainant, my lord. Because as per JDA agreement, my lord, it has been entered by 6 persons in favor of proprietor, my lord. That is my humble submission.
ನೆನ್ನೆದೊಂದು ಓಝೋನ್ ಇತ್ತಲ್ಲ ಅದು 4:15 ತಗೊಳ್ಳಿ. ಇವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ. ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಇಸ್ ದರ್. You inform 4:15 I'll take it. Yes.
That is my main submissions before your lordship.
Ah.
My lord, may I just debrief, my lord, what is their demands and what is my defense, my lord? My lord, the gist of the case is, my lord.
Put up all the defense there. The only thing is if you are not the signatory andre ಹೇಳಿ.
Yes, my lord, I am not the signatory. To establish, my lord, I have filed my objections. In objections page number 5, my lord, I have filed a check in my objections to the vacating of stay.
1 minute.
Page 5 of my objections, my lord.
Who is this?
My father, petitioner father. I'm not the signatory.
Is it a company firm ಏನದು?
No, my lord, individual.
Individual.
Yes, my lord.
He is GPA holder for this first accused.
Who is GPA holder?
This
For me.
signatory is the GPA holder. It is executed. That
What is the
complainant-
transaction? What is the transaction?
It's they together but bought a site. They've entered into an agreement to develop and into 6 independent dwelling units, for which complainant and her husband are the contractors to build the house, and they are supposed to pay the amount. This one of the present petitioner is the daughter who is who was acted by her father as a GPA holder, registered power of attorney.
Where is the GPA?
My lord, I
Page
furnish,
number
my lord.
31,
Page?
21.
21 to 27.
All this evidence are alle.
My lord.
Anything else?
Now, one other submission. Now
Just what's the amount in the check?
10,000 each.
10,000.
Sorry, 10 lakhs each.
Ah.
As against 20 lakhs each. He has issued two checks in respect of in respect of two buildings, two units. Now the second accused trial is almost over. It is in the final stage, final argument. They have
Yes.
not taken any defense before the court.
Yes, sir. Alle mugsbidi.
My lord, only for a few.
I will answer why you are not you are not the signatory.
My lord, I was resident at Australia, my lord, at that particular point in time. My lord, if this
Resident
check
of?
was Australian. My lord.
But the
I'm not
GPA
going-
Act in favor alle.
No, my lord, I have given GPA to
She
my
has-
father.
Oh, you have given GPA.
Yes.
I have given GPA to my father, my lord. The check has been issued by my father. And the check, my lord, it is there in the
Now,
name.
father is being prosecuted there.
Yes, my lord. And my lord, I draw your lordship attention towards page number, my lord. 108.
The petitioner,
108.
accused number 2, is before this court. Accused number 1
One.
is before this court calling in question the proceedings in CC 6509 of 2023 registered for offences punishable under section 138 of the Negotiable Instruments Act, hereinafter referred to as the Act for short. The petitioner, accused number 1, does not have any transaction with the complainant. The transaction pursuant to a sale deed executed is between the GPA holder of the petitioner, i.e. her father, and the complainant. The check is issued.
Joint development agreement as well.
The joint development agreement. Sale deed beda. The check is admittedly issued by the father pursuant to the execution of the GPA by the petitioner who was at the relevant point in time residing in Australia. The checks were dishonored. The dishonoring of the check resulted in the complainant instituting proceedings under invoking section 200 of the CRPC for offence punishable under section 138 of the Act. The concerned court takes cognizance of the offence. The petitioner then approaches this court in the subject petition, contending that the petitioner is not the signatory to the check. She has executed a GPA for all transactions, and in furtherance of the said GPA, the father has issued the check. The father is facing the prosecution. The petitioner must not be permitted to be prosecuted. This court has interdicted the proceedings. The complainant prefers an application seeking vacation of the interim order. The learned counsel for the petitioner would reiterate the grounds set out in the petition, particularly of the fact that the petitioner not being a signatory to the check. The learned counsel for the complainant submits that it is at the behest of the complainant, petitioner accused number 1, that the check is issued by accused number 2. The check having been dishonored, both would become equally liable for the offence under section 138 of the Negotiable Instruments Act. The learned counsel submits that it is for the petitioner, counsel for the respondent submits that it is for the petitioner to come out clean in a full-blown proceeding before the concerned court. I have given my so the aforenarrated facts are not in dispute. They are in fact a matter of record. The issue at this juncture lies in a narrow compass for the reason that the petitioner is not the signatory to the check is an admitted fact. She had executed the GPA in favor of the father for all transactions is again an admitted fact. The subject of the transaction in the subject list is with regard to a joint development agreement. Checks are issued by the father accused number 2 in favor of the complainant in furtherance of a particular agreement entered into between the parties. The petitioner, since the petitioner is not a signatory to the check and has executed a GPA for all transactions in favor of the father, the petitioner, in the considered view of this court, cannot be permitted to be prosecuted for offence punishable under section 138 of the Negotiable Instruments Act. As a non-signatory to the check cannot be drawn into the web of proceedings, it is by now a well-settled principle of law in the light of the judgment of the Apex Court in the case of 2021 4 ACC page 675 Alkan and the 10 to 15 para. Yes. In the light of the aforesaid judgment, and if the Law as laid down by the apex court is pitted qua the facts obtaining in the case at hand permitting further proceedings would become an abuse of the process of the law. Allowed question. Next.
Any order observation should not come in the way of.
ಅಯ್ಯೋ ಒಂದ್ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ವಲ್ಲ ಇವ್ರ ಬಗ್ಗೆ ಟೂ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ವಲ್ಲ
ಅಲ್ಲ, ಅದಲ್ಲಿ power of attorney.
ಅಬ್ಸರ್ವೇಷನ್ಸ್ ಮಾಡಿ ಮೇಡಮ್ ಎನಿ ಅಬ್ಸರ್ವೇಷನ್
It should not be a defense in the.
ಅದೇ ಎನಿ ಅಬ್ಸರ್ವೇಷನ್ ಗೊತ್ತಲ್ಲ ಮೇಡಮ್
55 Milord. The complainant in this case is
Sorry for the
the
second respondent in this matter, my lords.
complainant is the sister of the petitioner, first petitioner.
State has
Milord.
filed vacating stay. Your Lordship.
State has filed vacating
Please,
stay.
Your Lordship.
What's the matter, madam?
Milord, the case is that GPA of the complainant is forged and it is used for a release deed property in favor of another deceased brother. And the
All of your
petitioner-
suit ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ದಾರೆ OS ಇದೆ OS 2017 ಅಲ್ಲಿ ಸೂಟ್ ಹಾಕಿ 2024 ಅಲ್ಲಿ ಈಗ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಆನ್ ದ ಸೇಮ್ ಡಾಕ್ಯುಮೆಂಟ್.
Yes, sir.
It is already in scrutiny, under scrutiny.
Yes, sir.
Their GPA executed by the complainant, my lords, is a forged one. The signature is not tallying at all. And on the basis of the GPA, they have issued a release date. The release date and the property also was transferred. So that is why.
When was the transfer, sir? When was the transfer?
Transfer had happened in 2021.
Huh?
That's okay. 1 second, my lords. OS number 30, 2017, the OS was filed.
Ah.
Before that, it was, OS was
Before
filed.
that transfer ಆಗಿರೋದಾ?
ಹೌದು, transfer ಆಗಿರೋದು.
Anything else?
And now if it is under FSL, the fact will come into picture whether the signature is original or not, because the signature is totally different. That's why. If it is sent to FSL, my lords, if if the petitioner says that it is the original distinct argument, I am bound by it. Only the thing it has to send to FSL. And once the FSL confirms the signature
Suit ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Sister,
ಅಲ್ಲ ಇವ್ರು ಯಾರು?
brother.
Brother and sister suit ಹಾಕಿದಾರಾ?
ಅಲ್ಲ, sister, elder sister has filed suit against.
Complainant ಯಾರು ಮೇಡಮ್?
Complainant is elder sister, eldest sister.
Plaintiff ಆ?
Plaintiff in the suit, yes.
ಅದನ್ನೇ ಕೇಳಿದ್ದು.
Plaintiff in the suit, yes.
Suit 2017 ಆ?
30 of 17.
ಅಲ್ಲ ಸೂಟ್ ಅಲ್ಲಿ ಏನು ಇದೇನಾ ಫೋರ್ಜರಿ ಅಂತ?
This is, on this allegation itself suit is filed. Petitioner number 1
The
is not to the
petitioners
beneficiary also.
accused 1 and 2 are at the doors of this court calling in question proceedings in crime number 13 of 2024 registered for offense punishable under section so and so, prayer there. Heard so and so. The parties to the list, the petitioners and the complainant are members of the same family. It transpires that in the year 2000, it transpires that you ನಿಮಗೇನು ಬಂದಿದ್ದು ಶೇರ್?
Share ಅಲ್ಲ.
ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The complainant is the elder brother of the first, the first petitioner is the elder brother of the complainant. The second petitioner is the wife of another brother who is now deceased. Third petitioner ಇಲ್ವೇ ಇಲ್ಲ, ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಯಾವ್ದ್ರದ್ದು. The family is of 2 brothers and 5 sisters. The father passed away in the year 1989 and the mother on 6/12/2005, leaving behind some landed property. Then begins the problem between the brothers. The share of the property and the share in the property rendered some heartburn, and the complainant institutes a suit in OS 30 of 2017 seeking a decree of partition of the property, in which the prime contention of the complainant is that the general power of attorney so executed at an earlier point in time has been forged, and on the strength of the said forged document certain properties are transferred to the name of these petitioners. In that
Not on the name, to the deceased brother.
to the transfer to the deceased brother who ಯಾವಾಗ ಅವರು ಸತ್ತಿದ್ದು?
not on record.
Not on.
No,
So
wife
this
is
is
on
brother
record.
only. The
Wife
suit
is on
is
record.
pending, the suit is pending adjudication before the concerned court. The suit is now suit by the time when the complaint was registered, it was 7 years old. The complaint comes to be registered on 24/1/2024 on the score that the property is transferred to the deceased brother on a forged GPA, which admittedly happens on 5/6/2006. The 5/6/2006, and the complaint becomes a crime in crime number 13 of 2024 for the aforequoted offences. The registration of the crime is what has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner, Halima, would vehemently contend, Halima Amin would vehemently contend that the issue, which is purely civil in nature, is projected to become a crime. That too after registering one, after 7 years after after instituting the suit in OS 30 of 2017. The complainant is the plaintiff in the case at hand, and the same relief is sought before the concerned court. The learned counsel would seek quashment of the proceedings. Per contra, the learned counsel appearing for the second respondent complainant, M.V. Ramana, would vehemently refute the submission, contending that that both civil civil case and civil proceedings and the criminal proceedings can go hand in hand if the allegation is of forgery. Therefore, if the document is sent to FSL, the truth would come out, and as the signature admittedly differs of what admittedly differs with the admitted signatures. The learned counsel would seek dismissal of the petition, contending that investigation in the case at hand in the least is a must. The learned HCGP would also toe the lines of the learned counsel appearing for the respondent, second respondent complainant, in seeking dismissal of the petition. I have given my so and so. Therefore, narrated facts link in the chain of events are all a matter of record. They would not require any iteration. What brings the petitioners to this court is the registration of the crime in crime number 13 of 2024. The registration of crime happens upon a complaint being registered by the second respondent complainant. The complainant invokes section 200 of the CRPC. Student CRPC to register a private complaint for the aforequoted offences. The complaint reads as follows. Page 16 to 21. The complaint is registered on 21/4. The matter is referred for investigation and becomes the aforesaid crime on 24/1/2024. On the same cause of action, the complainant has instituted a suit in OS 30 of 2017. Same cause of action, I mean inter alia. The allegation of the forgery of a general power of attorney is taken even in the civil suit. The suit is pending adjudication. 7 years after instituting the suit on the same cause of action, the criminal law is set into motion on the plea that there is forgery in the case at hand. If this would be permitted, it would be permitting embellishments into a crime to be embellishments into a complaint to be given credence while setting the criminal law into motion, and would run foul of the judgment of the apex court in the case of Chanchalapati Das versus so and so, 2023 SEC online SC page 650 para 10 to 16. In the light of the said circumstance, reserving liberty to the petitioner to invoke the criminal justice system in the event the concerned civil court would arrive at the conclusion that there is forgery, the petition stands allowed. Yes.
Lordship, I may make an application for forensic laboratory that should not be denied.
Al ಮಾಡಿ sir.
ಅದೇ ಅಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಇಲ್ಲಿ ಅವರು ತಗೊಳ್ಳಲ್ಲ, ಇಲ್ಲಿ ಎಂಟರ್ಟೈನ್ ಮಾಡಿಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಂತಾರೆ. Lordship may just make an observation.
ಅವ್ರ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ನಿಮ್ ರಿಲೀಫ್ ಹೆಂಗೆ ಸರ್?
ಅಲ್ಲಲ್ಲ, forensic ಕಳಿಸ್ಲಿಕ್ಕೆ for the forgery I will just make an application. That's the only
ಅಲ್ಲಿ
thing.
You take advantage of the observation. Yes.
Yes, my lords.
Yes.
Well, I feel, my lord, for the petitioner's counsel. But in the first place, my lord, this
Vacating
petition
stay.
Please.
ಇದು ಆ society da?
Please, ma'am. Yes, ma'am.
Misappropriation.
Yes, ma'am. That is the allegation, ma'am. In fact, but before entering
Irregularity na misappropriation.
misappropriation to the tune of more than 19 crores.
19 crores.
19 crores.
ಏನ್
And they
ಏನ್
opened,
ಮಾಡಿದ್ರಿ ಸರ್?
But I will argue the matter.
they
Before
opened
that,
account in the name of Karnataka Sarkar Navkar Sangha Mandya at Cochin.
ಹೌದಾ?
ಹೌದು.
ಯಾಕೆ ಅಲ್ಲಿ ಬ್ರಾಂಚ್ ಓಪನ್ ಮಾಡಿದ್ರು?
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ because he is in very much hurry.
No, I am not
Don't
in
lock
hurry.
up my property, my money.
ಅವ್ರು ಹರಿ, ಬಟ್ ಯು ಡೋಂಟ್ ವರಿ ಸರ್.
Not before they be entering into the merits, Lord, this petition is also connected with two other matters.
ಹೌದಾ? ಯಾವ್ದು?
Between the same parties, that is 10,077 of 24.
Tag these petitions along with so and so Wednesday,
And
same stage.
5118 of 25.
Wednesday, same stage, yes.
About 10 days time for this reason.
10 days time.
Yes, please. Because, please, Abhilash. Fix
Next
it.
Wednesday, that is 24th.
My lord,
Abhilash.
there are as many as 40
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬರ್ಲಿ.
petition pending since from 2024.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬರ್ಲಿ, ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡು ಒಂದೇ ಸರಿಗೆ.
Please, my lord.
Please.
I request a date.
24th. ಅವತ್ತು ನೋ ಟೈಮ್.
Please, please.
For the respondent number 2, my lord. Lord, in this case, the very contention of the petitioner is that, my lord, that
ಇದ್ರಲ್ಲೂ ನೀವೇನಾ?
please, my lord, the treatment of the petitioner took place after 2 days. But I have been informed that there are material to show that immediately after the incident, he has taken treatment. So now he is taking care of his father at Somarpet and he is coming only by this Saturday. Maybe taken up any day next week, my lord. Short accommodation.
ಏನ್ ಪ್ರಾಬ್ಲಮ್?
To substantiate my fact that I took the treatment immediately after the incident has been taken.
The allegation occurred on.
324.
Yes, my lord.
ಹಾ.
The respondent number 1, the respondent number 2 and the petitioner are the childhood friend, my lord.
Oh.
That is the one stone throw the lady.
Stone thrown lady?
The petitioner is lady, my lord.
Lady thrown stone?
To the respondent number
On
2.
whom?
Last vacation.
On the childhood friend.
The last vacation is
Disputed question of facts, my lord.
Kind.
Any day, my lord, any day.
ಯಾವ ಸೈಜ್ ಕಲ್ಲು?
ಒಂದು ಇಡೀ ಗಾತ್ರದ ಕಲ್ಲು ಅಂತಾರೆ ಸರ್.
ಇಷ್ಟು.
No.
ಎಲ್ಲಿಗೆ ಬಿತ್ತು ನಿಮ್ಗೆ?
Short accommodation.
ಅಲ್ಲ, ಶಾರ್ಟ್ ಎಲ್ಲಿಗೆ ಬಿತ್ತು ಅಂತ ಕೇಳಿದ್ದು.
That was thrown and I was hurt to my private parts, my lord.
ಹೌದಾ?
Please, my lord.
ನಿಮ್ಗೇನು? ಚೈಲ್ಡ್ಹುಡ್ ಫ್ರೆಂಡ್ ಹಂಗೆಲ್ಲ ಮಾಡ್ತಾರ?
That is the incident, but after lapse of 7 days, he taken treatment before the.
ಸರ್, ನೀವು ಅಲ್ಲಿಗೆ ಹೊಡೆದ್ರೆ ಅದು 7 days ರೆಸ್ಟ್ ಅಲ್ಲಿ ಇರ್ತಾರ ಅವ್ರು.
There is a document to substantiate the fact that, my lord, I took the treatment on the very same day the incident happened. Just to produce
ಹಂಗಾರೆ
that.
ಏನೂ ಆಗಿಲ್ಲ ಬಿಡಿ ನಿಮ್ಗೆ.
Please, no.
If you have taken the treatment on the same day, walk to the hospital, nothing has happened.
No, not walk to, my lord. I was accompanied by my friend.
Another childhood friend?
Not happened to another childhood friend, but a common friend of both the petitioner and the
ಇಬ್ರಿಗೂ
respondent.
ಗೊತ್ತಿರೋರು.
Please, my lord.
ಯಾವ ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀರಾ?
I have no instruction to.
ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ಲ. ಐ ವಿಲ್ ಕ್ವಾಶ್ ಇಟ್ ಸ್ಟ್ರೈಟ್ ಅವೇ. ಎಲ್ಲಿ ಕಲ್ಲೆಲ್ಲಿದೆ?
I seized by the respondent number 1, my lord.
Maybe take up to Tuesday, my lord.
Nothing.
I'll make sincere efforts to see.
What is this childhood friends fighting with
Sir,
stone?
even otherwise, there is allegation with regard to 406 and 420, my lord.
ಯಾಕೆ?
That my signature forged and the same has been now been.
So 324 is a story for that, is it?
Not the story, my lord. The allegation is that just because I asked for her to give
back the money.
Give back certain of the document, because, my lord, initially she was running a company. And that company has gone for insolvency and that was never informed to me. And subsequently changed the name of that company in the name of another company and made me a party.
How are you aggrieved?
I am party in the new company and my signature for, and the forensic report says that the disputed signatures, the agreed signatures are disputed. There is a forensic report to that extent.
Stone ಎಲ್ಲಿ ಬಂತಿಲ್ಲಿ?
ಅವತ್ತು ಹೊಡೆದಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ. Subsequent to that, I was kept, my lord, for the reason that I kept quiet only for the reason that she happened to be my childhood friend. And also the father of the petitioner happens to be a close associate with the family. For that reason, I kept quiet, my lord. But when these things escalated, I was forced to file a complaint.
My lord, I issued a 8/2/2023 resolution of
ಇದು
partnership.
324 ಸುಮ್ನೆ 406 420 yes.
That is also not applicable to the petitioner, my lord.
If you have lured him to come into the company which is already doomed,
Kindly
then
see, my lord, that is the, in page number 161 is the FSL report. The private FSL report says that he is not signed by the one.
private FSO I will not refer to.
I will.
Truth Labs,
Rudra Associates.
Mudra Associates.
Fingerprints.
ಎರಡು ಅಷ್ಟೇ. If you have sent it to the state FSL only then.
State FSL confirms that my signature is forged.
State FSL
Yes,
confirms.
ma'am.
Yes. Anything else, sir?
Yes, madam. My lord, kindly see page number before going to.
Now you are sitting in the glass house and throwing stones at him.
No, nothing happened, my kindly see
And
page number.
subsequent
for
to
a
my
moment,
filing of
kindly
complaint, my lord,
kindly-
she files a injunction suit, a simpliciter suit saying that I am interfering with the peaceful possession of our property.
Kindly for a moment.
Subsequent to
madam.
this
Page
complaint.
number 88 for the womb certificate.
And on that particular day, I was not at all in the country.
Page number 88, madam. That is the own certificate, my lord.
No, stone is that you are not in the country.
No, my lord. The incident took place some other day. But the allegation made in the original suit saying that on a particular day I interfere with the peaceful possession. On that day I was not at all in the country. I was in Sri Lanka.
ಇದೇನು own certificate chest pain ಅಂತ ಇದೆ.
That is they created that own certificate, my lord. The connect to page number 73.
ಮತ್ತೆ ನಿಮಗೆ ಎಲ್ಲೋ ಏಟ್ ಬಿದ್ದಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದೀರಾ? ಚೆಸ್ಟ್ ಪೇನ್ ಅಂತ ಚೆಸ್ಟ್ ಹತ್ರ ಅಂತ ಇದೆ.
No, my lord.
ಕಂಪ್ಲೇಂಟ್ ಯಾರು? ಒಂದು ನಿಮಿಷ.
That it says is a grievous in nature. For that thing, my lord, a short accommodation, Monday or Tuesday.
ಬೇರೆ own certificate.
No, my lord. The certificate, on the date of alleged incident, I actually visited the hospital. And there is a
ಅದು
certificate.
ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಇರ್ತಾ ಇತ್ತು ನೀವು ವಿಸಿಟ್ ಮಾಡಿದ್ರೆ.
It not happened to be a charge sheet material, my lord. For that thing, my lord. A short accommodation, Monday or Tuesday, my lord.
ಇಲ್ಲ will grant but can't be settled.
We will once instruction.
My lord, I'm dragged into the web of crime firstly. Secondly, there is a suit. A simple.
ಇಲ್ಲ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಒಂದೇ ಸರಿಗೆ.
I will make sincere efforts, man. 2 days.
I will take
Try
instruction.
to settle. Childhood buddies.
Page 46 is the own certificate.
ಅದನ್ನೇ ನೋಡಿದ್ದು ಮೇಡಮ್. 88 ಯಾವುದು?
46, which says that it's
Both are
grievous
same,
in
my lord.
nature.
Both are same, my lord. 88 and 46 are both are same.
Wounds are grievous in nature is what it says.
Wounds grievous ಎಲ್ಲಿದೆ?
Please, ma'am.
None seriousness.
ಮೇಡಮ್ ಯಾವ್ದು ಇದು? 46 ಎಲ್ಲಿದೆ? ಇಲ್ಲ ಮೇಡಮ್ 46 ಅಲ್ಲಿ ಸಮರಿಯಲ್ಲಿ ಹೇಳಿರೋದು ಬಟ್ 88 ಅಲ್ಲಿ ಇದೆ wound ಅಷ್ಟೇ. Try if it is to be settled, otherwise no case for interference.
But 320 and 406 and 40, another case is large by the same respondent.
He was interested with the property.
All right, we'll see.
Please, ma'am.
I'll take it on 25th. In case you report settlement, fine, otherwise avatte order pass ಮಾಡಿ. And
But there is no material to show that 406, 420 and 324, my lord.
We'll
I
see,
produced
yes.
all the document before the, he is forged the document.
Categorical admits in OS.
whatever
That
it is,
different
you settle it, OS close ಆಗುತ್ತೆ. Yes.
Great.
interim
Next,
order.
that will continue.
Madam, Lord, I'm appealing for the petitioner's counsel.
filing
Petitioner's
retirement
counsel
memo.
is not
I'm filing retirement memo in this case.
Register ಇಲಾಖೆ.
interim order.
Yes.
Oblige.
ಇಲ್ಲ 25th, 24th ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
Kindly adjourn the case.
appealing for
ಆಯ್ತು
petitioner.
ಸರ್ 24th ಗೆ. ಹರಿಪ್ರಸಾದ್.
Correspond number.
Appealing for petitioners.
ಎಲ್ಲ ನಿಮ್ದೆ.
Petitioners are the in-laws, your lordship.
ನಿಮ್ದು ಯಾವ್ದೋ ಬೇರೆ ಇರ್ಬೇಕು.
Lord, even if
Number 59, your lordship. Petitioners
Aye,
are the in-laws.
there are specific court act allegations against each of the accused
Let
person.
me see. There is nothing, you know the result.
Please, my lord. But may I draw your lordship attention to page 17, my lord? That is to prove that all the 5 accused persons happen to reside under a single roof. According to the petition they have filed, the address so mentioned is the common address, my lord. May I pursue your lordship to page 5, my lord? I have also filed my detailed objections. And the stand they have taken is accused number 3, petition number 3 and 4 happen to be distant relatives. That's not so, my lord.
Post this on Wednesday, 17th.
Great.
ಅದೊಂದು ಯಾವ್ದೊಂದು ಪಾರ್ಟ್ ಆಡಿದೆ ಓಝೋನ್ ಮುಗ್ಸಕ್ಕೆ.
Great.
ಅದು ಕಲೀರಿ ಮೇಡಮ್. ಡಿಜಿಟಲ್ ವೇಟ್ ಆಫ್ಟರ್ ದಟ್.
On his legs, my lord, before court on Monday.
You start.
Yes. Not letter.
ನೀವು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Lord, I had submitted a small compendium yesterday. Can I take my lordship to some of the pages?
This is the one?
This is filed yesterday.
Yes, ma'am. This is a sequence of events.
ಬಂದ್ರು ತಾಳಿ. Yes, sir.
Your lordship said, my lord, your lordship should hear me on the predicate cases first.
ಪ್ರೆಡಿಕೇಟ್ ಕೇಸ್ ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
First matter for it.
ಇದರಲ್ಲಿ ಪ್ರೆಡಿಕೇಟ್ ಯಾವುದು?
Accepting the first matter, all are predicate cases.
ಮತ್ತೆ ಇಲ್ಲೊಂದು ಯಾವುದು 1.2 ಇದೆ?
That's the old ECI. First matter ಕೂಡ.
ಪ್ರೆಡಿಕೇಟ್ ಅಫೆನ್ಸ್ ಯಾವ್ದು ಹೇಳಿ ಫಸ್ಟ್?
20063, your lordship sir kindly have.
20063. All
yes.
Madam 1.1 ಕೊಡಿ. 1.
What's the difference in this? Huh? Your lordship sees, my lord, page number 16. 16 annex A B.
Madam 1.1.
You can sit. Well, in this matter, you are not there.
ಇನ್ಯಾವ ಪ್ರೆಡಿಕೇಟ್ ಇದೆ?
ಇದರಲ್ಲಿ they would
ಅಲ್ಲ ಇನ್ನೊಂದು ಯಾವ ಪ್ರೆಡಿಕೇಟ್ ಇದೆ?
1.3 and 1.5.
ಕಾಮತ್ ಸರ್ ಅದು ಫ್ರೈಡೆಗೆ ಹಾಕಿದ್ದೀನಿ.
Yes, I'm grateful.
ರೇಸರ್ ಪೇ ಅದು. I did not see the cost statement.
I'm sir.
ರೇಸರ್ ಪೇ ಅದು. The other SFI ಓದು.
Yes, yes.
It's razor pay.
ಇದೇನಾ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಿದು?
Yes.
1.1, 1.2, 1.3, 1.4 and 1.5 are the predicate cases. Your lordship should kindly have
ನಿಮಿಷ.
petition number
ಅಲ್ಲ
20063.
ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಒಂದು ನಿಮಿಷ. This 1.2 is not predicate, it is ECIR.
No, that's the first ECIR.
ಆಯ್ತಾ? ಆಮೇಲೆ ಈಗ predicate is 1.1 ನಾ?
Yes, 1.1.
ಆಮೇಲೆ 1.3.
Yes.
ಆಮೇಲೆ 1.4.
Yes.
And 1.5.
1.5.
All right. ಈಗ ನಾಲ್ಕು.
One more matter to be tagged, my lord. I am instructed to say it's not listed.
That's all right, no problem. ನಾವು ಇರೋದನ್ನ ಮುಗಿಸ್ಬಿಡೋಣ.
ಆಗ್ಬೋದು. Your lordship may kindly have this, my lord. 20063.
All right.
Of 2022. My lords may kindly have. My lord, the complaint which is at page number 16. My lord, one Mr. Padmanabha, my lord, raises this private complaint.
Sure. They have taken a predicate of his business.
Please see, my lord, what are the allegations? Allegations, my lord, that your lordship sees page number 17, paragraph number 5.
I'm there.
The complainant submitted in the year 2013 to 2019-20, accused has given 12 projects to the complainant. Accused has given 12 projects to the complainant for a sum of 4 crore, 4 lakhs, etc. The complainant has completed the said project works in time. My lord, this is a dispute between a contractor and, my lord, the builder. Now, what he says is, the complainant, my lord, paragraph 6, complainant submits that after several requests made by the complainant,
accused has dragged on the dates by saying one or the other pretext for the payment of the balance amount, and also informed that due to the COVID-19 effect, he has suffered a huge loss in business. They have already gone to civil court. And my lord, they are already before the civil court. And it is decreed.
What is decreed?
The civil suit is decreed, and my lord, we are now before the Honorable High Court. And the Honorable High Court, my lord, has granted an order of stay in this matter subject to, my lord, certain deposit. Besides that, this private complaint.
Next matter, ಇನ್ನೊಂದು ಯಾವುದು?
And my lord, my lord, since your lordships are on
That
this,
is 1.3 ತಗೊಳ್ಳಿ ಈಗ.
my lord, I'll have to, my lord, in this case, my lord, place the decree which is already granted in their favor.
All right.
And my lord, the indulgence granted by this honorable court onto this matter. My lord, that will place it along with a memo.
All right.
Now this private complaint, my lord, was virtually, my lord, a backdoor to, my lord, it was just, my lord, a backdoor tactic to, my lord, some of the other.
Which
my lord,
private
pressurize.
complaint, sir?
This one.
ಇದು private complaint ಅಲ್ಲ.
20063, my lord. is a private
20063 ಆಯ್ತು, ಅದ್ರ facts ಬಿಟ್ಬಿಡಿ. Now come to 496, 4968 of 2024.
968. Your lordship sees, my lord, annexure B at page number 22.
Yes.
And my lord, this is a complaint which is addressed to Devanhalli police station. And this is once again, my lord, by one Srimati Bhavana Sadhwani Raju Sadhwani. I have an advance submission to make in this case. Your lordship sees, my lord, annexure D, which is at page number, my lord, before I take your lordships through the complaint in detail, see, my lord, annexure D, page number 24. It is the same person, my lord, who joins.
Yeah.
Now, my lord, your lordship sees page number 24. Well, these are all the set of home buyers who would, my lord, some of them would go to consumer court, some of them would go to, my lord, police station, some of them would go to RERA. They take, my lord, orders everywhere. Dehearts that, my lord, this very complainant would also join hands with, my lord, one my lord, frontier by name Mr. Sethuraman Madhavan. And 183 others. Your lordship sees page number 24, my lord. They would go to NCLT. Precisely, my lord, claiming to be the financial creditors because, my lord, the IB code, my lord, permits an allotee of, my lord, a real estate project to be a financial creditor. They would seek, my lord, our resolution process by initiating CARP against us. NCLT hears us in detail, hears them in detail. Initially, NCLT was pleased to dismiss their, my lord, application under section 7 of IBC. They go to, my lord, NCLAT. The Honorable NCLAT, my lord, would appreciate and say that the NCLT may give a real look at, my lord, the matter was remanded back. After the remand, my lord, we have argued extensively. And my lord, my learned friend who is on the TV, my lord, is the lawyer for that.
TV?
Yes, my lord, here on the VC.
Screen. Sorry.
Is the lawyer for that. And the matter was reserved for orders. Last week, they went to Supreme Court on 29th of last month and seek a direction from the Supreme Court that the NCLT has reserved the matter, is not passing orders. Now, the Honorable Supreme Court passed a docket direction that we are sure that the NCLT will pass an order. The matter is today. It's, my lord, the orders have to be pronounced anytime, my lord. We are waiting our fingers crossed.
Before the NCLT.
Before the NCLT. Now, my lord, the cascade of that would be this. If the NCLT says, yes, you are all financial creditors. Because, my lord, there is a certain number of qualifying, my lord, people who have to join to go before NCLT. And, my lord, it's their case that they fulfill the qualifying number. My lord, our case that they don't fulfill the qualifying number in any which way. The core of the dispute remains that they are claiming to be the financial creditors, that we have given money to the real estate developer. The company has become, my lord, literally, my lord, the company has gone disabled to fulfill its my lord, promises. Ozone. Therefore, the company has to be admitted to resolution process, insolvency resolution process. Now, my lord, your lordships are kindly aware, my lord,
We have argued enough number of insolvency resolution process arguments before this honorable court. Now, my lord, if the resolution is possible, the resolution will be done. An RP is appointed, my lord, they'll have to file their claims before the RP. RP, my lord, will see, will take over all the properties and, my lord, try to distribute or, my lord, try to resolve the issue. If, my lord, no applicant comes to take over the company, then the matter has to go in for liquidation. The company will get into liquidation, my lord, the waterfall mechanism, whatever the assets of the company is taken over, my lord, it is then diluted and
ಈ
distributed.
ವಾಟರ್ಫಾಲ್ ಮೆಕ್ಯಾನಿಸಮ್ ಮುಂಚೆ ವಿಂಡ್ಫಾಲ್ ಆಗಿದೆಯಾ?
I'll come to the windfall, my lord. This exactly is the windfall. Now, what has happened is precisely this. They go before NCLT and say, we are all financial creditors. We have invested and given our monies. And the company has become unable to function in terms of whatsoever because they have financial distress, etc., etc. Now, my lord, my primary question is, when you go before NCLT, you say that, yes, I have invested money in this corporate entity. It has gone disabled for various reasons. Not, my lord, at least for criminal offences. Now, when you have that argument before the NCLT and you have successfully hit the end of the proceedings waiting for a judgment today, could you have still prosecuted a parallel complaint against me by saying, no, no, you have cheated me? If you have cheated me, then there is no question of you climbing as a financial creditor before NCLT, number one. Number two, are you climbing to be, my lord, an allotee of a project before RERA court and say, please give me this justice? My lord, RERA court has also passed several orders and your lordships have granted indulgence, my lord, directing the revenue recovery in these matters. My lord, there are a certain number, my lord, your lordship's judgments, my lord, we appealed it before the Honorable Supreme Court. Till the Honorable Supreme Court, my lord, your lordship's judgment was
Which one?
upheld.
That fees that was charged, Radha?
Allah, my lord, there was revenue recovery proceedings.
Houdu.
RERA passed, my lord, several orders. And, my lord, RERA directed the Tahsildar.
I said civil court has no jurisdiction.
That, my lord, is one indulgence which your lordships granted in our favor because they were also trying to enforce the award before the civil court. My lords have, my lord, now laid down law that civil court cannot enforce, my lord, an order of the RERA because it's not a decree. Parallelly, they went before, my lord, RERA Enforcement Authority. RERA Enforcement Authority directed the DC, District Commissioner, to recover, my lord, the order of penalty by way of arrears of land revenue. Now, that order, we challenged it before this honorable court. They also came before this honorable court saying that, no, 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 the revenue authorities are acting partisan. They are not doing.
Oh, that matter where you appeared, Radha?
Not my learned friend Velan. My learned friend Velan was not in the fray.
Velan alla. Reynolds had appeared.
Yes. Now, your lordships, my lord, issued a direction to the state revenue recovery authorities. Now, you will have to do it. Now, my lord, there is an attachment on that. My lord, that story apart. My lord, for me, the reason for me to say this is this. Limited reason. Now, you go before RERA authority. There you project yourself, yes, I am a bona fide allotee. And there is a project which has not hit its end. Therefore, I am entitled for penalty and recovery of my money. And which has been executed, my lord, through a judgment of this honorable court. Number one, you go before, my lord, the NCLT, say you are a financial creditor. How many clocks you want to wear? And at the end of the day, you go before the police and say, no, no, I have been cheated. I mean, like, can somebody have these multiple, either you are cheated or you are put to a distress by a civil action.
Correct.
Now, your lordships, my lord, a number of judgments, my lord, I don't want to cite that, but my lord, we are greatly depending on your lordship's judgment, my lord, in a couple of cases where my lords have held that the allottees cannot be satisfied in the beginning about the color and the edifice of the project, and later when the project is not delivered, come and say you have cheated us, etc., etc. Because, my lord, your lordships have cited even that Muhammad Ibrahim's case where the intention of cheating has to be traced at the beginning. My lord, today the ground reality is this: the buildings are very much existing, and many of these very complainants do live in that very community. Kindly, my lord, look at this. Now, you are living there in one of the flats and you say another flat or etc., etc. My lord, not everybody, at least some of them say, I have invested in this flat also. It's not complete. Now, my lord, if the flat is not complete, the apartment is not delivered. Apartment is not delivered. Where is the question of, my lord, the builder cheating? And all this happened, my lord, during the COVID, my lord, regime. Now, my lord, after the COVID, the central government particularly came out with a plan only to the builders where the projects are, my lord, promisingly completed to an extent, but, my lord, they have been, my lord, they had hit some roadblocks due to the paucity of funds. The central government directed, my lord, the RBI to search out a plan. RBI in turn, my lord, had talks with the SBI. They particularly floated a fund called SBI Swami Fund.
Swami,
It's called, my lord, very strange name. I was also, my lord, a bit confused. It's called Swami, but the spelling is not SWAMMY. It is SWAMIH something. Right? It's an acronym. Now, the qualifying factors to be entitled to claim, my lord, benefits of Swami Fund was very stringent. And this was also one of the companies, my lord, which qualified because the bank came, inspected. Yes, there is a lot of progress. My lord, in fact, we have placed, my lord, a lot of, my lord, glaring pictures, which are not, my lord, AI generated, but real pictures at the site. And your lordship, I remember, had directed a spot inspection, my lord, in one of the cases pertaining to very ozone. A party directed by the Honorable Court went, placed a report about what are the buildings that are done, half done.
that is old age home,
Exactly.
not this. That is in 2022.
Well, it's a continuation of the
Correct.
same.
That direction I gave in 2022 concerning an old age home. What are the amenities that you have given?
Yes.
And what have you projected? What had you promised? That inspection, then I passed some order in that. Yes.
It's the inspection, my lord, party did not say anything tragically against us. Inspection party simply said, yes, the project is underway. The project has hit some roadblocks. It was not that, my lord, it was at still ground level, my lord, we gobbled the money and ran away to oblivion. That was not the case. Now, my lord, I have to ask myself with great introspection that you go to RERA, there your story is, yes, project complete but delayed. I want compensation. You go to NCLT, there the story is different. I am a financial creditor. I want the resolution of the company. My lord, I'll pause here, my lord. Your lordship knows this, but my lord, for my satisfaction, may I say this? My lord, when you are seeking for the resolution of the company through a corporate insolvency resolution process, the admitted, digested fact is this: there is a corporate entity which is functional, but it has hit some roadblocks. It cannot be functional anymore. Therefore, a resolution professional has to be appointed to sail the company out of, my lord, the rough weather. This is what, my lord, is the core of, my lord, insolvency resolution process. The resolution process professional, my lord, will call for bids. If somebody is interested to take over, they will come and take over. And if it is not possible,
process gota then, madam.
yes, my lord. Now, my lord, the reason why I am putting this question to myself is this, my lord. Now, you agree that the company has hit disabilities. It is not your case that somebody has cheated you. Now, where is the question of raising a complaint against me? And on the basis of this complaint, my lord, your lordship may kindly appreciate this. The disastrous action, what they do is they get this complaint registered, and on the basis of this very complaint, my lord, they would go sit in Delhi and sit in front of enforcement directorate officers. Yes, my lord. And they say, look, there is a predicate offense, initiate ED action against them. Now, we have come before your lordship, my lord, in the ED case.
ED acts like that, is it? On somebody going and sitting.
Exactly, my lord. Yes, yes. I think my learned friend, Mr. My lord, Velan was saying that it's because of me the ED has committed for. No, I don't think, my lord,
Complaint. Well, it's maybe because of the complaint, not because they went and sat in front of
high
it.
time start wearing a cap, because I'm going to give you a lot of feathers to be kept in your cap.
All right, all right.
Now, my lord, now the claim is that ED action is because of me. Now the ED goes ahead, confiscates all the properties. Kindly, my lord, look at, my lord, it's not a cherry on the cake, my lord, it's a black mark on the cake. Now,
black mark on the cake.
Yes, my lord. Now they have made the cake inedible totally. Now this is what they have done. Finally, my lord, we have hit such a roadblock. We are trying to sail through, my lord, the NCLT, the consumer courts, the RERA, etc., etc. And now they have made the ED confiscate all the properties, including the project.
Oh.
Put me under, my lord, a caliper of this nature and say, you've still committed crime. My lord, either I commit a crime, I cheat and run away, my lord, by like some companies, my lord, like Manjog, etc., Anubhav Plantations, etc., etc., or I am still available to you for your resolution process. My lord, ED has attached all my properties. My lord, if had I taken this money from them, according to them, had I taken this money from them, used it, my lord, by way of criminal breach of trust, cheating, etc., etc., where is the question of ED taking over, my lord, by passing an order? Yes, this is the property earned out of these proceeds. Now we consider it as proceeds of crime. Now we are confiscating. Now they can't blow, my lord. It's not just, my lord, hot and cold. My lord, it's hot, lukewarm, warm, cold, ice cold, extremely cold.
Hot springs.
Hot springs. I don't know. My lord, the only place they have not troubled me is, my lord, in the space.
ಅಲ್ಲೂ ಹೋಗಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಏನಾದ್ರು ಇದ್ದಿದ್ರೆ ಅಲ್ಲೂ
ಅಲ್ಲ,
ಹೋಗ್ತಾರೆ.
ಅಲ್ಲೊಂದು ಓಝೋನ್ ಏನಾದ್ರು ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ದೀರಾ?
There is a space station, my lord, where they could
No,
raise a complaint. They
No,
would, my lord,
because
generously do that.
are you being true to your name? You have something there also.
My lord, this is
Ozone.
the only place, my lord, yes, the only place where they have let me, my lord, not, they let me still
Shamsundar
live.
sir, your name, company's name is Ozone.
Ozone, my
The
lord.
allegation is there is only carbon dioxide.
Carbon dioxide. No, my lord, I am now trying to show, my lord, it's not that carbon dioxide, my lord, I also, my lord, give oxygen and only emit carbon dioxide in the nights.
Oh.
Kindly look at this, my lord. You put me, my lord, in a sanitary pit.
Huh?
My lord, there is only methane is there, my lord. By all these actions, and still want me to, my
So
lord.
why do you want to get into the soak pit?
What to do? What to do, my lord? I am ozone, but they have put me in, my lord, a pit of methane like this. My lord, arm twisting is something which I understand. My lord, this is not just arm twisting. This is, my lord, twisting the entire body.
Body twisting.
Yes. Ringing, my lord. Ringing. WRINGING, my lord.
Gottaಯ್ತು.
Ringing. Yes. Now, my lord, this is where, my lord, my lord, let me just take your lordships back. I was just, my lord, showing to your lordships page number 24. I have, my lord, appended this petition, my lord, before NCLT to show to your lordships what is the version before the NCLT. Now, this petition, my lord, is much prior to the criminal complaint what they raise against me. Now, Annexure B, my lord, page number 22 is the criminal complaint which is on page number, my lord, Annexure B, 31/1/2024. The approach to the NCLT and RERA are all much prior to this. Now, my lord, they are waiting.
So, yes, sum and substance
Some
is this.
substance, your lordships rightly understood, my lord. I am not going to say anything
Going
more.
before all other authorities,
Exactly,
securing
my lord.
order, whatever, and setting the criminal law into motion is an abuse of the process.
It's an abuse. I want to only show to your lordships the name of this gentleman.
Which gentleman?
The one who is, my lord, the complainant, my lord, in this Annexure B, which is on page number 22. They are Bhavana Sadhwani and Raju Sadhwani.
ಏನಾಯ್ತು?
All ಅವರು NCLT ನಲ್ಲಿ ಇದ್ದಾರೆ, ಅವರನ್ನು ಪಾರ್ಟಿ ಅಂತ ತೋರಿಸೋದಕ್ಕೆ.
Admitted fact, they will not deny it.
They will not deny. They will not. I don't know, my lord, this complainant is being represented independently or not.
You don't worry, sir. Yes.
One second. Allow me. Your lordships also sees for a moment, my lord, a previous complaint that was lodged. My lord, I'll just show two other documents for my satisfaction. My lord sees page number, my lord, 77. My lord, this is one more thing which, my lord, your lordship sees page number 77.
I am there.
Like ED, NCLT, RERA, consumer. My lord, there is one more. They now go before, my lord, a KPID court, Karnataka Protection of, my lord, Interest of Depositors Act. Same, my lord, same people. Same gentleman, same crowd. They go before, my lord, the special court and say, my lord, one more new clock. We are the depositors. They are the deposit collectors. We have given them deposits.
ಅದು ಸ್ಟೇ ಆಗಿಲ್ವಾ?
Stay agide.
ನಾನೇ ಸ್ಟೇ ಮಾಡಬೇಕು ಇಲ್ವಾ?
Yes. Then they say, now initiate KPID action. And, my lord, the principal judge happily referred it.
ಅಲ್ಲ, ಅವ್ರು ಮಾಡ್ತಾರೆ.
Yes. Then your lordships granted indulgence. Now, my lord, can this be done? Can this be, my lord, can this, my lord, hydraulic press be, my lord, so strong that you punch me from every corner and finally, can my lord, appreciate my status, my lord? Amid all these things, recently is what I was, my lord, trying to argue when the learned ASG was here. Amid all these things, my lord, now the latest development is this. My lord, that may have the effect of wiping out all these things. Now, what has happened is this. My lord, your lordships, my lord, could recall that Unitech case was going on before the Honorable Supreme Court. The Honorable Supreme Court, my lord, enlarged its jurisdiction and say, let us look at what all the builders of the country, all across the country, who have been unable to deliver projects. Now, CBI directions were issued to CBI. Please go and make an investigation. CBI, my lord, for the namesake registered, my lord, for the record sake, sorry, my lord, for the record sake registered a case. I wouldn't say namesake. For the record sake registered an RC, came to us. Now, my lord, they sat, my lord, quite gentle. They sat with us.
Quite gentle, huh?
Quite gentle, my lord. CBI, my lord, they have been generally gentle, my lord.
Yes. ಆಮೇಲೆ
Then, my lord, they sat with us. We gave them all the details. My lord, they left with all the broad smiles that we will place all these documents before the Honorable Supreme Court.
Year to year.
Yes. Then what has
Broad
happened?
smile.
Yes, my lord. Now, the Honorable Supreme Court said, now let us go case by case. We'll appoint an amicus. My lord, there is
ಅದು ಯುನಿಟೆಕ್ ಕೇಸಲ್ಲಿ.
ಯುನಿಟೆಕ್ ಕೇಸ್ ನಲ್ಲಿ ಇವರು ಎಲ್ಲ ಹೋಗಿ ಸೇರ್ಕೊಂಡಿದ್ದಾರೆ.
ಇವ್ರು
Yes.
ಯು ಆರ್ ಬಿಫೋರ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್?
Yes. Precisely, yes.
Wait.
My lord, rightly or wrongly they are there. My lord, of course, wherever they want to make their beans, my lord, let them go. My lord, I have no issues with that. Now they have gone there, and we have given a detailed plan to the amicus. We have given a detailed plan to the amicus. Now the learned amicus will have to place it before the Honorable Supreme Court and say, this is how this company want to.
ನೀವು ಒಂದ್ ಹೇಳಿ, ಈ ಹೋಮ್ ಬಯರ್ಸ್ಗೆ ಫಸ್ಟ್ ದುಡ್ಡು ತಗೊಂಡಿದ್ದು ಯಾವಾಗ?
My lord, this
In which year?
My lord, that is different home buyers. My lord, different.
All right, approx.
My lord, could it be sometime during, my lord, 16 and 17, my lord, before the COVID? Before, my lord, there is something more which I want to say, because it fell from your lordship. My lord, may I clarify this?
I'll withdraw that.
No, my lord. I remember there's something very interesting, my lord, which I want to say. Kindly bear with me only for one moment. It is not, my lord, this home buyers gave 100%. I'm not saying, my lord, they did not give. Many of these home buyers came under subvention scheme where your lordships have delivered some judgment. Many of that was subvention scheme where they would, my lord, fund only by 10 or 20%. Remainder would be funded by banks. Now it became 100%. Now my undertaking to them was, I will pay your EMIs. So you are spending literally not excess than 20%. Now what happens? Bank funds. Bank gives me the money and, my lord, I put it into the project. Now today there are as many as more than 300 petitions that are pending before a coordinate bench of this honorable court, where they go and say, look, we are the signatories for this loan agreement. Now the very unit which was to be sold to us is kept as a collateral security under the SARFAESI. Now the bank is initiating SARFAESI recovery against us. Please stay. This honorable court granted an order of stay that there should not be any recovery against them. Now kindly, my lord, look at this. So there is no recovery from them, and it is the bank, my lord, which has funded the project. Now the bank has gone against me by way of criminal complaints, number one. Number two, my lord, before the coordinate bench of this honorable court, we are asked to give a plan. Bank has, my lord, agreed, at least, my lord, 70 of the home buyers, they come and say before the court, now we are good to return the unit and let the bank acquit us. That's more than enough. And I don't think, my lord, they can differ from this. Mr. Velan was not a party to this. My lord, I will be able to give a list of all of them, at least more than 70 of them.
No problem. Now that is.
They have gone out of the project.
That is a little besides the point.
Yes, my lord. Now, my lord, the only reason why I said
now
this.
Diving back to the facts.
Coming back to this, my lord, can a criminal complaint, that too, my lord, I am not going to rely upon the judgment of, my lord, the race club, but still I would say
406, 420.
Technicalities, my lord, I don't want to hang. My lord, I am on ethical grounds. I am on, my lord, moral grounds. My lord, you say I am criminal breach of trust. You say I am a cheat. And you say I am a financial debtor. You say I am a real estate project. I'm a real estate, my lord, company who has to take, my lord, branch from the RERA tribunal. My lord, therefore, my humble submission is these criminal actions, my lord, is nothing but a redundant, my lord, remedy that was opted for by them. And my lord, they have been able to squeeze me more than enough for this. And now, my lord, as a result of this, the ED action against me, my lord, in fact, I don't know, my lord, who gave them this advice. They have nailed on their own toe. Now the ED. Yes. No, my lord, the ED has taken over the entire property. What is that they are going to get out of me? At the end of the day, my lord, I ask this question.
Attach ಮಾಡಿದೀರಾ?
Yes. That's what is the main petition.
Sale ಮಾಡ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಡಿ ಇವರಿಗೆಲ್ಲ.
Challenge, my lord, the challenge is to the provisional attachment order.
Anyway, that we'll see. Now ಅಷ್ಟೇ ಅಲ್ಲ?
ಈ ಕೇಸ್ ನಲ್ಲಿ ಇಷ್ಟೇ, my lord. Should I hold the bench, my lord? Can I continue tomorrow, my lord, on the reminder?
Continue ಏನು ಮುಗಿತು ಅಷ್ಟೇ, ಎಲ್ಲದರಲ್ಲೂ ಅದೇನೆ ಸೇಮ್
ಇಲ್ಲ, ಇಲ್ಲ,
ಸಬ್ಮಿಷನ್.
ಬೇರೆ ಇದೆ.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಏನಿದೆ?
ಇನ್ನೊಂದ್ರಲ್ಲಿ your lordship sees, my lord, the next case 27587.
Predicate ಮಾತ್ರ ಮಾಡಿ.
ಅಷ್ಟೇ ಸರ್, predicate 445, my lord, that's the reason.
No problem, sir. Why are you worried?
I have to be on my, my lord, legs before the honorable CJ, my lord, for a parted matter.
ಇದೆರಡು ಆಯ್ತಲ್ಲ.
Kindly, my lord, have it tomorrow, my lord. I'll
No problem. In these two matters, I'll hear Velan.
In these two matters, your lordships are hearing.
But I'll need just 5 minutes for.
I will
Both
also
of you
be
are here.
succinct. I'll also be succinct. I'll not take much time.
Yes.
I'll just
In these
sanitize.
two matters, my lord.
Yes.
Strictly in these two matters.
Oh, all right.
And also in 1.5, the
ಅಲ್ಲ 1 point. Velan, you are there in 1.3.
3 and 5.
You argue in 3 now. Yes.
Before that, can I, Lord, I have some mentioning. In the item 1, I will just.
ಅಲ್ಲ
take
ಪ್ರಿಡಿಕೇಟ್ ಇದ್ರೆ ನೀವಿದ್ದೀರಾ?
ಅಲ್ಲ, ನಂದ್ರಲ್ಲಿ CBI case ಇದೆ.
Yes,
There is
for
a-
that my
there is
answer
a-
would be.
There is a CBI case which is registered pursuant to Supreme Court direction.
Now, for
And
that
I have-
my answer is, my
and
lord, that
that
CBI
is my
case is
case.
not about the proceeds of crime. It is not about the proceeds of crime.
ಒಂದು ನಿಮಿಷ.
After the investigation.
Where is the law that the predicate offense should be proceeds of crime?
No, my lord, now, my lord, there is a direct judgment on my lord. In fact, my lord, if all the predicate offences die, a subsequent offence, my lord, subsequent to ECIR comes into existence, that can also, my lord, anchor the ED case.
Lord, the
My lord, for that
petition-
the reason should be, for that the core should be that there should also be proceeds of crime in that, my lord. That CBI case directed by the Honorable Supreme Court, my lord, does not have a component of proceeds of crime.
Lord,
It
his
cannot
entire
anchor the
case
ED case.
is premised on the ground that all the FIRs registered by the state police is quashed. I'm fine with that. But I have updated my
CBI
ECIR with the CBI case. Lord, which is directed pursuant to
ಎಲ್ಲಿ
Supreme Court
ಕ್ವಾಶ್ ಎಲ್ಲ
direction.
ಆಗಿದೆ ಸ್ಟೇಟ್? ಎಲ್ಲಿ ಕ್ವಾಶ್ ಆಗಿದೆ ಯಾವ್ದಾರು?
That is what he claims.
ಕ್ವಾಶ್ ಅಲ್ಲ,
But
ಕೋಆರ್ಡಿನೇಟ್ ಬಂದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೆ ಎಲ್ಲ.
I disregard that. My ECIR number 1 is validated by the CBI registered case, which is in respect of a scheduled offence. Therefore, my lord, I am entitled to conduct investigation. As part of the investigation process, I have attached the provisional, I have provisionally attached
All the properties,
The
huh?
properties, only 3 properties, only 3 properties I have attached. Lord, he has to approach the adjudicating authority and
What is challenged in the attachment orders?
Yes, before your lord.
therefore, writ petition is not maintainable. JSW principles will apply. There is no doubt about the
ನೀವು
existence.
ಹೊರಡ್ಬೋದು ಅಷ್ಟೇ.
Illa, that,
ಅವ್ರನ್ನ
my lord,
ಕೇಳ್ತೀನಿ.
it's bit debatable, my lord. Let the learned ASG be there, my lord. Here tomorrow, my lord, I'll have to, my lord, make my submission.
Tomorrow he will be there. Now he is going.
Now, my lord, yes,
Ah,
he
Velan.
can be relieved now.
Yes, Velan.
Can I be excused?
Yes, yes. You want to be excused?
My lord, yes, my lord. My lord, I'm hopeful, my lord, your lordships are accommodating me tomorrow, my lord, for the rest of the matter.
Yes, sir.
Greatly.
Yes, Velan.
It's better. Yes,
You
it's
finish
better.
your argument.
Yes, my lord, it's better, my lord, I'm not here. Otherwise, my lord, brick bats will start again.
No.
No, don't.
Anyhow, my lord, it was a compliment.
No
for you.
brick,
It's quite
no bat.
formidable, my lord, that's the reason.
Lord,
My lord, may I
I
take
will
leave?
strictly-
Greatly obliged.
Yes. My learned senior has made a number of factual assertions. My lord, I would start by sanitizing all of them.
Ah.
Right, my lord. I take my lordship to a small spiral binding which I had circulated to my lordship with yesterday.
Yes. Is it right?
Yes, my lord.
Ah.
Now, my lord, what is the modus operandi? The modus operandi, my lord, is my lordship may take the daily orders in 245. My lordship may see the index.
Page.
My lord, summary of cases in page 1 to 5.
Yes.
And daily orders in criminal petition 245 / 2022. Kindly take page 8.
Page 8.
Yes, my lord. A submission is made stating that we are intending to enter into a settlement. In lieu of the same, a stay is granted. Now, my lord, that particular petition is kept pending, which ultimately culminates, my lord, which my lordship may see in page 13. It says, in view of a joint compromise between the parties, the said FIR stands quashed. In the intergum period, my lord, now I take my lordship to page 19. That is the second FIR. A submission is made. My lord, the last 10 lines, the learned senior counsel would submit that the court in a petition in criminal petition 245 of 2025, the same petition, my lord, which was stayed on a submission that we are entering into a compromise, filed by the petitioner number 2 herein by order dated has been granted an interim order staying further proceedings, and therefore he seeks the same relief. In furtherance of the same, devoid of consideration of the merits, a stay is granted. Now I take my lordship to page 68. In fact, my lord, page 77.
70?
My apologies, my lord, at page 71. My apologies, 71. The last 4 lines. The allegations made in the complaint appear to be contractual obligations of petitioner. It is also noticed in a set of home buyers complaint lodged before Kodihalli police station, that is 245, is stayed by the coordinate bench of this court. Considering the said facts, the learned senior counsel made out grounds for grant of interim relief. Now, based upon the second FIR which you have got it stayed, a third FIR is stayed. Now I take my lordship to page 73. In the bottom, my lord. The learned is my lordship with me, my lord, 73.
73 is over, 77 also over. Next.
Yes. Now I take my lordship to page 81.
Yes.
These are affidavits, undertakings given before different courts of this court. None of them has been complied with till date. Now, my lord, this is the classic case of Senthil Balaji. My lord, I take my lordship to the judgment of the apex court in Senthil Balaji's case.
Hello, it mugsbidi. Finish this.
My lord.
Finish narration of this summary.
Yes, my lord.
Now come to page 85. 86.
Yes, my lord.
89. All before the division bench.
Yes, my lord.
Challenge to the RERA proceedings.
Contempt proceedings.
Contempt proceedings.
5 affidavits given.
Yes.
Stating we will deposit the money. Till date, not a single affidavit has been complied with. The affidavit is at page 100. That is 92 to 200.
It's still pending?
Still pending.
Contempt is still pending?
Contempt is still pending.
Yes.
103 is a list of affidavits, undertakings filed by the petitioner here in This is in essence the modus operandi. Now I take my lordship to the essence of the allegation. What is the prima facie case? My lord, the test is whether on reading of the complaint, a prima facie case is made out.
Idu bari crime charge sheet agidya.
All of them have been stayed.
It's only in crime stage.
In crime stage.
Yes.
Yes, ma'am. Can I take my lordship to in writ petition 4968? That is point 1, my lord.
I'm holding.
Yes, my lord. At page 81, this is one of the complaints given by a large number of home buyers. I take my lordship to page 81. Paragraph 16, 17, 18 and 19, my lord. This would demonstrate that after obtaining money from us home buyers, the same was systematically transferred to other group companies. A list of the same forms part of ED's ECIR also. It is admitted that 30% of the money which is collected from us is redistributed, rescheduled among other people. My lord, in essence, the allegation is this. In fact, my lord, there are a large number of home buyers who had initially taken loan, subsequently repaid the same because their CIBIL scores crashed. There's a large number of people who have already paid. In fact, my lord, not a single one of them have got a flat till date. Few of the buildings do not have OCs. In fact, no buildings has OCs. My lord, can I take my lordship to the judgment of the apex court in Senthil Balaji's case, because it would at 348, my lord. My lord, this was a case where, my lord, large number of people were duped with a promise of an employment. My lord, in the state transport corporation. What the then minister,
the transport minister.
Yes, my lord. He was the then transport
minister.
Yes, my lord. He set up few petitioners who are amenable. They register an FIR. He enters into a settlement. Consequently, the same was quashed. It went to the Honorable Apex Court. My lord, at page 348. Thus, it is very clear from the march of law that court has to go slow even while exercising jurisdiction under 482 or Article 226 of the Constitution in matter of quashing criminal proceedings on the basis of settlement reached between the parties when the offence are capable of having an impact not merely on the complainant and the accused but also others. As seen from the final report filed in the case, the counter affidavit filed by the IO, persons have adopted corrupt practice to secure employment in transport corporation under 2 headings so and so. Therefore, if belonging to the second category are allowed to settle their dispute by taking refund of the money, the same would affix a seal of approval on the appointment of persons belonging to the first category. Therefore, the High Court ought not to have quashed the criminal proceedings on the basis of the state proceedings. Also, my lord, paragraph 57, which says As a matter of fact, the state ought to have undertaken comprehensive investigation into the entire scam without allowing the accused to fish out one case as if it was a private money dispute. My lord, in the instant case, my lord, the petitioners have not been subjected to investigation by any agency. Every FIR has been stayed on the basis of the sequence of events which I had narrated. Now, my lord, I take my lordship. My lord, my learned senior made a reference to race course judgment.
Only race club.
Race club, sir.
Hmm.
With regard to 406 and 420.
That's
recently it was clarified that at the stage of FIR,
I have myself done that. Yes.
yes, my lord, 406 and 420 can.
406, 420 at the crime stage, no.
Yes, my lord.
Charge sheet admal ನೋಡೋಣ.
In fact, even the Delhi High Court as well as the Allahabad High Court.
Oh,
have
I
followed
myself
suit.
done it last week. Yes.
Yes, my lord. Now, I take my lordship to the first judgment, that is Vijayaraj Surana's judgment. My lordship may be aware. The Madras High Court judgment, wherein which a question, the list before the court was whether on a basis of a technicality, if a predicate offence is stayed or quashed, would it be a basis for quashing of the ECIR?
The umbilical cord is not cut.
Yes.
Is what is said by the Madras High Court.
Yes.
Yes.
It is also said by the Punjab and Haryana High Court as well as the
Yes,
Delhi
sir.
High Court.
Next.
Well, now a reference was made to a number of the proceedings before the Honorable Apex Court. But I have made a compilation of all the orders passed by the Honorable Apex Court in the same.
That Unitech case.
Unitech, yes.
Kodiyat.
At page 41, my lord. At page 40, paragraph 1.
Now, even if this has emerged, how does it impact the investigation?
No, my lord. I just wanted to bring the complete set of facts before my lordship that what the Supreme Court was seized of a similar set of sequence of event adopted by other builders, whereby a large number of public has been scammed. In such circumstances, what the Honorable Apex Court did was, my lord, it passed certain directions to the CBI.
Now, you neither have money, neither have the flats,
Yes, my lord.
and are facing surfacey proceedings.
Yes.
Because that is now invested in a subvention scheme. That's your situation now.
Yes, my lord. In fact, my lord, the human cost is very heavy. My lord, I met one of the such home buyers. Both the husband and wife happens to be majors, has to be major in Indian Armed Forces. Their retirement benefit has been swindled.
And that is what.
Flat not given. The husband is suffering from cancer. The wife is running behind pillar to post. Now, this is a case with a large number of people. My lord, in fact, he has admitted in his investigation, my lord, which forms the basis of the ECIR, that at least 30% of the same I have diverted. In fact, my lord, my learned senior made an assertion saying all my properties are attached. But before attachment, he has encumbered all the properties with all financial institutions. There is nothing to be encumbered. Even if I have an order from RERA, it is incapable of execution because there is nothing left in the tank. Unless, my lord, the source of money where it has been diverted is obtained, my lord, there is no way the home buyers will be in a position to get anything out. In fact, my lord, the Honorable Apex Court, in the backdrop of though an insolvency proceedings held, my lord, this should not be looked as a commercial transaction. In fact, my lord, right to shelter is a fundamental right under Article 21. My lord, a very latest judgment. The internal page 23, my lord. At 20.
You need not read the whole thing.
Yes, sir.
Para 20 is enough, I guess.
In fact, my lord, till para 20.5.
No, till 20.5, but 20 is what right
Yes.
to life.
Yes, my lord. Hence, an argument to the extent stating it is only commercial, my lord, would not suffice. In fact, my lord, my learned senior has, I believe, borrowed his arguments from my lordship judgment in the Mantri case.
No, that is only one home buyer.
Yes, my lord. And also, my lord,
Mantri's case is different for
Yes, my
this
lord.
reason.
He had
All others had taken the flat, only one person wanted a particular flat, a particular thing to be given.
Yes, my lord.
That I said that cannot be done. 406, 420 would not arise for, not when it is a large scale home buyer problem.
Exactly, my lord.
Only one person was there, if I remember.
Yes, my lord. In
He
fact, my
appeared
lord,
party in person. That's in 2023.
yes, my lord. In
Yes.
fact, in that case, my lord, a submission was made that we have executed the sale deed, we are ready to execute the
They're
sale
ready
deed.
to execute the sale deed and he was not ready to take it.
Exactly, my lord.
Then I said, with all this 406, 420 will not come.
Yes, my lord.
That has nothing to do with it.
Yes, my
This is a different problem.
lord. My lord, in fact, as far as point 1 and point 3, point 3 is concerned, we have paid the money in whole,
Completely.
completely. One is a senior living.
How many home buyers have paid the entire money?
A large number, my lord. The total scam size is somewhere around 2,700 to 3,000 crores. There are other projects, the number could be higher. In fact, my lord, one such other transaction, they buy a land, a parcel of land from Rahejas for 400 crores approximately. The very next day, encumber it with Yes Bank for 600 crores. And not a single stone is laid till date. All the buyers are in lurch again. The modus operandi is this way. My lord, even the functioning of RERA will have to be taken into consideration. RERA gives you approval, but before the approval is given, all the properties are encumbered. The same is not taken note. Money is dispersed without any construction. This is all completely in the teeth of statute. And we are forced to pay the EMIs. In fact, my lord, what has
Of course,
happened?
that is there. SARFAESI proceedings are initiated against every home buyer who has not received, who was not into the homes at all.
Yes, ma'am. In fact, my lord, there are many instances where there are double sales. Same flat is being sold to a number of persons. Now, my lord, they have come up with a different scheme. The parcel of land, which was supposed to be where the construction was supposed to happen, they sell it to some other group with the approval of the RERA. They did so with Satwa. The same very parcel of land, the flats for which we have paid money was supposed to be built. The same is also not done.
All right. Yes. Actually, you finished all the cases, right? Same.
My lords, 1.4 I represent the complainant and respondent 2 minutes. In
ನಿಮ್ದು ಬೇರೆ
1.4
ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ?
ಹೌದು, this is totally a different complaint, my lords. This is
What's your
basically where
complaint,
there is a double sale. There is a double sale of units, my lords. ಇಲ್ಲಿ ಏನಾಗಿದೆ, what the second respondent unit
ಆಯ್ತು,
has been.
ನಾಳೆ you do it tomorrow.
Very well, my lords.
Yes.
In fact, Puneet Bariwala's case would also come into my aid. But can I take my lordship to one page of the compendium of cases of the Supreme Court orders which I have?
Which judgment?
Not judgment, my lord. The orders.
Yes. Page
232. Paragraph 10. Mr. Rajiv Jain, learned amicus curiae, has submitted a very comprehensive status report comprising 2 volumes. It delves into the details of the actions of 7 banks, financial institutions, particularly the circumstances surrounding ozone projects and further course of action. The report provides an in-depth analysis of the role of banks and financial institutions, leaving the landowners with very little resource but to agree to the terms of the respective agreements. In many tripartite agreements, the banks have ample power to move against the builders for recovery of the money. They can also fulfill the refund from the builders if the unit is abandoned by the purchasers, while the builders are only entitled to retain the earnest money paid by the purchaser. The report shockingly reveals how unfairly the home buyers or the landowners have been treated. In fact, my lord, the entire sequence of events, my lord, which is enumerated in this number of judgments of the apex court, my lord, the apex court has expressed anguish. My lord, can I only mark the relevant pages, my lord, so that?
Yes, it will be helpful, please. Take it. Mark the pages. Yes. Yes, madam. Nale. Tomorrow we'll continue. 2:30.
Please.
ಚೌಡ ಸರ್, ನಿಮ್ 2:30 ಯಾವ್ದಾರು ನಾಳೆ ಹಾಕದ್? ಅಲ್ಲ ಇವತ್ತಲ್ಲ, ನಾಳೆಗೆ ಯಾವ್ದಾರು ಹಾಕಿದ್ದೀನ?
Yes, my lords. One matter is posted tomorrow.
Which
my
one?
lords.
That's in fresh matters. Huh?
Fresh matters.
Not at 2:30.
No, not at 2:30.
This I'll take DA case. Arbati sir, I'll just finish the 2:30 mood matters and take it. Yes. ಎಷ್ಟಿದೆ ಮೇಡಮ್? 3 ಅಷ್ಟೇ. 2:30 ಮೂಡ್ ಮಾಡಿ. ನಿಮ್ದೇ ಫಸ್ಟ್ ಅಂತ ಗೊತ್ತಾ?
Saw the list. Lords, in this case, my lords, what has happened? Lords, custom offense. Lords, I'm accused number 2. Lords, 22 lakh amount of lords worth I'm taking my lords to Dubai. I'm caught. Lords,
22 lakhs you're taking?
I'm taking to Dubai. My
22 lakh dirhams or what?
No, in
Indian currency?
Illa,
Foreign
dollars.
Foreign currency.
Foreign
Yeah,
currency.
which foreign currency?
Dollars.
USD?
USD.
$22,000.
74 ಲಕ್ಷ ಟೋಟಲ್ ಆಗಿ.
Lords,
74 24?
20 lords, 3 accused. Accused number 1, 31 lakh, 26 lakh, my lords. Accused 2, 22 lakh, and accused 3, 31 lakhs. Totaling 79 lakh rupees. Now, my lords, all 3 of them are caught. Lords, I am remanded back, my lords, to the judicial custody on the same day. In a, lords, when you see section 135 1B, lords, if any amount is less than 1 crore, lords, it's a bailable offense. I am remanded back, my lords, to the
Well, how did
judicial
you
custody
put them into custody?
for 10 days. my lords.
ಏನಿದು?
Actually, I just have to check.
$20,000 ತಗೊಂಡೋದಕ್ಕೆ ಇದ?
ಅಲ್ಲ, our I will just check the on instructions. One aspect I need to ask is they're asking for relaxation of the condition.
What condition? ಎಲ್ಲಿಗೆ ಹೋಗ್ ದುಬೈಗೆ ಹೋಗ್ಬೇಕಾ ಈಗ?
I'm Dubai resident, my lords. I'm going Dubai.
And he's a
ಅದಕ್ಕೆ, my
resident
lords,
in Dubai.
I've also put, my lords, resident identity card of Dubai. My family lives there, my lords, in Dubai. My lords, the only 2 conditions I've challenged is one is cash surety of 50,000, my lords, and second is the my lords,
Not to travel
not
ಅಂತ
to
ಹೇಳಿ.
travel anta ಇದೆ. Without prior permission. My lords, exactly Telangana High Court, my lords, have dealt with this
Oh,
case.
no, they should be allowed on the face of it. This is not the way.
I'll take
Oh, no,
instructions.
sir. I'll take it tomorrow. No, day after tomorrow.
Yep.
Day after tomorrow in the fresh matters list, prima facie, unless I'm going to allow this. Yes.
I've not, my lords, challenged 10 days illegal arrest, my lord. I file bailable application, trial court treats it as
How did
non-bailable.
you even file an application for remand to judicial custody in this case?
I'll take
What is this, sir?
I'll take instructions.
$22,000 ತಗೊಂಡೋಗಿದ್ದಕ್ಕೆ in custody?
I'll take instructions.
When you're,
No, it is-
when the provision itself says 1 crore?
No, if it is, there's a 13 of 2022 circular.
You know,
50 lakhs.
what will prevail, sir?
No, but they are telling, I'm only taking 22 lakhs to come under the net of less than 50 lakhs. That is what they are trying to portray.
You have not collectively taken them. Individually, they were carrying this much money.
Together,
How
it's
do
a
you take?
conspiracy.
What?
It's a conspiracy.
ಅಲ್ಲ, ಕಾನ್ಸ್ಪಿರಸಿ ಇರ್ಬೋದು. 1 ಕೋಟಿ ಮೇಲಾಗಿದೆಯಾ?
ಇಲ್ಲ, 74 ಲಕ್ಷ ಇದೆ.
76 ಲಕ್ಷ ಇದೆ. ಮತ್ತೆ 135 1B ಪ್ರಕಾರ ಏನು?
ಅಲ್ಲ, ಅದರಲ್ಲಿ 1 ಕೋಟಿ ಅಂತ ಬರುತ್ತೆ.
ಮತ್ತೆ
I'll take instructions.
you should not do this.
No, that is for the purpose of prosecution. For the purpose of arrest, 104 will come. I'll just check it because other 50 lakhs ಇದೆ. I'll just.
Even then, I'm going to quash this. This is not correct.
No, I'll take instructions.
If I declare the arrest to be illegal, then you'll have to compensate them.
It is wrong if it is.
Not correct. Yes. Day after tomorrow, fresh matters.
Please.
Registered to print the name of Madhu S. Rao as appearing for the.
Madhu N. Rao.
Madhu N. Rao appearing for the respondent. Yes. Ravi Kumar. ಇಲ್ಲ ಅಂದ್ರೆ ರವಿ ಕುಮಾರ್ ಅವರೇನಾ?
Two matters for compromise.
Offense?
498 is
Yes,
one
yes.
matter. Other matter is.
ಅದರ್ ಮ್ಯಾಟರ್ ಯಾವುದು?
Connected matters, my lord. Case encounter case. my lord.
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? ಇಲ್ಲೇ ಇದೆಯಾ?
List number 4, serial number 2 matter.
Serial number 2.
ಅದೇ serial number 2 ಆಯ್ತು. ಇನ್ನೊಂದು?
ಇನ್ನೊಂದು 130 matter. Serial number 130.
First, so list ಅಲ್ಲಿ 130 ನಾ? Okay, fine. Yes, both closed. Next. Yes, next.
For the petitioner in this case, my lords, the offences are 318. We have cleared the loan for the respondent and all the original documents.
Yes, where is the
My lords, sir.
settlement?
My lords.
I'm appearing on behalf of.
So and so
respondent.
appears for the respondent, so. Yes, Parties are there?
Yes, my lord.
Yes, next.
My lord, and kindly mention that all the original documents have been handed
Alan
over.
Barkoli, the learned counsel for the petitioner stroke accused hands over all the original documents to the complainant, and the counsel for the complainant acknowledges the same. Yes.
My lord,
G. Arun.
please, it's a
Arun
POXO
ji.
matter.
Hmm.
It's a POXO matter.
Ah.
Though there was initially there was an agreement to because the boy was yet to attain the age of marriage. Now both the boy and girl are attain the age of marriage. The problem is that they both are not inclined to get married.
ಮತ್ತೇನ್ ಮಾಡೋದು ಹೇಳಿ?
They have because only for
ಅಲ್ಲ
only
ಪೋಕ್ಸೋ ಕೇಸ್ ಬೇಕಾದ್ರೆ ಡೈರೆಕ್ಟ್ ಕ್ಲೋಜರ್, ಬೇರೆ ಏನ್ ಮಾಡಕ್ಕ?
because if you're honest, kindly see the
ಅಲ್ಲ ಅದರ್ವೈಸ್ ಸೆಟಲ್ಮೆಂಟ್ ಕೆನಾಟ್ ಕಮ್ ಅಬೌಟ್.
because it's a statutory rape at the time when she goes to a medical examination.
ಏನಾದ್ರು
That is how the
ಇರ್ಲಿ.
case is discharged.
Whatever it is. On the merit, I can't entertain a POXO case. It's only.
No, because if you're honest, may kindly see for the sake of closure, then I may.
ಅಲ್ಲ, you may marry or whatever closure, ಮತ್ತೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
Allah, in fact,
We'll hear it on merits.
I may not succeed. That is the reason.
I'll direct the trial court to conclude the proceedings within 6 months.
No, man. Then I'll take a chance. Let it be taken.
ಆಯ್ತು.
For 2 weeks, a date.
The petitioner submits that there is no chance of settlement in the case at hand.
No, for reporting settlement only. Let it be there.
ಆ ಚಾನ್ಸ್ ತಗೊಂತೀರಾ? ಆಯ್ತು. List the matter on 25th at 4 p.m. to report settlement.
Please.
Next.
For the petitioner, my lordship.
Offense.
Offense is 498A, my lordship.
Yes.
They have settled the matter before the trial.
Mediation.
Mediation al settle agi compromise.
ಆಯ್ತು, ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್?
Page number 80, my lordship.
ಆಯ್ತು, ಕ್ಲೋಸ್. ಎಸ್ ಪಾರ್ಟೀಸ್.
Parties, you were present.
Yes. Next. ಮೇಡಮ್, ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್? ಎಲ್ಲಿದೆ ಕೊಡಿ ಅದು.
131.
ಪೇಜ್ 131.
ಅಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 80 ಅಲ್ಲಿ ಇದೆ.
80 ಅಲ್ಲಿ ಇಲ್ವಂತ?
80 and 81 is the compromise.
ನೀವೇ ನೋಡಿ ಮೇಡಮ್, ಕೊಡಿ, ಅದು ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹತ್ರ ಕೊಡಿ, ಅವ್ರ ಹತ್ರ ನಿಲ್ಸ್ಕೊಡಿ.
ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಇದೆ.
ಹೌದು, ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಕೋರ್ಟಲ್ಲಿ ಆಗಿರೋದು ಮೀಡಿಯೇಷನ್ ಎಲ್ಲ ಇಲ್ಲೇ ಇದೆ ಅಲ್ವಾ? ರೀಡ್ ಮಾಡಲೇಬೇಕು.
Just the husband is present, my lordship. Since 23, she has not been present before the court.
But she has signed there court ಅಲ್ಲಿ.
Sign ಮಾಡಿದ್ದಾರೆ ಸರ್. ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಅಂತಾನೆ ಬಂದಿದೆ ಸರ್.
No problem, madam. Compromise decree. Yes, next. Offense.
The POXO offense under the POXO. Now the complainant and the victim is present before this court. They are going to compound the offense. They are intent to marry each other.
ಎಷ್ಟು ವಯಸ್ಸು?
Now she is attained the age of 18.
Yes.
It's 18 years.
19
18 years.
17 years 2 months ಅಂತ ಇದ್ದಾರೆ. Nothing. List the matter on 25th. I'm not going to settle it. Yes.
Please not. Verify the Aadhaar card.
List the matter on 25th. The petition counsel for the petitioner to produce documents concerning the age of the victim. As the counsel of the petitioner submits that she is 18 years old and the learned additional SPP on the basis of the records would submit that she is 17 years 2 months even today. Yes.
Please.
498 my lord. I'm handed over the original DDs.
DD ಎಷ್ಟು?
12 lakhs my lord.
12 lakhs. The petitioner hands over demand draft of rupees 12 lakhs. The same is acknowledged by the complainant who is present before the court. Yes. ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
Mediation matters.
Yes. Yes. Next. 25th ಹಾಕಿಲ್ಲ ಅಂತ.
Marriage certificate ಕೊಡೋದಕ್ಕೆ ಹೇಳಿದ್ರು.
ಹಾ?
I'll produce the marriage certificate.
ಯಾವ್ದು?
List number 2, serial number 8, my lord. I'm producing the marriage certificate.
Offense ಏನು?
Child marriage act and post act, my lord. Marriage.
ಪೋಸ್ಕೋ ಅಲ್ಲ, ಪೋಕ್ಸೋ.
Poxo.
ಹಾ. ಮದುವೆ ಆಗಕ್ಕೆ
ಮದ್ವೆ ಆಗೋದಕ್ಕೆ I'm producing the
ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಾ?
marriage certificate. I'm producing the registered marriage certificate.
ಅಲ್ಲಿ ಕೊಡಿ. ಕ್ಲೋಸ್ ಇಟ್. ಮಗು ಇದೆ, ಅದು ಡಿಸ್ಪೋಸ್ ಕ್ವಾಸ್ಟ್ ಅಂತ ಮಾಡಿ ಕೊನೆಗೆ ಇನ್ ದಿ event the petitioner accused number 1 would leave the complaint victim and the child in the lurch, the proceedings under the POCSO that is now terminated will get automatically revived. Yes. ಕಸ್ಟಡಿಯಲ್ಲಿದ್ದಾರಾ? ಆಯ್ತು, ಅದು ಆರ್ಡರ್. ಅಲ್ಲ, ಅದು that goes merges in the order. I have quashed the proceedings. He's out, he's not in custody.
ಗಿರೀಶ್ ಅಂತ.
Yes. ಅಲ್ಲ, ಅದು ಫೈಲ್ಗೆ ಹಾಕಿ. ಎಸ್. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಎಲ್ಲಿ?
ಅವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ.
ಇಬ್ರಿಗೂ ನೀವೇನಾ?
ಇಲ್ಲ ಸರ್, ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹುಷಾರಿಲ್ಲ ಅಂತೆಲ್ಲ.
ಹಾ ಸರಿ. ಅಲ್ಲ, ಇಬ್ರಿಗೂ ನೀವೇ ಆದ್ರೆ ಮಧ್ಯದಲ್ಲಿ ನಿಂತ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ.
ಎಸ್.
Serial number 106.
1 minute. That yesterday's matter. ಆಯ್ತು, ನಾನು ರಿಸರ್ವ್ ಮಾಡಿ ಬರೀತೀನಿ.
Meanwhile, my lord, we have conveyed what was falling from the honorable court yesterday, my lords. The one thing is,
Mic use ಮಾಡಿ.
we have conveyed to the instructing council and the concerned parties, my lord, what was being expressed by the honorable court. We also bowed down what was the intention why the honorable court was had expressed. So, my lord, the intention that the child should not be left in the lurch, my lords. No, that first, my lords, one thing is that initial orders, your lordships fixed the amount of 75,000, my lords. The initial order, my lord, was deposited before the honorable high court, and one aspect, my lords, that what first installment was deposited before the honorable high court, my lords. As for the second installment, my lord, I do concede, my lord, there was some difficulty not paying it. Now the question is, my lords, without prejudice to other contentions, my lords, if my lord is pleased to permit me, I submit to the contentions, my lords. The final this thing is, my lords, without prejudice to other contentions, my lord, defense would be entirely different when you take the
Come
trial
to
court.
the point,
No,
sir.
my lords. This everything has to be, my lords, that the interest of both parties, my lords, as far as keeping in view of the child, everything has to be decided finally, my lord. About the amount that has to be paid, etc., has to be decided, my lords. May I suggest, my lords, the as far as those aspects are concerned, my lords, let the some mediator or the mediation center on those aspects, my lord, because we also now concede to that extent, my lords, that it has to be done, because it's my duty also to convey to the words expressed by the honorable court, my lord. Therefore, I humbly beg to submit, my lord, that the matter can be referred to some senior mediator or
that will, that I have no problem
on that point,
but
my lords.
pay the amount that is to be paid till today.
Yes. Now that one installment is what deposited.
ಒಂದಲ್ಲ one ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ?
ಇನ್ನೊಂದು installment ಮೇಲೆ.
ಇನ್ನೊಂದು ಕೊಡ್ಬೇಕೀಗ.
Your lords may kindly grant
ಅದು
us.
ಕೊಟ್ಬಿಡಿ. ಕೊಟ್ಟ ತಕ್ಷಣ I will refer it to mediation.
Please.
Then what happens in the mediation?
May I pray this, my lords? Now that the honorable court I am making this prayer, lord may grant 3 or 4 days for the other installment, subject to
No
that.
problem. No problem at all.
Subject
ಇಲ್ಲಿ
to that-
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ ಈಗ?
One was deposited.
That is 75,000 is
Yes, yes,
deposited
first month.
here.
Second month has to be deposited now.
ಆಯ್ತು. For that I will direct the complainant to withdraw it immediately.
So please,
Yes.
please.
Second installment, my lord, I'll let them pay it to us, my lord.
4 ದಿನ ಕೊಡ್ತೀನಿ ಟೈಮ್ ತಾಳಿ. After that only mediation will happen.
Please.
Yes. All right.
Without prejudice to other contents.
Absolutely without prejudice.
Because it should actually.
No, without prejudice.
Please, my lord.
I will observe that also.
Please, because my lord's observation should not.
No, that's all. Madam, the file ಕೊಡಿ.
We appreciate the senior counsel
Yes,
concerns in
that's
yesterday's
why
today, my lord.
ಅವ್ರಿಗೆ ಒಂದು 24 hours time ಕೊಟ್ರೆ ಮಾಡ್ತಾರೆ. No, sometimes he will be in the shoes of the victim. He knows the problem.
No, it's my duty also to assist the honorable court, my lord. When the honorable court expresses my duty, my
No,
lord, of
the
course.
only concern is, Hegde
Please,
sir,
I bow down.
consensual acts happen day in and day out,
Please.
no problem.
Please.
But out of the consensual acts, if innocent life is born, who will take care of
No,
the
no, the
child?
honorable court was trying.
Why should the innocent child that is not even,
No, I am
doesn't
the
even know
subject.
anything, suffer for the acts of a
I was
couple?
also having a reflection, reading the interim order of the honorable court and reflecting what the honorable court said. It's trying to balance both, my lords. And it's
Absolutely.
also my duty
I have
to.
granted an interim order of stay,
Please,
so
please.
no
No,
investigation.
I was
You
reading it
can't
again.
have the cake and eat it
I
too.
had an
You
introspection
have
and
not
I
paid.
thought-
Now, how is that possible?
I have advised them properly, my lord. So without further prejudice to any contentions, my lord.
No problem.
If there is a happy ending, we are also happy, my lord.
Huh?
If there is a happy
Ah,
ending,
yes.
it was began happily, my lord.
All right. ಇದು ಕೊಡಿ.
I'm sure if
File
senior
ಕೊಡಿ.
counsel makes further attempt, it will be an happy end.
My lord and friend will also cooperate in the state.
Is Ravi Shankar laughing with that?
No, we can't, my lords. Sri Jagadish can, in fact, mediate. Additional, SPP can mediate, my
Actually, we
lords,
proposed, my
on
lord,
this
to my
aspect.
senior counsel.
Yeah, I do consider. Do consider. No, accused is entitled to put all the defenses. Initially, my lord.
ಆಯ್ತು.
So your lords may not mistake what the defense we put forth, my lords.
Absolutely, sir. What am I saying? The petitioners were before this court calling in question proceedings in SC 35 of 2026. This court on 24/4/2026 had passed the following order. A direction was issued in the light of a child born from the acts of the accused number 1 and the complainant victim, and the child being left in the lurch, had directed the an amount of 75,000 to be paid to the mother and the child for the mother to take care of the infant. The allegation now by the complainant is that no amount is paid to the hands of the complainant victim, but 75,000 as directed is deposited before this court, which the complainant was not even aware. The second installment that had to be paid of 75,000 is yet to be paid. The learned senior counsel, now on instructions, would submit that if 4 days time is granted, the second installment of 75,000 would be paid, and have no objection for the withdrawal of the amount that is in deposit. He would further add that in the teeth of the circumstances that emerge in the subject petition, as also the status of the petitioners and the other of the petitioner and the complainant, if the parties are referred to mediation, some kind of settlement could be arrived at with regard to all the issues that are in the list. The said submission merits acceptance. The parties to the list shall appear before the mediator in the mediation, Karnataka Mediation Center.
Near mediator maybe.
ಹೇಳ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
Senior mediator.
ಹೇಳ್ತೀನಿ. ಯಾರು ಪ್ರಶಾಂತ್ ಚಂದ್ರ ಇದ್ದಾರೆ?
ಇದಾರೆ.
ಇದಾರಲ್ಲ, ಸೊ will ಅವರೇ ಚೂಸ್ ಮಾಡಲಿ.
As your, my lord.
Yes. A senior mediator be appointed for mediating the issue between the parties. The parties to appear before the mediation center on the 19th of June at 3 p.m. Subject to the condition that the petitioner would pay the second installment of 75,000 prior to the parties entering into mediation.
Them furnish the account details.
We have already given to you.
ಇದೆ ಮೇಲೇ ಇದೆ. The so and so in the next 4 days. The insofar as the deposit of 75,000 is that is before this court, the registry shall forthwith hand over the said amount to the complainant, complainant without broking any delay. Forthwith ಅಂದ್ರೂ ಇವ್ರು ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ, without broking any delay. Yes.
My lord, in this matter, let it be parted, my lord.
ಈಗಲೂ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲೇ ಇರೋದು ಸರ್.
Parted in the release ಆಗಿದೆ ಅಂತ ಇದೆ.
ಇಲ್ಲ
ಇಲ್ಲ
In the order sheet.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇದು 482 ಇದು ಕರೆಕ್ಟ್, ತೊಂದ್ರೆ ಇಲ್ಲ. List the matter on ಪರವಾಗಿಲ್ಲ, list the matter on 30th at 4 p.m. for further hearing.
Mediator, my lord, I think, your lordship.
Senior.
Sushila Sarthi.
ಆಗ್ಬೋದು. ಸುಶೀಲಾ madam.
ಅವ್ರು ಇದ್ದಾರಾ? ಮೇಡಮ್ ಸುಶೀಲಾ ಮೇಡಮ್ ಅಂತ. Yes.
Interim order.
Interim order subject to all the aforesaid shall continue. Yes.
I'm so grateful.
Some relief.
Only.
Yes.
Only. Only thing
Hegde
is, my
sir
lord,
has prevailed.
Yes,
Correct.
I also request the complaint to be reasonable, my friend to be reasonable and process goes on. Otherwise, both sides should
No,
be.
I mean,
Both, that's all. That I don't
ಮಗು
want to say
ಅಷ್ಟೇ
anything.
ಇನ್ನೇನಿಲ್ಲ.
And I also have sent him all this, my lords. It is also our duty to.
Even corporation is not ready to give the birth certificate in this matter.
No, all these
We have
things,
to take
all these things.
Everything will be settled. If it is not settled, we'll pass orders on merits. Why are-
Please. And only thing, let only the parties appear there. Otherwise, when third parties interfere before the mediator also. A humble request is. only the
Parties
concerned
ಇನ್ಯಾರ
parties.
ಥರ್ಡ್ ಪಾರ್ಟೀಸ್ ಯಾರು?
No, but I don't want to make any, because I don't want to aggravate, escalate the matter, anything, my lord, so that.
It is only, it is made clear that only the parties concerned to the list shall appear before the mediator and not all and sundry.
Please, most good.
1:30, sir. 4 o'clock.
Digital.
Digital. ಯಾವುದು? 1:30. ಈ ಕೇಸ್ ಅಲ್ವಾ?
ಅದಲ್ಲ, ನಿಮ್ದಾಯ್ತು ಬಿಡಿ.
I don't know what. I thought there was an end again. I thought it was only a comma. So grateful.
ರವಿಶಂಕರ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Before, when this case was called, Ravishankar stood up, my lord. We are grateful to that.
Yes.
We are filing our synopsis.
ಕೊಡಿ ಕೊಡಿ ನಿಮ್ದು ಕೊಡಿ.
Not for a paper, no, investigation paper.
ಇಲ್ಲ ಸೂರಜ್, ನಿಮ್ದು ಪ್ರೇಯರ್ ಏನು?
Passing of the 27-25.
What is your prayer?
Lords,
And what is that story you are twining to the prayer?
no, my lords, I've clarified from day one, my lords, that what they've initiated, basically this is the thing, my lords. I enter into.
No, now you tell me, I hear your story. Print this story in the judgment and render a judgment on that story when there is no pleading.
There is pleading for everything, my lords.
A prayer.
Allah, prayer is an, if my lord sees the prayers, page the 52 minutes. One is.
I think synopsis ಹಾಕಿದಿರಲ್ಲ?
ಹಾಕಿದೀನಿ. ಅಲ್ಲ.
We are also
ನೀವು
filing
ಹಾಕಿದ್ದೀರಾ?
synopsis.
We are also filing the synopsis, milords, indicating the details of every single transaction which was initiated by them. They are basically referring to annexure AG.
AG?
Annexure AG.
AG.
Milords, that's at page 236. If that entire letter is read to its face value, it will indicate, milords, we told them that we have sympathies for you. You say that everything has happened at third party's instance. You have been defrauded, everything. We accept that something might have happened to you, no difficulty. But don't hold us responsible for your voluntarily initiating the loan process, initiating the disbursement of the money. Please don't hold us responsible. Please give us our money. That is what they are referring to. That other than that, not a surprise. Paragraph numbers 55 and 56. He says that there is very unlikelihood of me being convicted in this case. Therefore, the matter requires to be quashed. That's essentially the substance of the.
Milords may take. Milords may.
No, ಅದಿದೆಯಲ್ಲ, ಚಾನ್ಸಸ್ ಆಫ್ ಕನ್ವಿಕ್ಷನ್ ಬ್ಲೀಕ್ ಆಗಿದ್ರೆ we should not permit ಅಂತ.
May I take my lords through some.
ಮತ್ತೇನು?
ಅಲ್ಲ, I've not had the chance to bat at all, my lords.
ಆರ್ಗ್ಯುಮೆಂಟೇ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ, grounds on merits have not.
ನಾನೇ ಡಿಜಿಟಲ್ ಅರೆಸ್ಟ್ ಆದಂಗಿದೆ ಈಗ. ಅಷ್ಟೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ. Yes.
ಅಲ್ಲ, my lords recollect, my lords, last date I just started for 2 minutes astral or.
It's 5:30. You give the synopsis. I'll take it on Friday perhaps. ನಾಳೆ 4 o'clock ಇದೆ with some reference at.
Yes, there is a reference.
That's why I rise at 4 o'clock.
ಅಲ್ಲ, because there are
statute, my lords, I am covered, my lord, because even under 25, my lord, similar to 130, there must be an underlying debt or liability. For there to be underlying debt or liability, my lords, I must have a contract with them where it's with free consent, my lord. Free consent can never be a situation where there is coercion, fraud.
You are, you take a submission.
So I have sought for.
Let me put him on guard, my lords. Coercion and fraud in entering into a contract makes it voidable where the fraud or coercion is played by one of the parties to the contract who gets the benefit.
Contract act.
ಅವ್ರು ಹೇಳ್ತಿರೋದು.
Contract act.
ಓ ದೇವ್ರೆ.
Contract
ಈಗ
ಓದೋಣ.
ಬೇರೆ ಕಾನೂನು ಬರೆದ್ಬಿಟ್ರೆ.
Contract act ಓದೋಣ.
ಯಾರು ದುಡ್ಡೇ ಕೊಡಂಗಿಲ್ಲ.
please see.
ಹೆಂಗೆ ಅಂದ್ರೆ ಯಾರೋ ಮೂರನೇ ವ್ಯಕ್ತಿ ಇರ್ತಾನೆ. ಅವ್ನು ನನ್ಗೆ ಹೆದರಿಸ್ಬಿಟ್ಟು ಬ್ಯಾಂಕ್ ಲೋನ್ ಕೊಡಿಸ್ಬಿಟ್ಟು ಅವ್ನು ಕೊಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾನೆ. ನನ್ನನ್ನು ಕೇಳ್ಬೇಡಿ ಬ್ಯಾಂಕ್ನವ್ರು ದುಡ್ಡು ಅಂತ. ಬ್ಯಾಂಕ್ ಲೋನಿಗೆ ಇದೇ ಬೆಸ್ಟ್ ಆನ್ಸರ್.
ಅಲ್ಲ ಇದು ಲೋನ್ ಕೊಡಿ ಅಂತಾನೆ ಕೇಳಿರುತ್ತಾನೆ ಅವ್ರಿಗೆ.
Just read the statute. This is not me saying, this is what the legislature said in 1872, 150 years back. 15 is coercion in the Inter Contract Act, my lords. Coercion is the committing or threatening to commit any act forbidden by the IPC or the unlawful detaining or threatening.
Where is this forbidden?
By the party to the contract.
It doesn't anywhere say party to the contract. As juxtaposed to a section 17. Section 17 ಅಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತೆ? Fraud means
ಆಯ್ತಾಯ್ತು ಎಲ್ಲ
committed by
ಏನೇನ್ ಹೇಳುತ್ತೆ ನಾಡಿದ್ದು ಹೇಳಿ.
party to a contract. 17 requires specifically one party to the contract to play fraud.
Now tomorrow it may not be possible.
Whenever it is comfortable for
Day after tomorrow, because tomorrow 4 o'clock andre I won't be able to complete it.
ಆಯ್ತಾ ಒಂದು ಕಾನೂನು ಅವ್ರು ಮಾಡ್ಸೋದು ಚೆನ್ನಾಗಿರತ್ತೆ ನಮ್ಗೂ ಅಂತ. ಒಳ್ಳೆ ಡಿಫೆನ್ಸ್. ಈಗ ಬ್ಯಾಂಕ್ ಲೋನ್ಸ್ ಇವರೆಲ್ಲ ಬಂದಾಗ ಡಿಫೆನ್ಸ್ ಇರೋದಿಲ್ಲ ನಮ್ಗೆ. ಇದೊಂದು ಒಳ್ಳೆ ಡಿಫೆನ್ಸ್.
If it was a simple civil suit, yes, my lords. Now this is a quasi criminal proceeding.
Which is quasi criminal? This criminal, sir.
Payment and settlement.
Oh, payments and is akin to 138.
138, it's quasi criminal.
It is quasi criminal, yes.
Which is why I'm in 528 before, my lords.
All right. Yes, the orders ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. ಮಿಕ್ಕಿದೆಲ್ಲ ರಿಪೀಟ್ ಮಾಡೋಣ.
Central government also handed over sealed cover, my lords.
That I have.
Inquiry report is placed before.
What my request is, my lords, that what Supreme Court and even the division bench of our honorable court would say is sealed cover procedure is to be looked down upon, my lords.
ಅಂದ್ರೆ ಇದೆಲ್ಲ ನಿಮಗೆ ಕೊಡಬೇಕು ಅಂತನಾ?
They cannot. Nothing can be heard behind my back.
Probably to the other accused people.
I don't know if it's to my benefit. I'm entitled to take with the benefit.
We'll see whether if it is beneficial to you, I'll myself give it to.
If it is adverse, my lords, I don't want it to influence my lords. Without me having a voice, without
Don't
having
worry.
a chance to rebut it.
Still at the stage of investigation, no jurisdiction to be heard. Supreme Court
investigation
wrote
by the-
sealed cover procedure in a departmental proceedings. Yes.
In our matter itself, in the stampede matter itself, my lords, there is a detailed judgment.
All right. Yes.
I produced that.
Oh, stampede matter.
Nam synopsis jate na hakidini.
ಆಯ್ತಾಯ್ತು ಸರಿ. ಸ್ಟಾಂಪಿಡ್ ಮ್ಯಾಟರ್ ಇತ್ತಲ್ಲ ಏನಾಯ್ತದು?
ಅದು ಬರ್ಲಿಲ್ಲ.
ಅದು ಯಾವತ್ತು ಹೋಯ್ತಲ್ಲ? We'll
Fifth
post that. We'll post. Yes. 12th, we'll try to post it on the.
42, your lordship has passed over asking me about
ಯಾವುದು?
42, my lord. I think release of the defreezing the bank account.
ಹಾ ಏನಾಯ್ತು ಅದೇ?
That we have no objection, my lord. He is asking. Trial court said that deposit that money in CJM Bangalore City.
Will direct defreezement. ನಾಳೆ ಮಾಡ್ತೀನಿ ಟೈಮ್ ಆದ.
To my account, my lord, just see the prayer number C.
ನಾಳೆ ಮಾಡ್ತೀನಿ.
Please.
Yes, ನಾಳೆ. Well,
Interim order may be explained.
that will ಇಲ್ಲಾಂದ್ರೆ 12th ಬೆಳಗ್ಗೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹಾಕ್ಬಿಡಿ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ.
Please.
Yes. ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್ ಅಷ್ಟೇ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗಳೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ. 60 1 minute 60 to 65 24th
ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್
ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಎಲ್ಲೆಲ್ಲಿದೆ. ಎಸ್ ಆಮೇಲೆ ಆರ್ಡರ್ಸ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಚೇಂಬರ್. ಎಸ್ ಮೆಮೊ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್. ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಮೆಮೊ. ಹೂ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಮೆಮೊ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್? ರೆಸ್ಪಾಂಡ್ ಪ್ರಜಿತ್.
Counsel is not here, my lord.
ಅದೇ ಪ್ರಜಿತ್ ಅಂತ ಯಾರೋ ಇದ್ದಾರೆ ಇಲ್ಲಿ.
ಅದೇ ಅವರೇ ಹಾಕಿರೋದು. He has filed retirement in both the matters.
True, but nobody else has entered appearance.
Nobody else has entered.
Anyway, list on 24th.
Interim order to be extended.
Interim order.
Please, my lords.
In terms of, okay, same. Post immediately after service of notice upon the respondent.
Weeks time, 73.
A week's time is granted to do the, 13, 13. ಯಾರಿದು ಚೇತನ್
Stay anila sir.
ಆಗಿಲ್ವಾ?
Stay ಆಗಿಲ್ಲ.
ಆಯ್ತು, a week's time is granted to do the needful. Next.
I'm for petitioner. Lords,
Post immediately after service of interim order ಇದೆಯಾ?
there is no interim order.
There's no interim order? There is no interim order. Yes. Post immediately after service of notice upon the respondent. Yes,
The
next.
government advocate had taken instruction.
75 yaru. Post immediately after service of notice upon the respondent. Same order. Interim orders ಎಲ್ಲೆಲ್ಲಿದೆ continue ಮಾಡಿ. 76, 77, same order. Same.
Lords, 80 am for the petitioner, my lords. One urgency, my lords. Lords, your lordship had granted interim order, my lords, but that is coming in the way of compassionate appointment to the.
Interim order is coming in. They will vacate it.
Please, no, my lords. The issue is that, my lords, it's a counter case. The two other cases have been quashed by this honorable court. Last time, my lords, your lordship had opined that this would be quashed. Lords, but.
I will see. But ಯಾರು complainant ಯಾರು?
Lords, complainant is the husband.
ಮತ್ತೆ ಕೇಳ್ಬೇಕಲ್ಲ complainant.
Lords, husband is deceased. Now they are.
No, they're not there.
306 is there. That is also quashed.
ಆಯ್ತು, list the matter on compassionate appointment ಅಂತ ಡೇಟ್ ಕೊಡ್ತಾರೆ. List the matter on 24th in fresh matters list. Yes, next. Post immediately after service notice.
81.
Same.
81, I'm petitioner.
Interim order idre continue ಆಗುತ್ತೆ. Yes.
83, I'm for the petitioner. My lords
80.
was pleased to order to secure CCTV footage, my lords. Previous date.
ಬರುತ್ತಾಳಿ. Yes. What is this for? PFA ಕಟ್ಟಿಲ್ಲ ಸರ್ ಕಂಪ್ಲೇಂಟ್ ಗೆ.
Notice order ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ನೋಡಿ ಮೇಡಮ್, ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. ಸ್ಟೇ ಆಗಿದೆ, ನೋಟಿಸ್ ಬೇಕಾಗಿಲ್ಲ. ಬಟ್ ಎನಿವೇ, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ದಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Date.
Emergent notice. Yes, post immediately service notice. Same. Interim orders will continue. Yes. Same. Continue. Yes. ಬರ್ಕೊಡಿ. Yes. Interim order continue ಮಾಡಿ. ಇದ್ರೆ continue. Yes.
My lord. 94, my lord.
94 interim order ಇದೆಯಾ?
ಇಲ್ಲ my lord. ಅಲ್ಲಿ respondent number 2 ಇದೆ. Respondent number 2, my lord.
ಸರಿ. Yes. Post immediately. ನಿಮ್ಮ respondent number 2 ಗ?
2 ಇದೆ.
Register to print the name of so and so. ಯಾರು?
ಗಜೇಂದ್ರ ಸಿ.
ಬರ್ಕೊಡಿ. Yes. As appearing for the second respondent. Next.
2 weeks time, my lord.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. Post immediately. Yes.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಓವರ್ ಆಗಬೇಕು. ಮತ್ತೆ ನೋಟಿಸ್ R2 ಡಿಸ್ಪೆನ್ಸ್ ಕವರ್ಡ್ ಬೈ ಕೋಆಕ್ಟಿವ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಕವರ್ಡ್ ಬೈ ಅಲ್ಲ, ಕವರ್ಡ್ ಬೈ ಆದ್ರೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾಗಿಲ್ವಾ?
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆ R2 ನೇ ರೆಫರೆಂಟ್ ಬೈ R1 ಅವ್ರ ಪೊಲೀಸ್ ಆಫೀಸಿಯಲ್.
ಪೊಲೀಸ್ ಅದೇ learned HCGP accepts. ಎಲ್ಲಿ HCG ಹೋದ್ರ? ಇಲ್ಲೇ ಇದ್ರಲ್ಲ. Learned HCGP accepts notice for the second respondent as well. Office objections overruled. Yes. Post the matter. Enter matter ಇದೆಯಾ? Post the matter on 15th in the fresh matters list. Yes, next. 2 weeks time to do the needful. Yes. Sheetal Soni.
My lordship, I am for the petitioner municipal comply office objection. 1 week time.
Week's time is granted to comply with the office objections. Maintainability.
Have it tomorrow. My senior counsel has been engaged.
Maintainability ga?
In the matter, my lord.
Matter Monday fresh matters. Next.
Tomorrow,
For the petitioners, my lords. Respondent number 2, my lords,
100
is the
post
excise.
immediately after service of notice.
My lords, respondent number 2 is the excise inspector. Your lordship.
Learned HCGP is directed to accept notice.
Please to quash the proceedings for them.
HCGP is directed to accept notice for the respondents. List the matter on Monday in fresh matters list.
Great.
Covered other close my note. Yes.
102 on the interim order is there in all.
Post immediately after service interim order. Yes. Admission ಕರಿಬೇಡಿ ಮೇಡಮ್. ಎಲ್ಲ all will post on
105.
ಎಲ್ಲೆಲ್ಲಿ interim order ಇದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. 104. ಏನಿದೆ 104?
My lord, 104. There are 7 cases, my lords. My lords directed to deposit 20 lakhs from all the 7 cases. Now what happened, my lord? On 13/11, I have deposited 5 lakhs. But in all the order sheet, it is reflected as 5 lakhs, my lord. So the magistrate is interpreting it as 5 lakhs in each case and issued the warrant.
ಈ ವಾರೆಂಟ್ ಸ್ಟೇ ಮಾಡಿದೀವಾ?
Warrant is stayed, but after 13/11/24 order, again warrant is issued.
ಆಯ್ತು, ಲಿಸ್ಟ್ ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕಿ ಮೇಡಮ್ ಫ್ರೈಡೆ.
Great.
Lord, in list 1025, Lord, which was heard today. Can I file my 2-page synopsis tomorrow morning?
You should.
Yes, I'll file my synopsis with judgment.
Homestead.
Homestead.
Please file.
For the illegality of arrest and.
Whatever, please file and serve a copy and Jagdish
serve
and
them.
file.
Tomorrow. I'm ready.
Your Lordship, serial number 122, my lord, there is no stay.
ಯಾವುದು ಬೇರೆ ಡೇಟ್ ಕೇಳಬೇಡಿ. 20 ಯಾವತ್ತರ ಪರವಾಗಿಲ್ಲ. ಎಸ್
122, there is
20?
no stay.
ಒಂದ್ ನಿಮಿಷ. ಆಮೇಲೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಯಾವ್ದು?
122.
ಒಂದ್ ನಿಮಿಷ. ಫಸ್ಟ್ ಟೈಮ್ ವಿತೌಟ್ ನೋಟಿಸ್ ಆಗ್ದೇನೆ ಇರೋದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಯಾವ್ದು ಇದ್ರಲ್ಲಿ? ಮೇಡಮ್ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಯಾವ್ದಾರು ನೋಟಿಸ್ ಆಗಿಲ್ದೇ ಇರೋದು ಇಲ್ಲಿ ಬಂದಿದ್ರೆ ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಪೋಸ್ಟೆಡ್ ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಆನ್ ಮಂಡೇ.
My lord,
ತೊಂದ್ರೆ ಇಲ್ಲ.
my lord, one submission.
106 is settled.
116 ಏನು? ಚಂದನ್, ಗಿರೀಶ್, ವಾಟ್ ಇಸ್ ದಿಸ್?
My lord, EC Act, my lord. 116 is EC Act, my lord.
ಎಲ್ಲ ಕವರ್ಡಾ?
Yes, my lord, ಎಲ್ಲ covered.
116 ಲಿಸ್ಟ್ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕ್ಬಿಡಿ.
Please, my lord.
106 is settled.
100 ಸ್ಟೂಡೆಂಟ್ ಏನು ಅಂದ್ರಲ್ಲ ಆಗಿದೆಯಾ? ಸಾರಿ. ಎಸ್, ವಾಟ್ ಇಸ್ ದಟ್ ಮೇಡಮ್? 105 ಎರಡಿದೆ.
ಎರಡು ಕನೆಕ್ಟ್ ಇದೆ.
ಎಸ್, ವಾಟ್ ಬೇಡವಾ ಈಗ? ಹೇಳಿ. ಎಸ್.
My lord, respondent, I mean, complainant is a advocate, my lord, who is a counsel of petitioner, my lord.
Why has he complained?
My lord, he filed a 138 complaint, my lord. He has taken a check stating that for a security purpose of MOU anteli. MOU is only replaced, my lord. Our pages ne replace ಮಾಡಿದ್ದಾರೆ. In the original MOU, it is stated that
ಈಗ ಸ್ಟೇ ಇದೆಯಾ?
stay ಇದೆ, but ಅವ್ರಿಗೆ ವರ್ಕಿಂಗ್ ವೀಸಾ ಆಗ್ತಿಲ್ಲ.
ದೆನ್ ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು? ಕೌನ್ಸಿಲ್ ಇದಾರಾ?
ಇದಾರೆ.
MR ಬಾಲಕೃಷ್ಣ
ಬಾಲಕೃಷ್ಣ,
ಅವ್ರು ಇರ್ಬೇಕು.
yes.
ಇಲ್ಲದೆ ರೀಕಾಲಿಂಗ್ ರಿವ್ಯೂ ಎಲ್ಲ
ಹೌದು,
ಬರುತ್ತೆ.
ನಾಳೆ my lord.
ನಾಳೆ ಬೇಡ, ಫ್ರೈಡೆ ಹಾಕೋಣ.
Friday, fresh matter list.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
106, my lord. My lord, the next matter, 106.
ಅದು ಸ್ಟೂಡೆಂಟ್ ಅಂತ.
122, my lord.
106 is settled, my lord.
ಕಾಲ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್, ಎಲ್ಲ ಗಲಾಟೆ ಮಾಡ್ತೀರಪ್ಪ ನೀವು. 24th.
My lord, 106, my lord. The matter is already settled before the trial court, my lord.
My lord, I appeal for the petitioner in this case.
ರಜತ್, ಏನಿದು?
It's a case and a counter case. My
ಸೆಟ್ಲ್
complaint is
ಆಗಿದೆಯಾ?
settled. It's settled in the
ಎಲ್ಲಿ
trial
ಟ್ರಯಲ್
court,
ಕೋರ್ಟ್
my
ಅಲ್ಲ?
lord. Trial court only. This is a copy of the joint memorandum between the parties.
ತಗೊಳ್ಳಿ.
Respondent
madam.
is served, my lord. She is unrepresented.
ನೋ ಪ್ರಾಬ್ಲಮ್, ಕ್ಲೋಸ್ ಇಟ್.
Please. Obliged.
ನೆಕ್ಸ್ಟ್.
My lordship, cause list.
24th, yes. 24th. Same.
110 covered by my lord, student, my lord.
ಏ ಅವರು ಸ್ಟೂಡೆಂಟ್ ಅಂದ್ರೆ ನೀವು ಸ್ಟೂಡೆಂಟ್ ಅಂದ್ರೆ
Accused number 2.
NDPS
NDPS.
ಮತ್ತೆ
ಇದು suicide, abetment to suicide. Accused number 1 is also student. ಅವರು ವಾಶ್ ಆಗಿದೆ.
ಯಾವುದು? 110 ನಾ?
110.
Respondent number 2 the
ಕವರ್ಡಾ?
not covered.
Student ಆ?
Student ಇದ್ದಾರೆ. They stand on different footing. Kindly fix a date.
ಯಾಕೆ ಫುಟಿಂಗ್ ಡೇ ಬೇರೆ?
There are two accused persons. One is the proceedings is quashed against accused number 1.
ಆಯ್ತು.
ಅದರ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ಸೆಲ್ಫ್ ಆಕ್ಟಿವ್ ನೋಟಿಸ್ is out.
ನೋಡಿ ಅದ್ರಲ್ಲಿ ಹಾಕಿದಿರ ಸೆಲ್ಫಿ? ಆಯ್ತು, ಸರಿ ತಗೊಳ್ಳಿ. ಲೆಟ್ ಇಟ್ ಕಮ್ 24th, yes. 24th, yes. Next.
My lordship, respond ಲೋಕಾಯುಕ್ತ ಮ್ಯಾಟರ್ ಮೇಲೆ ರೆಸ್ಪಾಂಡ್ ಟು ನೋಟಿಸ್ ಆಗಿಲ್ಲ my lordship, ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
Emergent notice to the second respondent.
In mean time my lordship.
And emergent notice to second respondent returnable 7 or 13 ಆ? 7 ಏನ 13 ಆ?
7 and 13 1D my lordship.
7th July, yes.
My lordship, framing of charge on 27/6 my lordship.
Adjournment ಕೇಳಿ ಅಲ್ಲಿ. Yes.
My lordship.
112. Arbati sir, let not the charges be framed.
4 years ago ಇವಾಗ ಬರ್ತಾ ಇದೆ.
ಇಲ್ಲ my lordship, charge frame ಆಗಿಲ್ಲ my lordship.
ತೊಂದ್ರೆ ಇಲ್ಲ. Yes, next. 7th, yes.
It's only on the basis of the confession.
No problem. 24th, next.
In the fresh matters, my lordship,
24th. ಯಾವುದು? ಲೋಕಾಯುಕ್ತ ಇದು. Yes, 7th, yes.
Petitioner, permission take.
24th.
Please.
24th.
For the
Same.
petitioner, my lords, one submission. This matter may be
7th.
connected with the criminal petition number 140/20.
7th, madam. Yes.
My lords, I appear for petitioner. There is no interim order in this.
No interim order. No interim order. Yes.
My lords, please, will try to convince your lordship.
First
Any
time.
shorter date.
Monday, fresh matters. First time ಬರ್ತಾ ಇರೋದು. Yes. ಇದು first time, 24th.
My lord, I am appearing with the respondent in this case, my lord, from day before yesterday. The matter is posted today, my lord. This is a case wherein they are supposed to pay 2 crores and add the arrears of rent by collecting from the debtors.
ಆಯ್ತಾಯ್ತು. ಸ್ಟೇ ಇದೆಯಾ?
ಅವ್ರಿಗೆ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ.
List the matter. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ವಿಕೆಟಿಂಗ್ ಸ್ಟೇಗೆ ಹಾಕಿದ ತಕ್ಷಣ I'll take it. Yes. List otherwise 24th. ಇಲ್ಲ ಅಂದ್ರೆ ವಿಕೆಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ. Yes. 7 13 7 second. Yes.
For the petitioner, my lords, interim orders.
ಇದೆಯಾ? 24th IO. ಇದು 24th ಬೇಡ. 2 weeks IO. Next.
Date may be fixed.
No. Yes. Next. ಇದು dogs.
Respondent number 2.
Yes, sir.
My lordship,
ಎಲ್ಲ dogs.
By forging my signature, they are taking contention.
Even otherwise, I will not permit dogs to be with you. You have
At least
disciplined the dogs and but you have beaten the dogs.
At least 3 Shih Tzu dogs, small dogs.
Shih Tzu, you have beaten that also.
My lordship, what happened? I filed an NCR against my neighbor.
That's okay. We'll hear it. List the matter on Wednesday, next 18th in the fresh matters list.
Obliged.
Next 125. First time Monday fresh matters list. Yes.
My lords, this matter may be taken up tomorrow, my lords. It
Why?
is posted in trial court for year before charge tomorrow. It is an ID Act, my lord. Your lordship has
What
directed.
act?
IT Act.
IT Act. All right. But Friday. fresh
My lords, tomorrow, my lords. It is posted.
ನಾಳೆಗೂ ಬರಲ್ಲ ಮೇಡಮ್, ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ. ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಬೇಕಾದ್ರೆ ಟೇಕ್ ಇಟ್. ಬಟ್ ಇಟ್ಸ್
2:30 I'll move tomorrow.
Move, we'll see.
Grateful, my lords. For the petition, your lordship. Interim order may be extended. Any date may be fixed, your lordship.
2 weeks IO. Next. One 135. Oh, these matters. 20, madam, 25th ಹಾಕಿರಿ. Interim order continue ಮಾಡಿ.
For the petitioner, my lords, 13 one be
Post, release the matter from the status of being part heard. Post the matter on 2nd July. Yes. 7th July.
to be
Yes.
extended, my
Next.
lords.
May I make a mention, my lords? In list to serial number 24, my lords. Matter was adjourned to 17th. I believe the respondents council mentioned it. This, I have an inconvenience on 18th, my lords. May I request for 24th?
ಆಯ್ತು 24.
Grateful.
ಸೈನು ಆಗೋಯ್ತಾ? ಆಯ್ತು ನೋಡಿ. ಅವತ್ತು ಲಿಸ್ಟ್ ಆದಾಗ ಬನ್ನಿ. ಅವತ್ತು ಹೇಳಿ.
Okay.
We'll grant you time, don't worry. Yes. Chowda sir. Monday ತಗೊಳ್ಳೋಣ. ಇವತ್ತು ಲೇಟ್ ಆಗುತ್ತೆ. I'm also exhausted. Monday we'll take it. ಯಾಕೆ? ಮಂಡೇ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. ಮಂಡೇ 4 ಗಂಟೆಗೆ ಬನ್ನಿ. 4 o'clock Monday, because I'll finish off the list. Please help me. 4 o'clock Monday.
Serial number 16, my lord, passover matter.
Passover ಯಾವ್ದು ಮೇಡಮ್?
436A, my lord, seeking statutory.
Oh, 436A.
ED. On behalf of respondent, your honor, may kindly have it tomorrow.
Friday ತಗೊಳ್ಳೋಣ. Friday fresh matters. Bye.